I call the Senate to order. Mr. Clerk, please call the roll.
Senator Barnett, Senator Barrett, Senator Berry, Senator Blackman, Senator Blackwell, Senator Blunt, Senator Boyd,
How are you doing?
Senator Brumfield, Senator Bryan, Senator Butler, Senator Carter, Senator Chazanall, Senator Chisholm, Senator DeBar, Senator Delano, Senator Dupree, Senator England, Senator Fillingane, Senator Frazier, Senator Gillespie Isom, Senator Harkins, Senator Hartness, Senator Hickman, Senator Hill, Senator Hobson, Senator Jackson, Senator Johnson, Senator Kirby, Senator Latner, Senator McCon, Senator McClendon, Senator McMahon, Senator Michelle, Senator Mumford, Senator Norwood, Senator Parks, Senator Pope, Senator Rhodes, Senator Seymour, Senator Simmons of the 12th, Senator Simmons of the 13th, Senator Sparks, Senator Suber, Senator Tate, Senator Taylor, Senator Thomas, Senator Thompson, Senator Turner Ford, Senator Whaley, Senator Wiggins, Senator Williams, Senator Younger. Mr. President, a quorum is present.
We could use your prayer. Thank you. Will senators and guests in the gallery please rise for the invocation to be given by Dr. Brent Parker. Dr. Parker is the lead pastor at the First Baptist Church of Van Cleve, Mississippi. The invocation will be followed by the Pledge of Allegiance by Senator England. Dr. Parker.
Thank you for this privilege. Let's pray. Our Father in heaven, your name be honored as holy. And we know that that reverence comes as we represent you well and accurately, both in what we profess with our mouth and how we live with our life. And as I've heard from many testimonies, today will be a very challenging day. There's a lot of tense moments will no doubt come about throughout this day. Perhaps even things said that shouldn't be said, that aren't meant, hurtful words, maybe even hateful words. I pray that your Spirit would descend on this place and that you would guide and guard every statement made, every implication, and that what is ultimately accomplished will be for your glory and the greater good of the people of Mississippi. Because that's why we're here. We're here to serve you and represent them. So I pray we'll do that well and that you'll give us wisdom in how to do that appropriately in a way that when we leave here, we can leave here as friends and those who have come together for that purpose to glorify you and represent our constituents. We love you, Lord. Thank you for the love you had for us. In Jesus' name, amen.
Amen. Please join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thanks for your privilege.
Go on, man.
A little bit of thanks.
Rick keeps up with everything. Like watching the show. Look, it's a good day for the show. It is today.
Well, I hope they're powerful enough to have some.
Yeah.
Thank you, Governor.
Thank you, Dr. Parker. Thank you, Senator England. Now the reading of the journal. Senator Blackwell.
Thank you, Mr. President. I move we dispense with the reading of the journal.
Senator moves to dispense with the reading of the journal. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Message and petitions, Mr. Clerk.
Mr. President, there are none.
Committee reports. Senator Blackwell, you're recognized.
Thank you, Mr. President. I move we dispense with the reading of the committee reports.
Senator moves to dispense with the reading of the committee reports. All in favor signify by saying aye. All
Aye.
opposed, no. The ayes have it. Next to the reading of the titles and bills and resolutions, Senator Blackwell, you're recognized.
Thank you, Mr. President. I move we dispense with the reading of the titles of bills and resolutions.
Senator moves to dispense with the reading of the titles and bills and resolutions. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Next, Senator Chasnow, you recognize. Arnold, you got to cut the mic on.
Yes, I'm sorry.
It's okay, yes, sir.
She's going to do her deal. Yeah, she's now looking up her words. Let's go.
Am I live?
Yes,
Think
ma'am.
so. Thank you, Mr. President. Well, the senators, excuse me. Here we are. I would like to request 4 privileges for the presentation of the Governor's Awards in Arts and the Excellence in the Arts. We have 5. I'm going to bring them individually so that they can receive their recognition. We have some other senators who have requested to be with me at the podium. So for our first honoree, I need Senator McConn, Senator England, Senator McClendon, Senator Michelle, Senator Simmons, and Senator Thomas to please join me. And if there are others that would like to be here, that would be very nice as well. I would like floor privileges at this time for Mr. Greg Harkins.
Sergeant at Arms, please show Mr. Harkins.
We're honoring him today for his fabulous long career and creativity. Mr. President, will you please have the title read?
Senator?
Will you please have the title read, Mr.
Mr.
President?
Clerk, please read the title.
Senate Resolution Number 13, a resolution extending the recognition of the Mississippi Senate to Mississippi Master Chairmaker Greg Harkins of Thomastown, Mississippi, as a recipient of the 2026 Governor's Arts Awards for Excellence in Traditional Craft. Now, therefore, be it resolved by the Senate of the State of Mississippi that we do hereby extend the recognition of the Mississippi Senate to Mississippi Master Chairmaker Greg Harkins of Thomastown, Mississippi, as the recipient of the 2026 Governor's Arts Awards for Excellence in Traditional Crafts, and extend our congratulations to this outstanding craftsman and civic leader on this auspicious occasion. Be it further resolved that this resolution be presented to Greg Harkins and made available to the Capitol Press Corps.
Thank you, Mr. Harkins. Those of you that are going to be here for further, can stay up here with me, okay? If somebody. Mr. President, I would now like to recognize a fabulous musician, Mr. Jesse Robinson. Thank you. And also joining me at the well for this presentation, I would like Senators McConn, Senator Blunt, Senator England, Senator McClendon, Senator Simmons of the 12th, and Senator Thomas, and any other of our senators who would like to be here as we recognize Mr. Robinson. Mr. President, will you please have the title read?
Mr. Clerk, please read the title.
Senate Resolution Number 14, a resolution extending the recognition of the Mississippi Senate to Master Mississippi Blues guitarist and vocalist Jesse Robinson of Jackson, Mississippi, as the recipient of the 2026 Governor's Arts Award for Lifetime Achievement. Now, therefore, Be it resolved by the Senate of the State of Mississippi that we do hereby extend the recognition of the Mississippi Senate to Master Mississippi blues guitarist and vocalist Jesse Robinson of Jackson, Mississippi, as a recipient of the 2026 Governor's Arts Award for Lifetime Achievement, and extend our congratulations to this outstanding musician on this auspicious occasion. Be it further resolved that this resolution be presented to Jesse Robinson and made available to the Capitol Press Corps.
Mr. President, I would like to request floor privileges for Heather Christian, please.
Seeing no objection, granted. Mr. Clerk, Sergeant at Arms.
And while she's coming in, I would also like Senator McConn, England, McClendon, and Simmons to join me, and any other persons in the chamber that would, any other senators that would like to be here for this.
Mr. Clerk, please read the title.
Thank you.
Senate Resolution Number 15, a resolution extending the recognition of the Mississippi Senate to award-winning Mississippi composer, playwright, performer Heather Christian from Natchez, Mississippi, as a recipient of the 2026 Governor's Arts Award for excellence in music composition. Now, therefore, be it resolved by the Senate of the State of Mississippi that we do hereby extend the recognition of the Mississippi Senate to award-winning Mississippi composer, playwright, performer Heather Christian from Natchez, Mississippi, as a recipient of the 2026 Governor's Arts Award for excellence in music composition.
Congratulations. Senator Chesno.
Thank you, Mr. President. I would like to ask a representative of the Mississippi Symphony Orchestra to join me. I'm sure they're not all here.
Sergeant at Arms, will you please escort them to the Senate
And
floor?
let's see. Also, I want to be sure that Senators McConn, Blunt, Dupree, England, McClendon, and Simmons of the 12th are present with us. They signed on to the resolution, and any other members of this body that wish to be here to recognize this honor today. Mr. President, may we please have the title read?
Mr. Clerk, please read the title.
Senate Resolution Number 16, a resolution extending the recognition of the Mississippi Senate to Mississippi's largest professional performing arts organization, the Mississippi Symphony Orchestra from Jackson, Mississippi, as the recipient of the 2026 Governor's Arts Award for excellence in performing arts. Now, therefore, be it resolved by the Senate of the State of Mississippi that we do hereby extend the recognition of the Mississippi Senate to Mississippi's largest professional performing arts organization, the Mississippi Symphony Orchestra from Jackson, Mississippi, as the recipient of the 2026 Governor's Arts Award for excellence in performing arts, and extend our congratulations to this outstanding arts and civic organization on this auspicious occasion. Be it further resolved that this resolution be presented to the Mississippi Symphony Orchestra Director, Crafton Beck, and made available to the Capitol Press Corps.
Congratulations.
All right, Mr. President, let's see. The next person I would like to request floor privileges for Ms. Dottie Armstrong,
Mr. Clerk, please show Dottie Armstrong to the floor.
and senators who signed on with me, McConn, Dupree, England, McClendon, Simmons, anyone else that would like to be here for this moment, please, sir. And Mr. President, would you please have the title read?
Mr. Clerk, please read the title.
Senate Resolution Number 17, a resolution extending the recognition of the Mississippi Senate to art education mentor and advocate Dorothy Dottie Armstrong from Newton, Mississippi, as the recipient of the 2026 Governor's Arts Award for Excellence in Art Education. Now, therefore, be it resolved by the Senate of the State of Mississippi that we do hereby extend the recognition of the Mississippi Senate to art education mentor and advocate Dorothy Dottie Armstrong from Newton, Mississippi, as the recipient of the 2026 Governor's Arts Award for Excellence in Art Education and civic organization on this auspicious occasion. Be it further resolved that this resolution be presented to the Capitol Press Corps.
Congratulations, ma'am.
Mr. President, for just a very, very brief moment, I'd like for Mr. David Lewis, the Executive Director of the Arts Commission, to be permitted to say just a word or two to the Senate. And, of course, he'll tell you more about tonight's ceremony, if we could have him allowed to be on the
Mr.
floor.
Lewis, you're recognized for a very, very brief speech. We appreciate your hard work on this.
Mr. Lewis.
Thank you, Senator Chasnow. Thank you to all the senators that co-signed on these resolutions. Thank you all for being a part of celebrating our rich legacy of artistic and cultural excellence. See some friends out there. We are going to have the Governor's Awards tonight at 6 p.m. at the Westin. If you would love to join us, we'd love to have you. We will see you tonight. Have a great day. Thank you all so much.
And very briefly, I would like to say, you can look up on Google a letter that Thomas Jefferson, whose works we're celebrating this year is the 250th anniversary of our Declaration of Independence, in a letter that he wrote to James Madison in 1785, extolling the virtue of the arts and how important it was for Americans to perform and to produce the arts and to appreciate the arts because it improved our stature on the world stage. So if a founder such as Thomas Jefferson recognized the importance of the arts, it is certainly incumbent upon us to do the same. Thank you, Mr. President.
Thank you, Senator Chasnow. Good job. Appreciate you. Now we'll go to introductions. Senator Chasnow is accurate. This is the 250th anniversary we will be celebrating this year of our country. And tremendous planning is being done to do that. And we encourage all of y'all to participate. Senator Blackwell.
For announcement.
Please proceed.
Or introduction.
Please proceed.
I asked my colleagues to look up in the gallery. Today we have the Mississippi Society of Radiologic Technologists is hosting its Capitol Day. In attendance are students from radiologic science programs from 4 of our state schools: Copiah Lincoln Community College, Jones College, Pearl River Community College, and the University of Mississippi Medical Center. Please welcome them to their capital.
Thank you, and thank you for the good work you'll do in Mississippi over the years. Senator Butler.
Thank you, Mr. President. Introduction of resolution out of order.
Please proceed to the front. Senator Hill.
Introduction.
Please proceed.
Somewhere in this gallery, I think I have a special guest, Elise Goss from Pearl River Community College, who is the daughter of a close friend of mine that I actually taught her mother in school, and that tells you a lot. So Elise, if you're up here, please stand up and let us make you welcome.
Okay. Anyone else? Mr. Clerk, please read the resolution.
Commemorate 155th anniversary of Alcorn State University.
Thank you. Thank you, Senator. We'll go to any other introductions. Go to the calendar, please. Number 1, Senator Harkins. We're on number 1, Senate.
Thank you, Mr. President. I'd like to go to item 1, Senate Bill 2915, and have the title read.
Mr. Clerk, please read the title.
Senate Bill 2915, Alcoholic Beverages, Revised Provisions Concerning Native Wine Retailers Permits and Festival Permits.
Make the usual motion.
Makes the usual motion. All in favor signify by saying aye. Opposed,
Aye.
no. The ayes have it. Please proceed.
A motion is we adopt the committee sub and recognize Senator McMahon to explain the bill.
Senator McMahon, you're recognized to explain the bill, sir.
Thank you, Mr. President, Mr. Chairman. 8 years ago, Mississippi passed a series of laws to strengthen our fledgling wine industry, and the industry is continuing to grow. It's doing very well. I'm happy to report to you. There are some economic opportunities in the state for some of these wineries to expand. So what we've done is brought forward the code sections, and if you look, really, the crutch of the difference is on line 150. What it's doing, it's allowing our wineries to have freestanding tasting rooms in different areas of the state, but it is all native wineries, and they'll still collect the taxes there just like they currently do, but that's what the bill does. That's what the crutch of the bill is thick, but that's the only sections what really change, and the other items are conformity items. You have any questions? If there aren't any questions, I think there's an amendment.
Senator Fillingane, for what purpose, sir? I'm sorry, Senator Sparks.
Thank you, Mr. President, for the amendment that the senator just mentioned.
Okay.
Before we accept the amendment, I'd like to adopt the committee sub that I've just explained. My motion is to adopt the committee sub.
All in favor signify by saying aye. Aye. Opposed, no. The ayes have it. On the amendment, sir? It's on
the amendment should be on the board.
It's on the board.
It will strike section 4, which simply addresses a dormant commerce clause issue that we discussed in committee, and that is all it does, is just make sure it complies with federal law. I'll yield to any questions on the amendment.
Questions on the amendment? Questions? Seeing none, we're ready on the amendment. Senator Sparks, do you have a question, sir?
I'd like to speak to the amendment.
You can speak to the amendment.
Thank you, sir. This strengthens the bill. It's a friendly amendment, and the chair and I accept the amendment. I ask you to vote for it.
All in favor signify by saying aye. Aye. Opposed, no. The ayes have it. We're on the bill.
If there are any questions, I'll move for passage on the morning roll call.
Use of the morning roll call been requested. Anyone object? Cause voting no. Present? Seeing none. Bill passes by use of the morning roll call. Item 2, Senator Harkins. I'm sorry. Senator Chisholm, no. Anyone else?
Angela.
Norwood and no. All right, well, let's stop right here before I call it. Fraser, no. Chisholm, no. Norwood, no. Butler, no. Anyone else? Seeing none, bill passed. Tate? No. Tate, no. All right, guys, pay attention. Anyone else? Okay. Bill passed by use of the morning roll call. The noes noted. Item 2, Senator Harkins.
Thank you, Mr. President. I'd like to go to item 2, Senate Bill 2828, and have the title read.
Mr. Clerk, please read the title.
Senate Bill 2828, Money Transmission Modernization Act, require licensee to charge for PERS and 278G refundable via income tax credit.
Make the usual motion.
Usual motion. All in favor signify by saying aye. Opposed, no. The ayes. I'm sorry, Senator Simmons, I cannot hear you. Senator Simmons is recognized, sir.
Thank you, Mr. President. I object to the usual motion.
He objects to the usual motion. We got to read. This is the one to read the thing. The usual motion is to read. Right. So, yeah. One moment, please. You're objecting to the usual motion, Senator. That's what I'm thinking. need to get the whole bill, sir, because we're going to have to read it.
Learn something every year. Yeah.
Okay. Pardon me? Who's going to read it? You going to read it? Oh, you're going to do it by the machine? Okay, Senate, as I thought, we have to read the bill here on the motion, so, Mr. Clerk?
Wait.
$2,828. CT to require licensees under the Money Transmission Modernization, a CT, to collect a fee of $7.50 for each transaction. Not an ACT to require licensees under the Money Transmission Modernization, a CT, an ACT to require licensees under the Money Transmission, an ACT to require licensees under the Money Transmission Modernization, a CT, to collect a fee of $7, an ACT to require licensees under the Money Transmission Modernization, a CT, to collect a fee of $7.50 for each transaction, not in excess of 500, and 1.5% of any amount in excess of 500. To require the fee to be remitted quarterly to remit such fees. To remit ND7. To require licensees to post notice. Paid may be reimbursed through an income tax credit. To provide for license suspension and claims on a licensee's surety bond. To create the Law Enforcement 287. G. Program Fund to assist Immigration and Customs Enforcement, ICE, through the 287 G. Program under the Immigration and Nationality ACT, to create an income tax credit for fees paid under this ACT during calendar year 2026 or any calendar year thereafter. To amend Section 7516.5, Mississippi Code of 1972, Key Commissioner of Banking and Consumer Finance, and Department as the Department of Banking and Consumer Finance, for purposes of the Money Transmission Modernization Act, and for related purposes. Be it enacted by the Legislature of the State of Mississippi. Section 1. 1. Any licensee under this chapter shall collect a fee of $7.50 for each transaction, not in excess of $500, and, in addition, an amount equal to 1.5%, of any amount in excess of $500. 2. The fee prescribed by subsection 1 of this section shall be remitted quarterly to the Department of Revenue on forms prescribed by the Department. All required forms and remittances shall be filed with the Department of Revenue not later than the 15th day of the month following the close of each calendar quarter. 3. The Department of Revenue shall remit all revenues derived from the fee to the Law Enforcement 287 G Program Fund created in Section 2 of this Act. 4. Every licensee shall post a notice on a form prescribed by the Department of Revenue informing customers that, upon filing an individual income tax return with either a valid Social Security number or a valid taxpayer identification number, the customer shall be entitled to an income tax credit equal to the amount of the fee paid by the customer for the transaction, as provided in Section 3 of this Act. 5. If a licensee fails to file the forms or remit the fees as required by subsection 2 of this section, the Commissioner shall have the authority to suspend the license of the licensee. The licensee may not reapply for a license until all required forms have been filed and all required fee amounts have been remitted. 6. Upon request from the Department of Revenue, the Commissioner or the Attorney General may make a claim against the surety bond of the licensee on behalf of the State of Mississippi. Section 2. 1. A special fund, to be designated as the Law Enforcement 287 G Program Fund, is created within the State Treasury. The fund shall be maintained by the State Treasurer as a separate and special fund, separate and apart from the general fund of the state. Unexpended amounts remaining in the fund at the end of a fiscal year shall not lapse into the state general fund, and any interest earned or investment earnings on amounts in the fund shall be deposited into such fund. 2. Monies deposited into the fund shall be disbursed, in the discretion of the Department of Public Safety, to assist the enforcement efforts of state and local law enforcement officers, partnering with U.S. Immigration and Customs Enforcement, ICE, through the 287 G Program under the Immigration and Nationality Act. Section 3. There shall be allowed as a credit against the tax imposed by this chapter the amount of any fee paid under Section 1 of this Act during calendar year 2026 or any calendar year thereafter. The credit may be claimed for the taxable year in which the fee was paid. Any credit claimed under this section but not used in any taxable year may be carried forward for the 3 succeeding tax years. Section 4. Section 75-16-5, Mississippi Code of 1972, is amended as follows. 75-16-5. Definitions. For purposes of this chapter, the following definitions shall apply. A. Acting in concert means persons knowingly acting together with a common goal of jointly acquiring control of a licensee, whether or not pursuant to an express agreement. B. Authorized delegate means a person a licensee designates to engage in money transmission on behalf of the licensee. C. Average daily money transmission liability means the amount of the licensee's outstanding money transmission obligations in this state at the end of each day in a given period of time, added together and divided by the total number of days in the given period of time. For purposes of calculating average daily money transmission liability under this chapter, for any licensee required to do so, the given period of time shall be the quarters ending March 31, June 30, September 30, and December 30. D. Bank Secrecy Act means the Bank Secrecy Act, 31 U.S.C. Section 5311 its seek, and its implementing regulations, as amended and recodified from time to time. E. Closed loop stored value means stored value that is redeemable by the issuer only for goods or services provided by the issuer, or its affiliate or franchisees of the issuer, or its affiliate, except to the extent required by applicable law to be redeemable in cash for its cash value. F. Commissioner means the Commissioner of Banking and Consumer Finance of the State of Mississippi. FG. Control means I. 1. The power to vote, directly or indirectly, at least 25% of the outstanding voting shares or voting interests of a licensee or person in control of a licensee. The power to elect or appoint a majority of key individuals or executive officers, managers, directors, trustees, or other persons exercising managerial authority of a person in control of a licensee. The power to exercise, directly or indirectly, a controlling influence over the management or policies of a licensee, or person in control of a licensee. Presumption of control. 1. A person is presumed to exercise a controlling influence when the person holds the power to vote, directly or indirectly, at least 10% of the outstanding voting shares or voting interests of a licensee or person in control of a licensee. A person presumed to exercise a controlling influence as defined by this paragraph, F, can rebut the presumption of control if the person is a passive investor. 2. For purposes of determining the percentage of a person controlled by any other person, the person's interest shall be aggregated with the interest of any other immediate family member, including the person's spouse, parents, children, siblings, mothers and fathers-in-law, sons and daughters-in-law, brothers and sisters-in-law, and any other person who shares such person's home. H. Department means the Mississippi Department of Banking and Consumer Finance. Eligible rating means a credit rating of any of the three highest categories provided by an eligible rating service, whereby each category may include rating category modifiers, such as plus or minus for S&P, or the equivalent for any other eligible rating service. Long-term credit ratings are deemed eligible if the rating is equal to a minus or higher by S&P, or the equivalent from any other eligible rating service. Short-term credit ratings are deemed eligible if the rating is equal to or higher than a 2 or SP2 by S&P, or the equivalent from any other eligible rating service. In the event that ratings differ among eligible rating services, the highest rating shall apply when determining whether a security bears an eligible rating. HJ, eligible rating service means any nationally recognized statistical rating organization, NRSRO, as defined by the U.S. Securities and Exchange Commission, and any other organization designated by the Commissioner by rule, regulation, or order. Federally insured depository financial institution means a bank, credit union, savings and loan association, trust company, savings association, savings bank, or industrial loan company, organized under the laws of the United States or any state of the United States when such bank, credit union, savings and loan association, trust company, savings association, savings bank, or industrial loan company has federally insured deposits. JL in this state means at a physical location within the state for a transaction requested in person. For a transaction requested electronically or by phone, the provider of money transmission may determine if the person requesting the transaction is in this state by relying on other information, provided by the person regarding the location of the individual's residential address or a business entity's principal place of business or other physical address location, and any records associated with the person that the provider of money transmission may have that indicate such location, including, but not limited to, an address associated with an account. KM individual means a natural person. LN. Key individual means any individual ultimately responsible for establishing or directing policies and procedures of the licensee, such as an executive officer, manager, director, or trustee. MO. Licensee means a person licensed under this chapter. Material litigation means litigation that, according to United States generally accepted accounting principles, is significant to a person's financial health and would be required to be disclosed in the person's annual audited financial statements, report to shareholders, or similar records. OQ. Money means a medium of exchange that is authorized or adopted by the United States or a foreign government. The term includes a monetary unit of account established by an intergovernmental organization or by agreement between two or more governments. PR. Monetary value means a medium of exchange, whether or not redeemable in money. Q. Money transmission means any of the following. I. Selling or issuing payment instruments to a person located in this state. 2. Selling or issuing stored value to a person located in this state. And 2. Receiving money or monetary value for transmission from a person located in this state. RT. MSB accredited state means a state agency that is accredited by the Conference of State Bank Supervisors and Money Transmitter Regulators Association for Money Transmission Licensing and Supervision. Multi-state licensing process means any agreement entered into by and among state regulators relating to coordinated processing of applications for money transmission licenses, applications for the acquisition of control of a licensee, control determinations, or notice and information requirements for a change of key individuals. TV. NMLS means the nationwide multi-state licensing system and registry developed by the Conference of State Bank Supervisors and the American Association of Residential Mortgage Regulators and owned and operated by the State Regulatory Registry, LLC, or any successor or affiliated entity for the licensing and registration of persons in financial services industries. Outstanding money transmission obligations shall be established and extinguished in accordance with applicable state law and shall mean I. Any payment instrument or stored value issued or sold by the licensee to a person located in the United States or reported as sold by an authorized delegate of the licensee to a person who is located in the United States that has not yet been paid or refunded by or for the licensee, or is cheated in accordance with applicable abandoned property laws. 2. Any money received for transmission by the licensee or an authorized delegate in the United States from a person located in the United States that has not been received by the payee or refunded to the sender, or escheated in accordance with applicable abandoned property laws, or, for purposes of this paragraph, U. In the United States shall include, to the extent applicable, a person in any state, territory, or possession of the United States, the District of Columbia, the Commonwealth of Puerto Rico, or a U.S. military installation that is located in a foreign country. VEX. Passive investor means a person that I. does not have the power to elect a majority of key individuals or executive officers, managers, directors, trustees, or other persons exercising managerial authority of a person in control of a licensee. 2. Is not employed by and does not have any managerial duties of the licensee or person in control of a licensee. Does not have the power to exercise, directly or indirectly, a controlling influence over the management or policies of a licensee or person in control of a licensee. And IV. Either 1. Attests to subparagraphs I, T, and TU in this paragraph in a form and in a medium prescribed by the Commissioner, or commits to the passivity characteristics of subparagraphs I, T, and 2 of this paragraph in a written document. Y. Payment instrument means a written or electronic check, draft, money order, traveler's check, or other written or electronic instrument for the transmission or payment of money or monetary value, whether or not negotiable. The term does not include stored value or any instrument that I. is redeemable by the issuer only for goods or services provided by the issuer, or its affiliate, or franchisees of the issuer, or its affiliate, except to the extent required by applicable law to be redeemable in cash for its cash value, or 2. is not sold to the public but issued and distributed as part of a loyalty, rewards, or promotional program. Person means any individual, general partnership, limited liability company, corporation, trust, association, joint stock corporation, or other corporate entity identified by the Commissioner. Receiving money for transmission, or money received for transmission, means receiving money or monetary value in the United States for transmission within or outside the United States by electronic or other means. ZAB, stored value, means monetary value representing a claim against the issuer, evidenced by an electronic or digital record, and that is intended and accepted for use as a means of redemption for money or monetary value or payment for goods or services. The term includes, but is not limited to, prepaid access as defined by 31 CFR Section 1010.100, as amended or recodified from time to time. Notwithstanding the foregoing, the term stored value does not include a payment instrument or closed-loop stored value, or stored value not sold to the public but issued and distributed as part of a loyalty, rewards, or promotional program. AAC. Tangible net worth means the aggregate assets of a licensee excluding all intangible assets, less liabilities, as determined in accordance with United States generally accepted accounting principles. Section 5. Section 1 of this Act shall be codified in Chapter 16, Title 75, Mississippi Code of 1972. Section 3 of this act shall be codified in Chapter 7, Title 27, Mississippi Code of 1972, Section 6. This act shall take effect and be in force from and after July 1st, 2026.
Hawkins. Bill's been read. Senator, you ready? Right. He's made a motion, right? Okay, Senator, we have a motion. You have your motion? All in favor? Right. All in favor signify by saying aye.
Aye.
Opposed, no. Senator Simmons, for what purpose?
Mr. President, I request a roll call vote.
We need 6.
Need 6.
We have 6. Mr. Clerk, please call the roll.
Barnett, Barrett, Berry, Blackman, Blackwell, Blunt, Boyd, Brumfield, Bryan, Butler, Carter, Chazanall, Chisholm, DeBar, Delano, Dupree, England, Fillingane, Frazier, Gillespie Isom, Harkins, Harkness, Hickman, Hill, Hobson, Jackson, Johnson, Kirby, Ladner, McCon, McClendon, McMahon, Michelle, Mumford, Norwood, Parks, Pope, Rhodes, Seymour, Simmons of the 12th, Simmons of the 13th, Sparks, Suber, Tate, Taylor, Thomas, Thompson, Turner Ford, Whaley, Wiggins, Williams, Younger, Barnett, Barrett, Berry, Blackwell, Blunt, Carter, Chazanall, Delano, Harkins, McMahon, Parks, Rhodes, he's aye. I think we got them all. Voting yes or yea: Barrett, Berry, Blackwell, Boyd, Carter, Chazanall, Chisholm, DeBar, Delano, England, Fillingane, Harkins, Harkness, Hill, Hobson, Johnson, Kirby, Ladner, McCon, McClendon, McMahon, Michelle, Parks, Rhodes, Seymour, Sparks, Suber, Tate, Taylor, Thompson, Whaley, Wiggins, Williams, Younger. Voting no or nay: Barnett, Blackman, Blunt, Bryan, Butler, Dupree, Frazier, Gillespie Isom, Hickman, Jackson, Mumford, Norwood, Pope, Simmons of the 12th, Simmons of the 13th, Thomas, and Turner Ford. Tate. Okay. Go back and call again. Bumper is not here yet, either. What you getting? 3417?
Senator Harkins, let's go. By a vote of 34 to 17, the usual motion passes. Senator Harkins, you recognize.
Thank you, Mr. President. I'd like to adopt the committee substitute and recognize Senator Hill to explain the bill.
Senator Hill, you recognize.
Thank you, Mr. President. On wire cash transfers, the federal government already charges a fee. What this bill does, it allows a fee to be charged only on cash wire transfers out of the country. If it's less than $500, it's $7.50. If it's greater than $500, it's 1.5%. If you don't want to pay the fee, you simply can use a bank or credit card or a debit card. Even if you use cash and you file a tax return, you can still get the money back at the end of the year if you are a citizen. So that's basically what this bill does. It's something that's been happening in Oklahoma for many, many years. It's tested. It's legal. We're trying to capture those transactions that are not having cash paid, having taxes paid on them, and that are money laundering, going out of the country. A lot of this is from drug smuggling, human trafficking. Some of it is cash being paid under the table, exploiting the workers and paying them cash, and then they're sending the money out of the country. So that's basically what the bill does. If you have a bank account, credit card, or a debit card, you would be exempt from it. It's only for those cash transactions to catch those who may not be paying taxes or may be sending money out of the country for money laundering or criminal purposes. And that's basically what the bill does. And we would also like to make an amendment to the bill and add a reverse repealer to it. We spoke to Chris Graham yesterday over at the Department of Revenue, and we're trying to get a few things worked out to make it seamless and to make it to where if somebody is trying to retrieve their money through the Department of Revenue, that we would have a mechanism to catch any type of fraud. Because now that we have artificial intelligence, we want to make sure that whatever receipt that they have, if they're going to try to get it back at the end of the year, that that's a legitimate receipt. So that's some things that the Department of Revenue and the Banking Association and the licensees that do wire transfers would have to work out. So I guess my motion would be to adopt a reverse repealer. I'm sorry. We're getting it drafted. I move to adopt the committee sub.
All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Senator Tate, while we're waiting on the committee sub, do you have an introduction? Okay. Senator Blackman has a question. Senator Johnson has a question.
I have an amendment at the appropriate time, Mr.
Please
President.
bring your amendment forward, sir. Senator Johnson. One moment, Senator Johnson.
Thank you, Mr. President. Question?
Question?
Yes.
Senator, I appreciate you working with me in committee when we exempted FDIC-insured banks or institutions. You mentioned trying to prevent or stop money laundering or fraud. I know that you've worked on some of these things. There are several rules about money laundering and that have already put a burden on financial institutions and individuals. You know, for years we saw where people would have cash over the amount of $10,000 that would be seized and later forfeited. You know, we changed some laws in our state. There's a federal court decision on that. But already there's a huge burden on legal law or law-abiding citizens regarding how much money they can have, how much you can deposit into a bank. There are major restrictions on people doing things correctly. And one of my concerns on this bill is that you're ensnaring people who are operating legally and then requiring them to go back and try to get money from state via income tax credit, which we are reducing and eliminating the income tax over time, and a lot of people may not even have an income tax liability to get their money back, which we see that now with the inventory tax, which is a problem, right? And so I would ask you then to consider looking at ways where, as people make these transactions out of state or out of country, we do not charge them a fee, or they're not charged a fee if they are here legally. Not just a U.S. citizen, but someone here working on a visa. So if someone is picking blueberries in Pearl River County, that is an asset to the landowner, to our community. And if they want to send money home from that, I would like to not ensnare them into a fee for doing that. And so I would ask you, as you work through this, to consider ways that we can not charge people that are U.S. citizens or here legally in any way.
We definitely will, and I might say that they already pay a fee to the federal government no matter what when they send a fee, when they send a transfer out of the country. And as we were looking at those federal rules that you mentioned, we think that those federal rules would take care of the concerns that we have already. But that's something that that the Commissioner of Revenue and the Department of Banking and Finance, that we need to get together and further discuss that. And so that's kind of where we are in the conversation, to see if we think those federal rules would potentially maybe catch some of those that are here legally that you're concerned about. And also, you already put the amendment in there the other day in committee that if you use a bank, a credit card, or a debit card, that you're exempt from this fee. So we do have a way right now for somebody legally to be exempt from the fee, but we will continue looking at that. And we think that the rules, the federal rules, the main thing we want to do is check the legality. And I think that the federal rules, there's some federal rules there that would help us do that already. And we certainly don't want to put any extra burden on the Department of Revenue to have to search through, and try to decide whether or not the claims at the end of the year are valid or not. So that's what we're looking at right now. So we have the reverse repealer. So my motion will be to adopt the reverse repealer.
All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. We're on amendments. Senator Blackman.
Thank you, Mr. President. This bill, as currently drafted, reminds me of a Eddie Murphy joke that he told back in the 80s. It was about Johnny Carson. I'm going to paraphrase and keep it PG for Senate rules. But he was talking about if you partner with Johnny Carson, who already has $300 million. Sometimes, couples got to get second jobs to make ends meet. So you go get your second job, come back, here, Johnny, here's my $70. Now we have $300,070. What this amendment does is it takes all the funds that we're taxing, and it all goes to the general fund. Half of it would not go to the 287 program fund that our law enforcement agencies around the state can already partner with ICE. ICE has a $10 billion annual budget and a $75 billion surplus budget. So they have $85 billion already to use if they want to partner with any local law enforcement agency. So what we would be doing right now, as this bill is currently drafted, is sending them, $3, $4, $5 million, so they have $85 billion and $3 million? They're never going to touch that $3 million. It's going to sit there and collect dust. So I don't understand why, if we are going to enact this bill and tax this money, why would it not go to our general fund? As Senator Johnson just pointed out, we're eliminating the state income tax. So we need funds to come from somewhere to our general fund. And if we adopt this amendment, This amendment would take all of those funds and send it all to the general fund and not send half of it to an agency that already has $85 billion. That's my amendment, and I'll take any questions.
Questions on the amendment? Senator Sparks, please.
Question,
What
Mr.
purpose?
President.
Senator Blackman, you recognize the senator?
Yes.
Senator Sparks, you're recognized for a question.
Thank you, Mr. President. Thank you, Senator. I understand your analogy and your joke was spot on. That was good. But my question is, this money, is it not going into a fund that's controlled by the state of Mississippi that would allow grants to local units of government to work in conjunction through the 287G?
Yes, it is. But what I would say to that is we already have law enforcement agencies that are working with them. Now, if you can tell me that the federal government and ICE's $85 billion budget is not helping them do that already, then that would make my amendment useless. But I believe if you're partnering with them, they're going to give you the money to whatever training, whatever coordination they want to have, because they can't spend the money. They want to use it and they want to partner with us.
And I don't disagree with you that the federal government's got more money, but is this body going to get to vote on ICE funding this year for the federal government?
No, this body doesn't get to vote on ICE funding, but this body should be good stewards of our money. And if we're taking all different sources of income tax and revenue from our general fund, and we need to find ways to fill that general fund, this is a way to do that without taking half of that money and putting it towards programs where you can already work with the federal government and get those funds to do that.
But you can work with the federal government, but you can't dictate that they give you a certain amount of money, because if we can do that, I would like to ask FEMA to send us more money, because they've got billions of dollars, and we fund MEMA, and this body has tried to put money aside for our local units of government, but based on your theory, the federal government's got enough money that we shouldn't put any money toward FEMA because we can partner with them. That's kind of my disconnect. I understand you're correct. Federal government's got a lot more money than us, but the money that's going into this fund is for the specific purpose of grants to local units of government if they wanted to partner, whether that's buying technology, whatever it's doing. And you are correct, the federal government could probably pay for all of it, but we don't get to vote on that. This is the only thing we get to vote on, is to actually have funding for law enforcement to carry out a partnership of which is of their choosing. Is that fair?
That's fair, but I still believe that any local law enforcement agency that wants to partner with the federal government through ICE, through the 287 program fund, can get them to give them that money to do it. Because from what I've seen, they are very willing to work with any local law enforcement agency that wants to work with them.
Okay. Thank you, Senator. Thank you.
Okay. I'm sorry, Senator Harkins.
For an introduction.
Please proceed.
Ladies and gentlemen, we are honored today to have a group of fifth graders from Oakdale Elementary. Miss Laura Howell is their teacher. They are here today to watch the Senate. If y'all would please help me make them welcome.
Okay, back on the bill. Senator McMahon. For what purpose, sir?
I have a question.
Please proceed.
This bill went through committee and it was heavily debated in committee, and I'd like to hear the chair's position on the amendment before we vote.
The chair's position on the amendment. Senator Harkins. He's going to speak out on close. Any other questions for Senator Blackman? Any other questions for Senator Blackman? All right, we have the amendment. Senator Harkins, you're recognized to close on the amendment.
I appreciate Senator Blackman's spirit of what he's trying to do. I think part of to kind of echo what Senator Sparks said, I said, you know, this is giving them the funds because we don't get to dictate how much they reimburse. I know they will reimburse with the state, but this gives the funds to DPS to administer, and there is a 3-year repealer we can come back and look at, and if we need to tweak that amount and realize that there's more in there than needed, then we can make that adjustment at that time. So I would oppose the amendment.
Okay. Ready on your motion, sir.
Can I close?
Yes.
Oh. Well, just that, there's a reverse repealer in there. So if we adopt this amendment, when we look at it, we can see if we do actually need to send half the funds to this program fund instead of in a general fund. I move for adoption of the amendment.
All in favor signify by saying aye. Aye. Opposed, no.
No.
The chair is in doubt. We'll go one more time. All in favor signify by saying aye. Aye. Opposed, no. No. We're still in doubt. There we go. We have one. Ready, individuals? If you go back to your chair, please. Senator Blunt, Senator Thompson, Senator Carter, thank you. If you are in favor of the amendment, please stand. If you are opposed to the amendment, please stand. (31 to 17), amendment fails. Okay, Senator Harkins, we're back on the bill.
Move final passage on the morning roll call.
Use of the morning roll call has been requested. Does anyone object to the procedure? Wish to be recorded as voting no on the bill. No on the bill, Senator. Senator Fraser, Senator Dupree, Senator Isom, Senator Mumford. I'll keep going. Senator Thomas, Senator Hickman. Could you raise your hand higher, please, sir? Senator Simmons, Senator Norwood, Senator Barnett, Senator Blackman, Senator Simmons, S., Senator Jackson, Senator Turner Ford, Senator Pope, Senator Blunt, Senator Bryan, Senator Butler. Anyone else? Mr. Clerk, did you get both Simmons?
Yes, sir.
(17 noes). The bill passes. Thank you, Mr. Clerk. Item 3, Senator Harkins. I'm sorry, Senator McCon, for what purpose?
Mr. President, to announce a pair.
Please proceed.
Mr. President, if Senator Brumfield was here, he would be a no, and I am an aye.
Pair, McCon and Brumfield. Now, the vote is announced. We'll pass the bill, finally. Item 3, Senator Harkins.
On to the non-controversial calendar. Item 3, go to that item and have the title read.
Mr. Clerk.
Senate Bill 2863, Bayou Casat Industrial Zone Establishment Act and Enact.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed, Senator.
Recognize Senator Wiggins to explain the bill.
Senator Wiggins, you're recognized.
Thank you, Mr. Chairman, Mr. President. And to be clear up front, this bill affects nobody in this chamber, their areas, except in Jackson County. The reason it's a general bill is because of the it can't be a local and private due to the nature of it. And what it's doing is around Chevron facility is creating an industrial zone. That's what it's doing. There's some, let's just say, local back and forth going on. This is about economic development for Chevron. It's also economic development for Jackson County. And we want to see economic development to grow in this state. And we also want to see partnerships with our various entities. So just for those that have any questions, there are discussions going on, and I appreciate the chairman working with us on this. The House has a bill as well, and so I'd be happy to answer any questions, Mr.
Questions
President.
on the bill? Seeing none, we're ready for your motions.
Move passage on the morning roll
Yes, the
call.
morning roll call. I'm sorry, Senator Seymour. Yes, sir?
Question, Mr.
Oh,
President.
you have a question. Senator Wiggins, will you yield for a question?
Sure.
Senator Seymour, you recognize.
Thank you, Mr. President. When it comes to exemptions as far as the industrial area, will school taxes ad valorem, will it be exempted, or will it still go through, and will it now be part of the county?
No, this has nothing, this is not affecting school taxes at all.
Thank you.
Thank you, Senator Seymour. Senator McClendon, for what purpose?
Question, please.
Will you, Senator?
Yes.
Please proceed.
Does this involve any annexation?
The bill itself is dealing with the industrial complex, but yes, there's it has its roots in those local politics, yes.
Will people living in the county be annexed by a municipality with this bill?
If this bill passes, the people in the county, in the area in this industrial complex, that cannot be annexed.
They cannot.
Cannot.
Thank you.
Yes.
Senator Tate?
Introduction at the proper time.
Go ahead, Senator. We missed you last time.
Ladies and gentlemen of the Senate, if y'all can direct your all's attention to the South Gallery, we have with us today Mr. Daniel Weil and Ms. Caitlin Harris. They are the State Game Athletes of the Year. If y'all will, please make them feel welcome.
Congratulations. Lots of effort to get there. Okay. Last question. Senator McMahon.
I have a question.
You, Senator? Senator
Yes.
McMahon's recognized.
Yes.
So I rise for this question because of my colleague, Senator McClendon's questions. Just for the body, this deals very specifically with a very specific area that's basically in your area.
100%, that is correct, and thank you.
I'm sorry, Senator.
No, that's 100% correct, yes.
And the reason you're having to do this through general legislation is because the local and private doesn't apply.
Correct,
of the law. Okay.
because of the particular nuances of all of this stuff.
Correct.
Yes.
I've read the bill. It's listed in the bill, the actual area.
It actually gives legal description of the area, which is the Chevron facility in that area.
I didn't want there to be any confusion about that.
No.
Thank you, Chairman.
Appreciate it.
Okay, ready for your motion, sir?
Motion is passage on the morning roll call.
I'm sorry, we have one more. Senator Barnett.
Thank you, Mr. President, for a question.
Will you for a question, Senator Wiggins?
Yes.
Senator Barnett, you're recognized.
Senator Wiggins, I just want to make sure that I'm hearing this correctly, is that this is only applies to an area where you are, correct?
Just like Senator Boyd said, study committee 5 times, the third time, yes, it applies to just Jackson County area.
Okay, so I can ask that 2 more times.
Right. No, yes, it's just the Chevron facility, borders with the city of Pascagoula, the refinery is not in the city limits, which is a fact, and we want to promote economic development.
Would there be any chances in the future if another municipality or another area in the state could use this same language or could use this particular bill in an annexation lawsuit because they have something similar to Chevron or something similar to what you have going on in that area, is that possible or not?
I don't know how it could be, because if you look at in section 3, it it lays out what we call the legal boundaries of that area, and that's only, and the reason we did that was because that is where it's at. It can't be language that apply. That description cannot apply anywhere else in the state.
Okay, so I'm just asking, but there could be similarities. Where it says Jackson County, it could be Jasper County, and where it says Chevron, it could be Hunt Oil, because the comparisons are so similar to what you have. And so if the legislative, so what I'm asking is that, can that be used in a court of law and say that, well, the legislative body passed this based on this, and we have similar or just like the same things that you are proposing in this bill? So that's why I'm asking, because we know how Supreme Court rulings and things like that goes, so, and that's because of a lot of similarities to the same thing.
Right. Senator Barnett, I don't think so because of what I said, which is the description of the boundaries. You can't take that and apply it into Jasper County because you have this specific description. Now, if it is passed into law, I'm not going to sit here and say some crafty lawyer can't say, oh, they did this, and so now we're going to go apply it over here. But you can't. This is not, and that's what I said. We wanted to do this as a local and private, and so did the House. But because of the nature of what we're dealing with, an industrial zone, that can't be local and private. So that's why we're doing this general. And that's why, by the way, it's called the Bayou Casat Industrial Zone. Bayou Casat is where the Chevron refinery is. As far as I know, there's no Bayou Casat anywhere else in the state.
I understand that, but I'm just talking about if there's strong similarities to what you're proposing, and there's another entity out there where the city and this place may lie right outside the city, like in the county, but it would be a perfect for an economic development, and the same situation occurs there that's happening in your county. How could that not be used to prove their case in a court of law that said, hey, Jackson County and Pascagoula was able to do this, and now we can't? Maybe Hopkins.
Well, I'll just reiterate that it's very specifically tailored. It's very specifically tailored to this one area of Jackson County.
Okay. Thank you, Senator.
Thank you.
Seeing no further questions, we're ready on your motion, Senator.
My motion is passage on the morning roll call, Mr.
Use
President.
of the morning roll call been requested. Anyone object? Carter's voting no.
Thank you.
Present?
Thank you.
Seeing none, bill passes by use of the morning roll call. Number 4.
Thank you, Mr. President. I'd like to go to item 4, Senate Bill 2874, and have the title read.
Mr. Clerk, please read the title.
Senate Bill 2874, Common Cent and Gold Silver Commemorative Coin Act, enacted.
Make the usual motion.
Amendment makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed. Senator Kirby.
Thank you, Mr. President. An introduction at the proper time.
Please proceed by Senator.
Thank you,
McManus
Mr. President.
recognized to explain
Ladies
the
and
bill.
gentlemen of the Senate, in North Gallery today we have the Psychological Association for their day here at the Capitol. And the North Stand, if they would, in the North Gallery, if they would please stand and let their Senate make them welcome.
Yes, sir. Senator McManus recognized.
Yeah, my motion is adopt the committee sub and recognize Senator McMahon to explain the
Senator
committee sub.
McMahon, you're recognized to explain the committee sub.
The motion is to adopt the committee sub. I'd like to explain it.
Please.
So originally, the original bill dealt with rounding. So municipalities and government entities, as you know, the penny is going away. The federal government's omitting the penny. So the original intention of the bill was to allow all entities within government to a round to the nearest dime. And so the chair had a different bill that we took care of that, and we're going to round to the nearest nickel. So what's left in this bill, and this is the committee substitute, as you know, senators, in the state of Mississippi, we've done so many positive things about our image here in Mississippi and promoting the very best of the state. We now have a state song and a state tartan. Yesterday, we could have a state tartan. We've got a state berry bush. And so we're trying to promote the best of the state. So what this bill does, it will empower or authorize a state treasurer to mint some gold and silver commemorative coins. And that's all it does. He may enter into those agreements. That's what there's no money in this bill. The bill does allow him to take pre-orders for the gold and silver commemorative gold coins. But here's what the design will be, starting on line 17. Well, I want to back up to 14. First of all, the coins have to be minted at the same standard as an American Eagle, gold or silver eagle. So that sets the standard. The words, "The state of Mississippi," shall be on the coin. The phrase, "In God we trust." The year in which the coin is minted. On one side, it shall have the great seal of the state of Mississippi, and the reverse side shall have a magnolia flower. No monetary value can be assigned to the coin, so it's only for commemorative purposes. And the coin shall not feature any image of any human being or any human beings. So it will be done in the best to promote the state. I believe there is a lot of demand for this. I believe that it will become a family heirloom. Many of you might want to purchase one for your own children to be passed down from generation to generation. The state treasurer is also authorized to keep 20% of the profits from the measure, and he may not sell these coins at a loss, in which I think there will be a lot of pent-up demand, and the coins will sell at a cost plus premium. And so that's what the bill does. I have some examples of some coins that I brought with me. These are not silver or gold rounds, but this is an 1898 American coin. Think about all the hands it went through. It's an American $20 gold piece. Very rare. Less than 1% of these exist in the world. Also, I brought a 1921 Morgan dollar, which is a very sought-after coin. Now, these coins have monetary value. But the coins that we will authorize the treasurer to mint will not have any monetary value. So that's what it does. And by the way, for those interested in the gift shop, we already sell commemorative coins that would be sorted. But this is about a $5, basically worthless coin. So the coins that we would mint would be in the finest taste. In pursuit of gold and silver bullion for those that would like to pursue it. And I would yield for any questions.
Senator England, for what purpose?
Questions, Mr. President?
You yield for a question?
Yes.
Senator England is recognized.
Thank you. Thank you, Senator McMahon. Is this going to cost the state of Mississippi anything?
No, sir. There's no money in this at all. The state treasurer, I've discussed it with him. He can private contract with someone to handle all of it. They'll just get a portion of whatever the profits will be if that's the way it's done. He could do it a lot of different ways, but there's no money associated. Not one penny of taxpayer money will be spent to pursue this.
Does Mississippi have a mint? Do we have? I don't think we have a mint. Do we?
We do not. No,
okay.
There are some companies in the state that could strike these coins, though.
Is this going to be? It's going to be required that they're gold or silver. Did I understand that correctly?
It'll be, yes, in the same quality as an American gold eagle, which is 90% gold, or a silver eagle, which is 90% silver. So it has to be done to that same standard. It can't be a substandard coin. If we're going to do it and promote the best of this state, it's going to be done at the highest quality in the coin industry.
Where is that gold and silver? Do we have that stockpiled, or how do we get that?
All of that, Senator England, will be handled by the treasurer. He can contract with someone to do it, a public or private entity. He may be empowered to contract with the U.S. Mint. He may choose to go that route and let the U.S. Mint handle it.
Is he going to have to abide by the regular rules when contracting and to try to find somebody? Is he going to have an RFP and go with the lowest bidder, or how does that work?
That piece of legislation, this piece of legislation doesn't address that, but I'm sure that he will follow all state laws.
Okay, I just want to make sure. One thing I'm always worried about when we do something like this is what it's going to cost the taxpayers. And I know that we have good intentions here. I agree with you that we need to make sure Mississippi always looks its best and does good things to promote our state. I just have concerns whenever we're doing something, whether it's going to cost us money.
It's not going to cost there's no money in this bill. It doesn't authorize him to spend any money, and there's no money tied to this. There's no fiscal note.
Okay, is there any requirement that any mints that we contract with be located within the state of Mississippi?
No, sir. He can enter into an agreement with a public or private entity.
Okay.
And that's, it is in the bill that he can he can take pre-orders. So if he wants to sell the coins in advance and know exactly how many he's going to strike, he can do that. And look, the treasurer may do nothing with it. We're just empowering him, a treasurer, to do that if they'd like to.
So I know that when we, for instance, the new state flag we had a commission that decided on the design. Who decided on this design of the coin that you have here in this bill?
I wanted it to be done in a way that would honor our state. And so I discussed it with several different ones, and we thought that the state seal on one side is appropriate, and on the other side, our state flower, which is the magnolia. Now, the design of the magnolia is not dictated in the bill, but I know the treasurer's office will seek a beautiful design.
Did you talk with anybody with Visit Mississippi or any of the tourism folks that know what images? Mm-hmm. Okay, what did they say about the design?
We didn't. I don't recall what we said about the design. They just thought the concept was a great concept, and they liked the flower and the steel.
Okay, so our tourism group is on board with this?
Well, they're not endorsing the bill or anything of that nature, but I mean, I don't think they're opposed to it. As a matter of fact, most everyone I've talked to are very excited about the opportunity. Very excited about the opportunity that they may can pre-order or purchase a gold or silver commemorative coin from their state. They love that idea.
That's great. I haven't heard from anybody, but I'm sure I will. The treasurer, does he endorse this bill?
I have met with the treasurer on the bill multiple times. He's excited about the bill. I'm not going to tell you he's endorsing it, but he's excited about it, and he appreciates that it's a may and it's not a shall. So depending on economic conditions and depending on his will, he can do it anyway. This only authorizes him to do it.
Okay. Thank you, Senator McMahon, for bringing this important legislation.
Thank you, Chairman.
Ready on your motion.
I move for passage on the final roll call. I move for adoption. The motion before us by the chair was to adopt the committee sub, and that's my motion.
Motion is to adopt the committee substitute. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it.
My motion is we pass on the morning roll call.
Use of the morning roll call been requested. Anyone object to that procedure? Wish to be recorded as voting no.
I yield.
Chisholm, no. Harkness, no. Blunt, no. Anyone else? Anyone else? Seeing none, the bill passes with the 3 no votes. Motions to reconsider. Motions to reconsider. Last call. Senator, what number are you, sir?
Number 8.
What number are you, Senator Michelle? Okay. So we're 5, 6, and 7 stay. Number 8, Mr. Clerk. Senator Barrett, you're recognized.
Thank you, Mr. President. I'd like to go to item 8 and have the title read.
Mr. Clerk, please read the title.
Senate Bill 2203, State Agency Property, authorize DFA as central leasing agent for all state agencies.
Mr. President, I'd like to reconsider the vote by which the bill passed.
All in favor signify by saying aye. Opposed, no. The ayes have it. Please proceed, Senator.
Mr. President, I have an amendment, so I'd like to move to amend this bill. This bill was held by Senator Blunt and Senator Sparks. They have come to an agreement as to the language that they wanted to put in this, and I have that amendment, Mr. President.
Is that on the screen?
No.
Hold one moment, please. Okay, we're ready.
Thank you, Mr. President. The amendment's on the screen. What it would do is add those two entities. Mr. President, I'd yield for any questions, and if there are not any, I'd suggest passage by use of the morning roll call.
Questions on the bill, on the amendment? Questions on the amendment? Seeing none?
Mr. President, I suggest passage by use of the morning roll call.
One moment, please, Senator Sparks. He was just practicing. So your motion, sir.
Yes, sir. I suggest passage by use of the morning roll call.
Anyone object to that procedure? Wish to be recorded as voting no. Present? Seeing none. Senator, the bill passes upon reconsideration. And Senator Michelle. Senator Michelle?
Yes.
I'd like to go to item 9, ask that the title be read.
Mr. Clerk.
Senate Bill 2479, Creating Transparency and Accountability in Dental Services Act, enact.
I make the motion to table the motion to reconsider.
Motion to table. All in favor signify by saying aye. Opposed, no. The ayes have it. Any other motions to reconsider, Senate? Any others? Senator Fillingame, which one, sir? Item 10. Mr. Clerk, please read the title.
Senate Bill 2114, Illegal Immigration Criminalized under state law.
Move that we table the motion to reconsider.
Motion is tabled. The motion to reconsider. All in favor signify by saying aye. Opposed, no. The ayes have it. Anyone else? Any? Senator? Which one, sir? Number 11, Senator, you're recognized. Mr. Clerk, please read the title.
Senate Bill 2432, State Inmate Housing Rate, remove certain provisions.
Thank you, Mr. President. I'd like to reconsider the vote by which that bill passed.
All in favor signify by saying aye. Opposed, no. Ayes have it. Please proceed, Senator.
Thank you, Mr. President. We have heard some concerns from our cities regarding what was in this bill regarding what the counties could charge for the inmates that are in the city. So all we want to do, Mr. President and members of the Senate, is to put a reverse repealer in the bill so we can keep the bill working. Keep the bill moving, but also work with our counties, our sheriffs, as well as our cities on what is fair regarding the housing rate for the municipal inmates.
In your motion, sir?
I think we have to adopt
An amendment. We have to
adopt the amendment, Mr. President.
Yes. It's on the screen, I think,
Okay.
Senator.
And members of the Senate, this is just a reverse repealer in the bill. I move that we adopt the reverse repealer.
Seeing no questions, all in favor signify by saying aye. Aye. Opposed, no. The ayes have it. Thank you, Senator Simmons.
Thank you, Mr. President. I think, do I have to move? I move adoption by the morning roll call now, Mr. President.
Use of the morning roll call has been requested. Anyone object? Seeing none, bill passes by use of the morning roll call. Number 12, Senator McMahon.
Yeah, I call up item 12 and ask the title be
Mr. Clerk,
read.
please read the title.
679, Mississippi Land Bank Act, Local Government Transfer Vacant and Abandoned Property to.
My motion is that we can reconsider the vote on Senate Bill number 2672, reconsider the vote by which it passed.
All in favor signify by saying aye. Opposed, no. Aye. I need aye, at least one.
Aye.
Opposed, no. Bill, go forward, sir.
Okay, we're on the bill. So yesterday, Senator Blunt had offered an amendment to this bill. So I would like to reconsider the vote by which the amendment passed, and I ask you to vote no to the Blunt amendment. My motion is, we're on the bill. My motion is to consider the amendment by which it passed, and now I'm asking you to vote no to the amendment.
Just 1 second. We don't have the amendment, Senator.
And by the way, I didn't know Senator Blunt was on the phone, but Senator Blunt and I have discussed this at length, and his intentions, I support his intentions, but we think that it drew some negative criticism. So what we would like to do is withdraw it, and I support. He and I have talked, and and he agrees with me. So this is This is an opportunity. We're working together, and I appreciate what he's doing. So we're on the amendment, and my motion is that you vote no to the amendment.
All in favor, reconsider the vote, please signify by saying aye. Opposed, no. The ayes have it. Please proceed.
All right, we're back on the bill as it was before it was amended.
We did that.
Now I have a motion. I would like to add a reverse repealer to this piece of legislation so that I can address some of your concerns. This is the only piece of legislation left that deals with this. I know this land bank is very important to some of you. It's very important to our cities. And so I want your input. You'll get a chance to see this again. But my motion is that you support the amendment to add a reverse repealer.
Questions? Seeing none.
Motion, we adopt the amendment.
All in favor signify by saying aye. Opposed, no. The ayes have it.
So we're on the bill with the reverse repealer in it. And my motion is that we move.
We have a question. 1 second, please. Senator Sparks. Be you for a question, Senator McMahon?
It's
Yes.
point of parliamentary inquiry. The senator asked us to vote no on the amendment. Nobody said a word, and the vote was called aye. So the amendment was not stricken. If I'm asking that question as a point of parliamentary inquiry.
I voted aye.
Hold on just a second.
No.
Okay. The amendment. We're on the Blunt amendment. I'm asking you to vote no to the Blunt amendment, to take the Blunt amendment out of the bill. So my motion is that we can reconsider the vote on the amendment and ask you to vote no.
I don't think that's right, Senator.
For clarification, we're on the Blunt amendment. I'm asking the body to vote no to the Blunt amendment. The amendment is before us. I'm asking you to, and I call for, I use the morning roll call and I ask you to vote no.
All in favor signify by saying aye. All opposed signify by saying no.
No.
Okay.
All right, that amendment has been taken out. So now I have an amendment. My amendment is a reverse repealer. As I stated, there's some questions about the bill. This is the only bill left to address this. This is very important to some of the municipalities in the state. It should be important to each of us to support our 298 municipalities. 30 other states are already using this particular piece of legislation in their cities. So I ask you, I move for adoption of the amendment to add a reverse repealer, and I ask you to vote aye.
All in favor signify by saying aye. Aye. Opposed, no. The ayes have it, Senator.
We're on the bill amended with the reverse repealer. I yield for any questions.
Questions on the bill? Senator Chisholm? I'm sorry. Here we go. That was Senator Sparks, actually. All right.
Okay.
Seeing no questions.
I ask you move for passage on the morning roll call.
Use of the morning roll call has been requested. Anyone object? Opposed voting no. Suber, no. McCon, no. Whaley, no. Chisholm, no. Taylor, no.
I move for a point of personal privilege.
One moment, please. Harkness, no.
Thank you.
We're on the vote here. One moment, please. Anyone else? Anyone else? Just one moment.
It has to do with this bill, Mr. President.
Bill passes by use of the morning roll call.
I move for point of personal privilege.
Please proceed.
The other day when we were debating this bill, Senator McCon asked a question of the presenter, and when the chair came and spoke at the end for closure, I invoked Senator McCon's name without giving him an opportunity to reply. And to that, I publicly say to Senator McCon, I apologize for that. I was just trying to answer your question, but I do offer you an apology because you should have had an opportunity to reply. And to this body, I appreciate this body in the debate, and so I just apologize to the entire body, and I want us to work together. I meant no offense to Senator McCon or anyone else. I yield the podium.
Thank you. Item 13. Item 14. Seeing none, Senator McCon. Item 15, Senate.
Mr. President, I would call up item 152632 and move that it be taken from the table for consideration.
All in favor signify by aye.
Aye.
Opposed, no. The ayes have it.
Mr. President, I would ask that Senator Lano be able to continue the conversation on this as we've already adopted the committee sub previously.
Senator Delano, you recognize.
Thank you. Ladies and gentlemen of the Senate, this bill was originally filed to help address an issue that we have seen coming for a number of months now. At the federal level, FEMA and DHS has given the states indication that they are going to significantly change how we respond to natural disaster events. And we do not know currently, as of today, what those changes are going to be, how deep they're going to affect our local states. So the purpose of this bill originally was to bring forward code sections for us to continue to work on these issues with our federal partners and to understand how this may be impacted and what changes would need to be made to our disaster recovery account and general legislation to give MEMA the authority and the governor's office to respond or to natural disasters in the future. However, as many of you know intimately and you're still living it today, on the fourth weekend of January, the state began another historical natural disaster event that is a generational event that occurred in the north part of our state. We had many families that were disrupted. Many of our members had issues that they're still dealing with, and anyone from the coast knows how this is going to impact families for a very long period of time. Not physically, not just physically, but it's going to be an emotional scar. It's our duty, it's our job to make sure that we do what we can to give our local entities the support necessary from the legislature and from the state to provide for immediate needs while we are waiting for FEMA money to start flowing to the state. Now, there are many things that are ongoing right now between MEMA and our local jurisdictions to try to help address some of these response and recovery issues. But there is going to be a problem, and we know this, we see it, and many of you have already had phone calls on this. There's going to be a very difficult time where our counties and municipalities are going to have a cash flow issue. So this body, led by the Lieutenant Governor, Lieutenant Governor asked me and the Appropriations Chairman to try to find a way for us to provide some instant liquidity to our local entities so that they can help cash roll some of these responses that they are in the recovery efforts that they are ongoing at this time. So yesterday we passed the motion, or we passed the committee sub, which brought forward the code sections. I'm now going to offer an amendment, and that amendment is going to be to explain a concept of a revolving loan fund that would provide instant or quick liquidity to some of our entities, and I'd like to explain that amendment at this time. So, Mr. President,
you're recognized to
let me
explain the
recognize-
amendment.
Thank you. Ladies and gentlemen, this was an unprecedented storm that requires a lot of effort from everyone that's involved. And there is no precedent today for a revolving loan fund to help with our local entities respond to these federally declared natural disasters. What we're presenting here today is something that has been done in the state of Tennessee, or very similar to a program that has been very successful after Hurricane Helene in Tennessee. What this does is it establishes a local government's disaster recovery emergency loan program. And it's just for the disasters that were the federally declared disaster for the ice storm, which currently there are over 33 counties that are affected by this. And everyone in this chamber needs to know that when FEMA and MEMA did their initial disaster assessments, I believe they were only able to get to somewhere around 13 or 14 counties, because at the time of the preliminary assessments, there were many counties, another 13 or so, that were under the ice cap, if you will, where they were not able to go in and do those assessments. But this bill would be limited to the federal declared disaster area as amended from time going forward. We are going to follow a principle and a procedure that is very consistent with how project worksheets from local entities will flow up through the counties to MEMA to then eventually be reimbursed from FEMA at a future date. There are different categories of expenses that are eligible under the federal disaster. Currently, the only thing that has been declared or that it has been granted to the state is what's called public assistance. And public assistance is for local entities for public needs. This does not include any individual assistance to help with homeowners or farmers with issues that they've presented. This is solely for public assistance programs. Within the public assistance framework, there are 5 or 6 categories that are available, and they're known as categories A through, I believe it's E. This bill is only going to be for categories B through F, and I can explain those later to you, but those are the things that are tangible within our counties and within our municipalities that need to be replaced and that they're ongoing. The overall budget for this particular storm, we expect it to be in excess of $400 million. There is no funding that's provided in this bill at this time. That'll come at a later date. But the discussion that's been battered around is that this revolving loan fund would be somewhere in the neighborhood of $50 million. That $50 million would go out to the counties as a prime borrower. Then there would be an opportunity for the counties to administer loans to a secondary borrower, which would be the municipalities. That's very important because, again, that follows the same chain of command and the link of procedure for applying for federal disaster declaration reimbursements. So we are wanting to make sure that the loan program is conforming with how documents will be provided to the counties and to MEMA. DFA will oversee this program. It will not be done through MEMA. And one of the main reasons why is that we need to have an arm's length loan program that does not violate any duplication of benefits that would may cloud either water or slow down any type of eventual reimbursements to the municipality or to the local governments. The way that the loan would be is that the loan would go out to the locals and it would be repaid upon the first dollars of MEMA or of FEMA money that is reimbursed back to the municipalities. We call it a revolving loan fund because even while those loans are going to be pushed out and pushed down to the locals, once they're repaid, they can apply for them again and go right back out. Again, this is a single point of entry. It's the easiest, quickest way that these types of programs can be administered. There will be a lot of additional changes that we will want to do to tweak this, to tighten it up, but the framework that's before you today gives us a very good starting point for us to work with our colleagues in the House. This bill does have a reverse repealer in it, and I know there will be questions. Mr. President, I will yield for any questions.
Okay, Senator Dupree.
Question, Mr. President.
You for a question, sir?
Absolutely.
Please
Yes,
proceed.
Is there a prevailing interest rate that goes along with this?
We didn't say a prevailing interest rate. Our goal here actually is, I believe it's in Section 3, is that rates must be below market level but high enough to cover the state's administrative cost for issuing of the loans, not necessarily a recoupment of it. But we're trying to help benefit the locals and the municipalities in this effort.
Can it be used to match the federal funds?
So this body has already appropriated $20 million to go towards that match program. What this is going to do is not necessarily tied to any app or any worksheet, as you would know it from the county. All it does is push money out and allows for recoupment through whenever the local jurisdiction receives reimbursements for any of their worksheets.
Okay, this is to make sure they keep their receipts and all that kind of thing. I guess it won't be reimbursed.
Absolutely. And MEMA will be working on that, and the DFA contractor will be working on this side.
Thank you, sir.
Senator Norwood.
Question, Mr. President.
Please proceed.
Yes. Thank you. Thank you, President. Thank you, Senator Delano. In the event that, though, the federal dollars are not available to give to the county, how would that be handled?
So we need to have some type of reasonable assurance that there has been a proper assessment of damages that have occurred, and that's going to be done through MEMA and through the county's emergency management agency. They will then submit that information to FEMA ultimately for approval. Again, I pointed out that this is probably going to be a $400 million event. We're talking about, at this point in time, somewhere in the neighborhood of maybe 15 to 20% of those costs. We anticipate that we're not going to get into a situation where, or it'd be highly unlikely for us to get into a situation where a loan would be approved based on the project worksheets that were submitted at that time, and they would not be reimbursed by FEMA at a later date. However, because this is a loan, and it is a loan, and we have to show that it's a loan, there is provisions in I believe it's Section 5, that will require, at the time of the loan being dispersed, that the municipality and or the county would have to pledge some source of revenue for the case in which they did not receive those reimbursements from FEMA.
and they would be equal to or parallel with the money that they would receive. But that, and there again, if the worst case scenario would happen and they do not, if there any provision for forgiveness of that, should they not receive those monies?
Senator, that's a good question. And the way we have this, the terms written right now is that this would be a 5-year loan. There would be an opportunity for rules to be established to set forth parameters by which those rules would be, or those terms could be extended. But if the county or municipality receives notification from FEMA that their project or their worksheet is going to be disallowed, then, and there's monies that are outstanding, everything else has been closed out, the municipality or the county has 2 years to make whole on that. But that also gives the legislature an opportunity to come back and visit that issue at a later time.
And I guess my point is just to make sure that if the county obviously applied for it because there was a need, and if they had the resources to do that, probability could be that they wouldn't. But if worst case come to play, that they do not have the money, put the county into bankruptcy because they can't afford, then are there procedures in place where that we can basically, going through all of the documentation and everything, that we could forgive them for that, working with them to pay it back, and if they just don't have it, they just don't have it.
Senator Norwood, I understand what your concerns are. The way that we address this is to have that 2-year window so that the legislature would have an opportunity to come back and speak to it, because we would be the only ones that would be able to correct that or to provide additional funding for that. However, there has to be skin in the game by the locals on these types of programs, and it has to be a true loan program. So it can't be a grant that we go out, or else we would get tripped up for a duplication of benefits that may preclude the jurisdiction from seeing those reimbursements at a later date.
And I guess I appreciate what you're saying, because obviously you're saying that, I won't say obviously, but I conclude that you're saying that there will be ongoing conversation and negotiation should this come to play, and that you all will come to an amicable conclusion.
Yes, sir.
Thank you, Senator Lano. Thank you, Mr. President.
Senator Barnett, for what purpose?
For a question, Mr. President.
You're here for a question?
Absolutely. You know that.
Senator Barnett, please proceed.
Thank you, Mr. President. Thank you, Senator Lano, for taking my question. Senator Lano, I appreciate your efforts in this, but in Jasper County, about 2 years ago, we had a tornado come through, and I could take you through there now and still show you debris still piled up along the road because we don't have the monies to pay for it. And I understand the intent of this legislation, but my question is similar to what Senator Norwood asked. If they don't have the money, how are they going to put skin in the game if there is no skin to be placed in the game?
Yeah, I completely agree. The skin in the game is the fact that they would only be eligible for these loan proceeds if they were able to demonstrate that they actually make those expenditures up front, that they're requesting reimbursement from MEMA and or FEMA for those expenditures they've already occurred. So what we're trying to do is to push money out as quick as we can to say, we know you've spent a lot of extra money, or you've spent a lot of money on this disaster. We're trying to do our part to say, here's something, a little bit to help to make sure that they have the liquidity necessary to do other and provide other functions of government. I 100% agree with you that there are disasters in the past, there are going to be disasters that are in the future that are going to come in and say, hey, we need something similar to this. And this is a dangerous precedent to set. But ladies and gentlemen, we all hope that this was a generational storm and we don't see stuff like this again.
We know that these are not generational storms because of the frequency that they're happening right now. would you be open to some legislation that's provided to the state, just like we do for our 911 systems, where out of every telephone call, a percentage of that money goes back to the state to help pay for 911 services that we know are vitally important in all of our...
Yes, sir. If you remember when I opened up in this discussion talking about the changes that we're going to see from FEMA, we know that we are going to have to be more prepared as a local state, as well as our local EMA directors, our counties, our municipalities, for future disaster declarations or disaster events. And what you're talking about are some of the tools that we have available to us to find a way to respond to the immediate needs for a response as well as a recovery. To answer your question, yes, there will be an opportunity for us to look at that.
But so my question is, if what we're doing with the Telephone Act that allows a portion of everyone that uses a telephone to help pay for 911 systems so that we can get EMS where they're needed, we can get police where they're needed, we can get all of the emergency service where they're needed because we have 911 service. So my question is, wouldn't it be better if we could pay, if all of the ratepayers that has electricity at their homes could pay a simple $1 fee, and that money could be used in cases like this so that wherever the area is, then we can have cash or we can have monies on hand to be able to help these places that can't, because what we're talking about is a loan. Some people already, even if they qualify, can't pay the loan back. So that may deter a lot of them from even applying for the loan because they can't pay it back. I just think that if we're going to start trying to help ourselves, then I don't think helping ourselves is with the loan. I think we can help ourselves by paying a little bit forward for ourselves. And I don't think a $1, I think if we could consider something like $1 on every home that has power would be sufficient going forward. Has there been any thought or consideration to think about something like this to be put in place so that we can help those counties or municipalities that cannot afford to apply for a grant to get this debris moved, and it doesn't just have to sit there and rot for years and years and years because there's no way to move it?
To answer your question, sir, yes, those are things that are being considered, not necessarily within this loan program, but in the larger conversation of how do we respond to future disaster recovery needs. Yes, sir, there are a lot of things that are on the table.
Is there not any way that we could consider that in this legislation that you're passing?
I don't think that I have the code sections to be able to accomplish that at this second, but Senator, I'll work with you as we move forward with this bill, and obviously this is going to come back to this chamber for further discussion.
Thank you, Mr. President. Thank you, Senator Leno, for taking my question.
Thank you. Senator Jackson.
Introduction out of order, Mr. President.
One moment, please. We'll get to that. Senator Barrett, introduction. One moment. We'll get to yours. Senator Parks, I think you do have a comment on this particular legislation. Senator Parks.
I'd like to speak on the bill or the amendment at the appropriate time.
Please come forward. Okay. Do we get everybody? Senator McClendon? You're good? Okay. Senator Senator Barrett, did you have an introduction? And then we had one other introduction, I think.
Thank you, Mr. President. Ladies and gentlemen of the Senate, if you will help me recognize, we have Lipsey Middle School here today from Brookhaven, Mississippi. Kids, if you guys will stand. These are the Lamplighters student leadership team and the student council. They are hosted today by Principal Misty Sias, Miss Deanna Moak, and Miss Emily Sanders. Thank you guys so much for being here.
Senator Jackson, while we're getting ready here, pass. Okay, you're good. All right, Senator Parks. I'm sorry, Senator Hobson. For what purpose, sir?
Introduction out of order.
Please proceed.
Thank you, Mr. President. It is my pleasure to have my daughter, who has flown in from D.C. to see her dad for Valentine's Day weekend, but I would like y'all to welcome my daughter Jane here to the Capitol today.
Welcome home, Jane. We're glad you're here. Moved back to Mississippi. Okay. Anyone else? Senator McClendon. And then we'll let Senator Parks. I want to give Senator Parks full attention here momentarily. Senator?
Thank you, Mr. President. Introduction.
Please proceed.
Today, Senate, I'd like for you to welcome in the North Gallery and also in the West Gallery, we have from South Haven, Mississippi, Heritage Academy and their entourage there in the West Gallery, and Mr. Andrew Seeley, who is running chaperone for them. Please give them a warm welcome.
Okay. Senator Parks, please pay close attention to Senator Parks on this bill.
First of all, let me say thank you, Senator, for your hard work in the last 36, 48 hours on this bill, and to the Lieutenant Governor who, for the thought and the idea that was the conception that occurred last week and the visit to the North over the weekend. And I say that all as I began to tell you, I'm going to make some comments, some facts right now, and then I'm going to tell you about what occurred during that time. And colleagues, we have work to do so that we're prepared for the next one. So with just a few comments and facts that's occurred, IHL just gave one university $10 million. I want you to remember that fact. What we're asking today is that you're about to share $50 million, that's the proposed figure right now, between 32 counties. Think about that one. Keep that fact in mind. And then I want you to keep this in mind. We have sat in here, and I've been here 14 years, maybe plus, and we have a rainy day fund that is full. And we brag about it, and we boast about it. And we're probably going to add that, we're going to add more to that fund before we leave here this year. Keep that fact in mind. And then I want to tell you about 36 hours of raining ice that occurred. I want you to think about that. And I know coastal folks, you had a little bit of snow last year and you got to get out and play in it and you had a really good time. And you stayed at 32 or a little below. Oh, what was that? 36 hours? And you had a really good time. And we talked about it. And we laughed about it. But I want you to think about 36 hours of raining ice. And then I want you to think about that there was somewhere in the neighborhood of 5 or 6 counties that went 2.5 days without transmission lines being down from TVA. That was historical. That's never supposed to happen. And people, it happened. So we spent 2.5 days with no transmission, no power even coming into us. Okay? Now I want you to think about that. There was no restaurants, no gas stations. My district, there's 2 counties. I had one gas station that sits at the intersection of 72 and 45 that ran on generator. We were able to keep that open for our emergency services only for gas. Now, we prepared because we were told, but have you tried to prepare for propane or diesel or gas for that many hours without a transmission line coming to you? And keep in mind, once you get the transmission lines up, your local power has to go to work then, because they couldn't go to work beforehand. So you had another 6, 12, 24 hours. This is for one half of my district. One half of my district. One county got a transmission line up. So therefore, the first goal was to get our hospital back up. Keep in mind, nursing homes, hospitals, wasn't prepared. Couldn't, how do you prepare for something that's that long? So long story short, I had hospitals, I had nursing homes, 4 days, 4.5 days without power, without water. I had some areas without power, without water, without gas. And I'm going to tell you what those temperatures were like. When we woke, when that power went out at midnight on Saturday night, we were at 24 degrees. On Sunday, we were at 18. On Monday, we were at 20. Now, we've got some tough people in North Mississippi, tough people that lived in those conditions. Our state, I want you to understand, colleagues, we've got a lot of work to do. No one came to help us until Tuesday morning. The troops came in. They came in during the night. But before there was anything, we had people sleeping on floors. We had no cots. We had very few. I think we had 20 or 30. We had people in churches. Our communities came together to feed our people. Outside organizations came in to feed our people before our state. And then our highway, and I'm sure one of my other colleagues is going to speak on that. Our major highways coming into us were shut down. So things trying to come from our capital city or from the south couldn't get to us. This is 2026. This isn't the 1800s, and this isn't the 1900s. Colleagues, we've got a lot of work to do. We seriously do. We were 6 days without ever reaching above 32 degrees. Again, I'll repeat, we've got tough people in the north. We're rocking 19 days today, and we still have constituents with no power. Think about that. Yes, there was Katrina. You were without power many days. We share something. We share a deep something now. I had a colleague when I was first elected. He stood at the well, and he cried and he wept, and he said, "I stood in line to get diapers for my baby." I remember that today. I remember standing before you today, and I hope you remember how my people were cold. And we as a state, we failed them. I'm included. It was hard for me on Mondays and Tuesdays. As you all came back, I went to those meetings, and I had to sit there and go, "It's on the way. It's on the way. It's on the way." And as I walked into those warming shelters, and I had to say, "It's on the way." And I had colleagues from the South, bless their hearts, they got water to some of my people when the state couldn't get water to my people. And I thank them for that. And they know who they are. I mean, people text from all over this state, and I thank them so much because I had areas, again, I'll repeat, no water, no gas, no electricity, nursing homes in the same situation. Can you imagine that? Can you imagine what that smell was and those cries were like by that second day? And those people being with more and more blankets being placed on them just to try to keep them warm? Tough, folks. We have spent several tough days and nights. I know some of you are hesitant about voting for this bill today. I heard the comment from my colleagues, this is conceptual. It is conceptual. But it's a time that we have to think outside of our box and how we're going to try to help bring our communities back to life. Because this is going to be a process, just like Katrina was. It was days, months, and years. When you come to the north, you're going to see that it's going to be days, months, and years before we get back. And how many more weeks are we going to be with people without power? That's the other question we have to ask ourselves, and what can we do to help? I learned more than I want to know. I can tell you that it takes a generator that can provide just a small amount, refrigeration, and maybe one heater. Well, if it's running on propane, it's going to take 25 to 30 pounds of Grell bottle every 4 hours. Now think about how many every 4 hours are in 24. Can you really prepare for that? Those are things that we need to think about and look at as we move forward. And I hope today, as you think about this conceptual bill, as I've heard it commented about, and some of the other comments that have gone, and that the amount of money that we're looking at sharing, and that is, it's still, this is a conceptual number, that maybe that number will grow, but that you'll vote for this bill today, this amendment, that you will, as colleagues, and we will sit down, we will begin to understand how we were affected by this and how we can improve ourselves. Rural water associations, nursing homes, hospitals, AT&T, you have to understand those towers are only, battery power only lasts 2.5, 3 days. When it's gone, it's gone. So let me help you understand, after 3 days, no power. Remember, those transmission lines were still down. Think about, we've all moved to the cell phone. We've all moved to the new age. No internet, no cell service. Those are things that we, as my colleagues of this Senate, under this dome, that's helped leading this state forward, we have to look at how we're going to improve these types of elements that control us and support us every day. Thank you for listening to me. I know it's close to lunchtime, but I needed you all to understand and to hear what it was like in the North, especially for those first 5 to 6 days. Thank you for listening.
Senator Whaley, for what purpose?
Would also like to speak on the bill, please.
Please proceed.
Thank you, Mr. President, and thank you, Senators, for allowing me to come before you. To start off, I would like to thank Senator Delano, Senator Hobson for their work on this. I do very much appreciate it, and I do know that the people of the North Mississippi and the other areas affected, especially the Delta, will also appreciate this. It's hard to follow Senator Parks with her delivery. She's a wonderful orator. She does a good job. I'm not going to be as nice, and I'm probably going to be a little bit more straightforward. That Saturday and Sunday night, all hell was unleashed on North Mississippi. Trees were popping, lines were popping, roads were covered. And you had people that immediately went to work, got up out of bed, and as they were working to clear roads, there were trees falling on top of them, around them, power lines coming down. It was a terrible sight, and it was a terrible thing to be in. I know because I was there. You have different kind of leaders. You have those that will sit and pose in the back of a truck loading a case of water, and then you have those that will actually be out there in the work. I missed an entire week of work here in this body. I felt that it was better served to be with my people back in North Mississippi, to be with my family, than it was to be down here. That was a hard decision for me because I take work very, very seriously. I would like to thank the everyday normal citizens who got up and went to work, who organized and worked while they had nothing to try to find a way to provide for everyone else who had nothing. You heard me right. They had nothing, but yet they still got up and they worked every single day to provide something. I'm thankful for groups like the Cajun Navy Relief, Mercy Chefs, and the work that they do. If you don't know about these groups, you ought to learn a little bit about them. They're great groups. We had a business that completely changed the way they operated, completely shut down their operations, and opened up their building to become a warming center. And they were met with some obstacles at first. Well, you have to have this, and you have to have this, and you have to have this. Well, to heck with all of that. We have a need. We're going to work on it. You tell me what we need, and we'll get that as we go. Over 19,000 hot meals served through that entire process. And a lot of those people were volunteers who didn't have power at their homes, didn't have water at their homes. Heck, for the first 9 days, I looked like a homeless person, and I may as well been. 17 days without power. And I was blessed with the situation that I was in. And you hear that, 17 days without power, and I consider myself to be blessed. I still have people without power. I heard Senator Parks mention that she would go into the meetings and she would tell them, help is coming, help is coming. I heard the same thing, and I didn't really believe them. I was being told help was on the way, and I didn't see anything of help coming. There are a lot of things that have opened my eyes through this entire process. I watched as I live in an area where the district lines of Mississippi Department of Transportation meet, and for some reason that plow truck blade just would not stay on the ground when it got to that district line. It would pick up and have to go a couple of miles and then turn around and come back. Something about that district line, folks, just wouldn't let that plow stay on the ground, and that's a problem. We have a problem. We have a lot of problems to fix. There are a lot of questions that need to be asked and a lot of things that have to be answered. The people back home expect us to do that, and I intend to bring a lot of this out to light. Senator Parks mentioned the nursing homes. It is a terrible thing when you get a phone call from that person whose mother or father is in that nursing home and is squalling because they're cold. Local nursing home, it was around 30 degrees inside. Those people were freezing to death. No help to be found. That's a problem. And it should not happen anywhere in this state alone. I would like to thank the linemen who have gotten up and gotten out and went to work. And they have restored power all across this state and are doing a great job. And I know people back home are frustrated because they haven't gotten to them yet. But one thing I can tell you, I promise you, they are coming. They will go to work. To each and every one of my colleagues, as you consider voting on this bill today, ask yourself, how do you see your constituents back home in this situation? And where do you see yourself? Are you going to be that elected official taking the picture, loading the case of water, or are you going to get out and go to work? Well, I'm going to get out and go to work continuously, and I'm going to support this bill. Thank you.
Senator Delano.
Motion be to adopt the amendment.
All in favor signify by saying aye. Aye. Opposed, no. The ayes have it, Senator.
Before we go to the vote, I just want to let everyone in this chamber know that we appreciate the goodwill of everyone across the state that reaches out to our fellow Mississippians in times of need. We're going to have a lot of discussion over the next year on how we prepare better for these types of events. I want to say thank you, and I look forward to working with each and every one of you. Motion, Mr. Speaker, I believe that
you were doing so well.
Mr. President, I'd move to adopt the committee's adopt the bill on use of final
morning roll call. Morning
roll call is what I'm trying to think of. Use of the morning roll call has been requested.
Anyone object to that procedure? Wish to be recorded as voting no. Seeing none, the bill passes by use of the morning roll call. Thank you, Senator Delano. Senator McCon. I'm sorry, Senator Hill.
Introduction out of order.
Please do that, Senator McCon, if you prepare.
Thank you, Mr. President. In the West Gallery and the South Gallery, we have Poplarville High School and Middle School choirs from Poplarville, Mississippi in Pearl River County, and their teacher, Andrea Will. These are 6th through 12th graders. Please stand and let us all make you welcome. And you sounded wonderfully in the rotunda. So glad to have y'all here.
Okay, Senator Whaley.
I'd like to ask unanimous consent to be added as co-author to the prior bill.
Seeing no objection, granted. Seeing no objection, Senator Parks and everyone else here will be unanimously added to the bill. Thank you all. Thank you, Senator Parks. Okay. We've got a heavy load here. What we'll do here, I'll recognize him. We'll have a shortened lunch so that we can meet the deadline today. So I'll recognize Senator Blackwell, and I do appreciate so much the work that was done by Senator Parks and Senator Whaley and so many other senators in North Mississippi, Senator Boyd, Senator Chisholm, so many of you. Thank you all. Senator Jackson, all of you. All right, Senator.
Thank you, Mr. President. Immediately upon recess, we will have page pictures. So if you're a senator with a page, please go up to the dais. Motion is that the Senate stand in recess until 1 p.m. today.
Till 1 p.m., all in favor, signify. Senator McConn, you pass. Thank you. Senator DeBar. Pass and retain. Senator Thompson. Senator Thompson is recognized. We're on 18, Senate.
Thank you, Mr. President. I ask that we go to item number 18, called up and have the title read.
Mr. Clerk, please read the title.
445 DMH required to promulgate performance standards and perform periodic audits to assess community mental health centers.
Make the usual motions.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed.
Ask that Senator Boyd be recognized to explain.
Senator Boyd, you recognize.
The committee substitute.
Senator, please proceed.
Thank you, Mr. President. The bill you have before you is a bill that is to expand the state oversight and accountability framework for the community mental health centers. The bill is being requested by the Department of Mental Health. This is very similar to a bill that has passed this chamber both last year and the year before. What it does is it allows the Department of Mental Health to develop and promulgate a rating scale with performance standards that would be used in a formal performance audits for each of the community mental health centers. The community mental health centers receive about $60 million in state appropriation from us each year. About $9 million also comes from comes from counties in their area. What it does is that it mandates that they begin to conduct these performance audits in the fiscal year of 2028. They would have to go a performance audit every 2 years. If they failed to achieve a passing audit score, they would enter into a probationary period. Failure to achieve compliance after that would replace the Senate's executive leadership and officers identified with, in the audit with the contractors. And they would be working with the Department of Mental Health to make sure that those entities get into compliance. The Department of Mental Health testified at the hearing. They want to make sure they have no interest whatsoever in taking over the running of the community mental health centers. They want these community mental health centers to be operational and efficient. And that's what they'd like to do. But right now, there's really no way for them to step in to help them with an audit or anything like that until they fail. And so they'd like to step in a proactive way to really do this process. So that's an explanation of the bill, and I'm happy to answer any questions.
Thank you, Senator. Senator Turner Ford, for what purpose, ma'am?
Question.
Were you here for a question, ma'am?
Yes.
Senator Turner Ford is recognized for a question on this bill.
Thank you, Mr. President. Thank you, Madam Chair. As it stands currently, is there any type of appeal process in this bill for the community mental health centers?
So as at committee, they told us that they have within their administrative rules and procedures, they already have an appeal process that's articulated in their rules and procedures already promulgated. And so it was their intention that community mental health centers would use those already promulgated rules and procedures to be able to appeal anything that would go then before their board.
But would you also understand that community mental health centers may feel more assured if the appeals process is actually codified in this legislation?
Yes, ma'am, and I think you have an amendment on that, and that is a friendly amendment.
I do, thank you, and I just request to be recognized to offer my amendment at the appropriate time.
Thank you, Senator. If you'd bring that to the front, Senator Norwood.
Thank you, Mr. President. Question.
You for a question, Senator? Senator Norwood's recognized.
Okay, thank you, Mr. President. Senator Boyd, the monies that they receive is federal dollars that they receive that come to the state, then the state would grant the money to them. Now they have federal restrictions, they have federal requirements, so whatever they put together would encompass those and would not be any, no conflicts with that.
No, sir, there's no conflicts with this. And in fact, the court monitor, they were in litigation. That litigation was subsequently dismissed, but the court monitor actually helped develop some of the procedures that they would be intending to use and what they would be intending to do. So that's one of the aspects of this, that they have already, because we've had this legislation a number of years, they've already looked at that issue, and this would not be in conflict.
Now, currently, do they have a procedural manual, more or less, that would be provided to the subgrantees that would give them the directions as to what they should be doing and how they should be doing that?
Yes, sir, I believe so.
Okay.
I don't know if it's a manual per se, but they do have lots of procedures on how, but I don't know if it's a book or on the computer.
Well, I guess what I'm saying is that the subgrantees would know what it is that they
absolutely
that they're scheduled, because if they're haphazardly preparing them, then when they go out, it's going to be haphazardly done.
Absolutely. Senator Norwood, as the department testified before us, there is no desire on anybody's part to play the gotcha game. This is simply something so that they can step in if a community mental health center is in chance of failing before they actually fail. And we've had a number of community mental health centers. We have some absolutely fantastic ones, and that is the vast majority. But we have had through the years some that have struggled. And so this simply gives the department the opportunity to go in there immediately and really look at them and help them constructively get back on track.
And I know if there are challenges, certainly there will be times that there will be afforded a time and technical assistance to resolve whatever challenge they may have.
Absolutely.
Now, is that written out, or is that something that will be developed?
Yes, it would definitely, because there would be a formal audit. You would have, definitely writing. They would have to be meeting with them and working with them on that. So really, kind of describe this as a very hand-holding process to get them back on track. But the Department of Mental Health does not want to operate a community mental health center.
Thank you, Mr. President.
Thank you, Senator Norwood. We're on the committee substitute. I think we have to adopt the committee substitute, ma'am, and then we'll have an amendment.
Move to adopt the committee sub.
All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Senator Turner Ford is recognized for an amendment on the committee substitute.
Thank you, Mr. President. Thank you, ladies and gentlemen of the Senate. What I have proposed is an amendment for Senate Bill 2445, which generally can be described as the due process amendment. As it stands currently, if the State Board of Mental Health attempts to or wants to replace or remove the executive director, there is no recourse for the community mental health centers. And so what is proposed here is that written notice of the intent to replace the executive director to the community mental health center must be provided to the executive director and the regional commission. The decision to replace the executive director with a contractor shall constitute an appealable action. The Community Mental Health Center's Board of Commissioners may submit a written request for appeal to the State Board of Mental Health within 14 days of the receipt of notice of their intent. And the State Board of Mental Health shall conduct a hearing within 90 days of receipt of the request for an appeal and shall issue a ruling within 30 days of the hearing. And the replacement shall occur only after a final decision of the State Board of Mental Health following an appeal. And the contractors who are placed, if the executive director is replaced, those contractors cannot expend funds without the approval of the Community Mental Health Center's Board of Commissioners. Also, lastly, they shall provide monthly progress reports to the board during the period of engagement. I will yield for questions. If there are none, I move adoption of the amendment.
Senator Norwood, for what purpose?
Question, Mr. President. Question, Mr.
Are
President.
you here for a question, ma'am?
I do.
Senator Norwood's recognized.
Thank you, Mr. President. Thank you, Senator Turner. Now, the community health centers, do they have boards themselves?
They do.
So what is the role? But you say that if the Department of Mental Health, what role would the board play in this decision? Does the board have a role?
Well, the board, State Board of Mental Health, would be acting, I guess, as the reviewer of the audits. And if there's an intent to remove the executive director based on audit findings, then the board would have the right to appeal.
The state board or the
commissioners, Board of Commissioners.
The Community Health Board?
Yes.
Okay. Thank you, Mr. President.
Thank you, Senator Norwood. Any other questions? We're on the amendment. Senator Boyd, you recognize to speak on the amendment?
This is a friendly amendment.
Ready for your motion, Senator?
Move adoption.
All in favor signify by saying aye. Aye. Opposed, no. The ayes have it. Thank you, Senator Turner Ford. Senator Boyd, you're recognized. We're on the final final statute.
If there's no further questions.
Seeing none. Oh, I'm sorry, we have one. And your name, sir? Senator Bryan.
Mr. President, I would like to speak on the bill.
Please come to the front. Senator Bryan, speak on the bill. Anyone else? Okay, Senator Bryan's recognized to speak on the bill.
Mr. President, this is a very far-reaching bill, and I would suggest to members they would be well served to look at the clear text of the bill rather than relying on the explanation that was given. A community mental health center is an organization of a group of counties. Every county in the state is a member of one community mental health center. The community mental health center is governed by a board appointed by the boards of supervisors in your counties back home. What this bill would do would be to authorize the Department of Mental Health in Jackson to fire the executive director that was hired by your local board members and basically take over or dissolve the community mental health center and privatize everything. There's much been said about this appeal process. The only appeal that's in this is an appeal to the Department of Mental Health. I wonder how we would react if the Board of Community and Junior Colleges came before us with a piece of legislation which would allow them to take over your local junior college and fire the junior college president. That's essentially what this does. The Department of Mental Health, which is so anxious to exercise this authority, is very prickly about any oversight of their operations. But I would mention just a couple of things that have occurred in the past that I think we should bear in mind before we put the Department of Mental Health in charge of overseeing and destroying and abolishing the community mental health districts in the state. A number of years ago, there was some money provided through ARPA or whatever it was at the time. It's hard for me to keep it all straight, for computers. Some of that money was allocated to the Department of Mental Health to get computers. And I will just say, very broadly speaking, we need data to make decisions. We need data across agencies in lots of places, and we need to get that data so that we can know what's going on around the state and use that to make decisions. The computer system between the local community mental health centers and the department has been a problem for some time, but nevertheless, for some reason, and I don't know all the ins and outs, the computer system was never purchased with this money. Time ran out, and the money was paid back into the pool to go elsewhere, and there's no good computer system. It's also the case that the Conservator of Mental Health, an entity not directly controlled by the Department of Mental Health, provided us some time back with data that had been collected from the community mental health centers about what services were being performed and to how many people. The data was meaningless, and I could get you a copy of it, but as you go from one community mental health center to another, the figures just show that there's nothing being entered into this system properly or consistently. Nevertheless, the Department of Mental Health apparently didn't look at this information, which should have been one of the beginning points to see what's going on with mental health around the state. I would suggest to you that your people back home will not be happy with this legislation, and I would suggest to you also that in the overall scheme of things, some people may have been reluctant to speak out about their true feelings on this piece of legislation for fear of retaliation. I just think the concept, and again, I learned about this bill when I see that it's on the Senate calendar. I don't think it's a good proposition, and I intend to vote no, and I think that would be a good vote for others.
Senator Boyd, you're recognized to speak on the bill.
This is a process that is very similar to when a school district is failing, except what we've done is we have put the process in place when a community mental health center is not operating as it should be. We've put these audits to check it in and make sure that we don't have them fail, that we put the steps in place to do this. This has been a bill that has been before us a number of years that we've passed this out. It's not a surprise bill, but it is a bill that really makes sure that our community mental health centers, who serve our most vulnerable in the state with mental health issues, are given that expertise. My community mental health center is very in support of this legislation. Many community mental health centers are in support of this legislation. The board is very in support of this legislation because they know it is incredibly important across this state that we have strong community mental health centers in every district. So on that, I will, Mr. President, I'll ask that I move that the bill be passed by the use of the morning roll call.
Use of morning roll call has been requested. Do you object, Senator Bryan? Please call the roll.
Barnett. Barrett. Berry. Blackman. Blackwell. Blunt. Boyd. Brumfield. Bryan. Butler. Carter. Chazanall. Chisholm. DeBar. Delano. Dupree. England. Fillingane. Frazier. Gillespie Isom. Harkins. Hartness. Hickman. Hill. Hobson. Jackson. Johnson. Kirby. Ladner. McCon. McClendon. McMahon. Michelle. Mumford. Norwood. Parks. Pope. Rhodes. Seymour. Simmons of the 12th. Simmons of the 13th. Sparks. Suber. Tate. Taylor. Thomas. Thompson. Turner Ford. Whaley. Wiggins. Williams. Younger. Barrett. Berry. Butler. Chazanall. McMahon. Pope. Rhodes. Simmons of the 12th. Suber. Voting yes or yay. Barrett. Blackwell. Boyd. Carter. Chisholm. DeBar. Delano. Dupree. England. Fillingane. Harkins. Hartness. Hill. Kirby. Ladner. McCon. McMahon. Michelle. Parks. Rhodes. Seymour. Sparks. Suber. Tate. Taylor. Thompson. Whaley. Wiggins. Williams. Younger. Voting no or nay. Barnett. Blackman. Blunt. Brumfield. Bryan. Frazier. Gillespie Isom. Hickman. Hobson. Jackson. Johnson. McClendon. Mumford. Norwood. Pope. Simmons of the 12th. Simmons of the 13th. Thomas. And Turner Ford.
Senator Johnson, pass and retain? I'm going to call a vote. I'm just checking, going down the calendar while y'all are counting. Senator DeBar? Pass and retain.
30 to 19, number.
Senator Barnett. Pass and retain, sir. I'm just trying to get the next guy to come up on 22, sir. All right, we'll call the vote here. Senator Barnett, if you come up to the well so we can keep moving. $30 to 19, the bill passes. So to confirm then, Senator Johnson pass and retain, Senator Barr pass and retain. We're on Senator Barnett 22. Pass and retain. Senator Fillingane. Senator Fillingane. We're on 23, Senate.
I'd like to go to that item called up and have the title read.
Mr. Clerk, please read the title.
23.
Yes, sir. 23, sir.
Senate Bill 2710, juvenile crime amend provisions related to.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Questions for you.
And now we go to the committee substitute, Mr. President.
You're recognized to explain the committee substitute, sir.
Thank you, Mr. President. I do have a strike-all amendment for the committee substitute, so I'll explain that with your permission. Senate Bill 2710 seeks to address the problem of gang violence and juvenile crime that we're experiencing, of course, nationwide, but also here in Mississippi. Section 1 of the bill, with the adoption of the strike-all amendment, amends Section 4321-151 to place a number of acts committed by a minor within the original jurisdiction of the circuit court. Under this strike-all that I'm presenting before the body, any act attempted or committed by a child which is a crime of violence pursuant to 9732 while in possession, openly or concealed, of any gun, rifle, pistol, or other firearm of any kind would be in the original jurisdiction of the circuit court. Secondly, any act attempted or committed by a child which is a violation of Section 9737-17, which is act with a firearm committed on educational property, and which would be a felony if committed by an adult there, would also be in the original jurisdiction of the circuit court. And finally, any act attempted or committed by a child which would be a felony if committed by an adult while in possession, openly or concealed, of a stolen firearm would also be in the original jurisdiction of the circuit court. So that's the first section of the bill, Section 1. The second section, number 2 of the bill, amends Section 9737-35 to revise the penalties for the crime of the sale, delivery, or transfer of a stolen firearm in certain circumstances. So, for instance, for the conviction where the sale, delivery, or transfer of the stolen firearm or an attempt to sell, deliver to a person under the age of 18 years of age, the offense shall be punishable by a commitment to MDOC of not less than 10 years nor more than 20 years. Or if the firearm that was then transferred was used in a violent crime that was listed in Section 9732, the offense would then be punishable by a commitment to MDOC of not less than 10 nor more than 30 years in Mississippi Department of Corrections. And finally, if that stolen firearm was subsequently, not stolen necessarily, but the firearm that was transferred, the stolen one, to the minor was used in these following crimes: if it was an attempted murder, murder or capital murder, or child homicide, the offense would be punishable by not less than 10 years nor more than 40 years. The current punishment for those crimes starts at 5 years. So that would be the change there. In this strike-all amendment, we do restore the existing law concerning the penalty for any person who commits or attempts to commit another crime while in simple possession of the stolen firearm. In the original bill, that penalty was going to be increased, but after talking with some of the committee members and the DA's office and prosecutors, they feel comfortable leaving that where it currently is, which is the 5 years. And finally, the Section 3 of the bill creates a felony crime of shooting or discharging a firearm into an assembly or group of two or more people. This offense is punishable by a term of imprisonment of not less than 5 years, no more than 15 years, and a fine of not to exceed $10,000. Now, where that shooting is into an assembly or group at certain locations, and I'll list those for you: a church, synagogue, temple, or other established place of worship, courthouse, school, playground, or park, then the penalty would be enhanced from 5 years to not more than 20 years. And then finally, if anyone in the assembly or group is a child or under 18, that penalty is enhanced further to a term of imprisonment not less than 5, no more than 30 years, and a fine, again, not to exceed the $20,000. Finally, if the offender who's shooting into the group is a street gang member, or those identified as such in Section 9744(3), or a member of a terrorist organization, then the penalty is further enhanced to a term of imprisonment not less than 10 years, nor more than 30 years, and a fine not to exceed $20,000. So that is the explanation of the strike-all amendment to the committee substitute. I'm happy to answer any questions or move for adoption of the strike-all amendment. Okay. I move to adoption of the committee substitute.
All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Okay, Senator, we're on the bill.
Move adoption of the strike-all amendment.
All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Now we're ready.
Any questions?
Seeing none, Senator, ready.
Move adoption by use of the morning roll call.
Use of the morning roll call been requested. Anyone object to the procedure? Don't be raising your hand. You already did that once. Okay, the bill passes by use of, oh, I'm sorry. Oh, you want to vote? No. I got you. I'm voting a no. Fraser, no. Dupree, no. Mumford, no. Simmons D, no. Thomas, no. Simmons S, no. Jackson, no. Pope, no. Blackman, no. Brumfield, no. Butler, no. Turner Ford, no. Hickman, no. No Blunt. No Isom. No Bryant. No Norwood. Barnett, no. Anyone else? Anyone else? Okay, the bill passes by use of the morning roll call. Noes noted. We go to Senator Blackwell.
Thank you, Mr. President. I'd like to go to item number 24, Senate Bill 2708, and ask the title be read.
Mr. Clerk, please read the title.
Senate Bill 2708, postmortem depression, create new laws and revise existing provisions related to.
Make the usual motion.
Your motion, all in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed, Senator.
Request that you let Senator Boyd
Senator Boyd, you're
explain the
recognized.
committee substitute.
This bill is pretty simple, straightforward to you. This is something that came out of the Women, Children, and Families actually several years ago. And we had it last year and it failed on the House for some other additional reasons. But this bill, all it simply does is it makes postpartum depression screening a requirement from all of our managed care. All of them are doing it right now, but this just codifies it into statute, and we want to make sure that it stays into statute. So they have to provide postpartum depression screening as part of women's health care. That's an explanation of the bill. I also have an amendment at the appropriate time. Mr. President, I move to adopt the committee sub.
All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it.
Okay. There's a simple, we're making some edits in the committee and we forgot to strike a portion of it that we are not doing that particular portion in this bill. So this is really just a drafting technicality, and it is to strike lines 105 through 118. So that is the amendment. If there's any questions on the amendment, I would be happy to take that at this time.
Senator McClendon?
Question on the bill.
Okay. We'll come back on the amendment first.
Okay, if there's no further questions, I move that we adopt the amendment.
All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it, Senator. Now we're on the bill. Senator McClendon, you're recognized for what purpose, sir?
Question, please.
Senator Boyd, will you yield for a question?
I will.
Senator, you're recognized.
Thank you, Mr. President. Thank you, Senator Boyd. Senator, does this include live births or stillbirths?
Senator, this would be for any postpartum depression screening. So it would include live births and stillbirths. It would be a requirement from our managed care.
Would that also include stillbirths where cesarean had to be performed?
I believe it would, Senator.
We're sure or pretty sure?
I'm 99.5% sure, but I will check on that. My nurse expert up here says it absolutely would include that.
If not, could we fix that as this goes on?
I'm almost 100% positive it already covers it. I'm like 99.5, but I will check on that.
Thank you, ma'am.
Okay. Thank you.
Okay, Senator, I see no other questions.
Move that we adopt by the use of the morning roll call the bill as amended.
Senator Black.
Introduction.
Okay, 1 second. Use of the morning roll call has been requested. Does anyone object to the procedure? Voting, voting no. President, the bill passes by use of the morning roll call. Senator Blackwell, you recognize.
Thank you, Mr. President. On behalf of the DeSoto delegation, ask the Senate to take a look in the North and the West Gallery and welcome DeSoto leadership to their capital.
Glad to have you with us. Thank you for taking the time to join us. You joined us on a very busy day. Senator Barrett.
Thank you, Mr. President. I'd like to go to item 25 on today's calendar and ask the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2408, the Mississippi Soil and Water Conservation Commission authorized levy system.
Make the usual motion.
Usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it. Senator.
Mr. President, I would like Senator Hobson to be recognized.
Senator Hobson is recognized to explain the bill.
Thank you, Mr. President. Thank you, Mr. Chairman. This bill authorizes the Soil and Water Conservation Commission to complete a levee that's in Yazoo County. This levee has been partially done to the north and the south, and there's open spots. This is partly in my district, partly in Senator Thomas's district, and the federal government has sent $100 million to complete this levee. The Soil and Water Conservation Commission just needs the authority to be able to begin the work to build this levee. So this gives them that authority. I'll yield for questions if there are any.
Okay, seeing no questions, Senator.
I suggest passage by use of the morning roll call.
Use of the morning roll call has been requested. Anyone object? Should be recorded as voting no. Present. Seeing none, thank you, Senator Hobson, for your work on that. It's very important. Okay. Senator England. Senator England.
Mr. President, I'd like to ask that we skip item number 26 on today's calendar, have it moved to the heel of the calendar.
Move to the heel of the calendar. Senator Wiggins. Senator Sparks. Senator Sparks, 28, sir.
Thank you, Mr. President. I'd like to go to number 28 and have that bill called up and the title read.
Mr. Clerk, please read the title.
Senate Bill 2417, State Employee Telework Policies Amend.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed.
Mr. President, I'd like to be recognized to explain the bill.
You're recognized.
Senate Bill 2417 is a bill we've passed the last couple of years that addresses remote work, and this makes sure that the State Personnel Board is involved in setting policies. It makes exceptions for people whose job is required to be outside of the office, actually in remote situations. Otherwise, at least 3 days out of the week they need to be in the office, and also an exception for Americans with Disabilities Act or any other federal or state law. That is a brief explanation of what the bill does. It extends a repealer was what we did last year, and when this bill died in conference, some of these code sections actually repealed. So I have an amendment at the appropriate time, Mr. President, if there are no questions on the basic bill. Have an amendment at the appropriate time.
Okay, sir.
The amendment should be on the screen, which simply reenacts the code sections that were repealed, and also adds a reverse repealer to make sure we've got all this squared away. That's an explanation of the amendment, Mr. President. I'd yield any questions.
Questions? Seeing none, Senator, we're ready.
If there are no questions, I would move for adoption of the amendment.
All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed.
If there are no questions on the bill, I'd move for passage on the morning roll call.
Use of morning roll call has been requested. Anyone object? Wish to be recorded as voting no. Present. Seeing none, the bill passes. Senator, 29.
I'd like to go to item 29, have the bill called up.
Mr. Clerk, please read the title.
Senate Bill 2419, Office of Workforce Development authorized to implement and oversee an employee child care tuition assistance program.
Senator makes the usual motion.
Use your motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed, Senator.
I would like to recognize Senator Boyd to explain the bill.
Senator Boyd, you're recognized.
Thank you. This bill is really simple. It's 2 lines, and all it does is it allows the Office of Workforce Development, if funds become available, to implement and oversee an employee child care assistance partnership program. It's a program that they're particularly looking at that would have, it's kind of a tri-share model, and it would look at employers, employees, and possible funding from another source. So that's what they're looking at. That's an explanation of the bill, and I'm happy to answer any questions.
Questions? Senator Hill, for what purpose, ma'am?
Question.
You for a question, Senator?
Yes.
Senator Hill's recognized.
So where are they going to get the funds from?
They have and this is a program that the governor's office has requested. They have requested an appropriation in regards to this, and so that there's a number of states that have operated a tri-share model is what they're calling it. They've operated it in Kentucky and a number of other places, and it's been very effective at getting employers, employees, and then the state has chipped in a nominal portion to make that happen.
Thank you.
Senator Seymour, for what purpose, sir?
Question, Mr. President.
You yield, Senator?
Yes.
Thank you, Mr. Chairman. Is there any representation on this board from our CTE school systems?
Yeah, so this is the Accelerate Workforce Board. This is Accelerate. So
Okay.
as you know, this is huge number.
I'm sorry.
Yes.
Thank you.
Thank you, Senator Seymour. Anyone else? Seeing none. Senator?
Mr. President, I ask that we adopt this bill by the use of the morning roll call.
Use of the morning roll call has been requested. Anyone object? Wish to be recorded as voting no. Hill, no. Hartness, no. Chisholm, no. Rhodes, No. Seymour? No. Anyone else? Anyone else? Seeing none, the bill passes by use of the morning roll call. 5 noes noted. Item 30, Senator.
Thank you, Mr. President. I'd like to go to item number 30, have the bill called up and title read.
Mr. Clerk, please read the title.
Senate Bill 2671, maximum compensation for certain public officers and employees, bringing forward code section concerning.
Senator makes the usual motion.
Usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it.
Be asked to recognize to explain the bill.
You recognize.
Thank you, Mr. President. Senate Bill 2671 is bringing forward the code sections that address compensation based on caps that we have in our system, based on the discussion we had yesterday, looking at potentially attorneys in the AG's office and others that have disparity because there's a cap based on the governor's salary. So this is simply bringing this code section forward for possible amendment. That is an explanation of the bill, and I would yield to any questions.
Questions on the bill? Senator McClendon. For what purpose, sir?
Question, please.
Were you here for a question, Senator?
I yield.
Please proceed, Senator McClendon.
This is strictly statewide offices, no local?
This bill is brought forward. In no way am I trying to change anybody's statewide salary. This is for state employees. It's not local. That is correct, to answer your question. This is for state employees who are capped based on a statewide official salary.
Thanks, sir.
Thank you. If there are no other questions, I'd move for adoption on the morning roll call.
Use of morning roll call been requested. Anyone object? Wish to be recorded as voting no. Present? Seeing none, bill passes by use of morning roll call. Thank you, Senator. 31.
Go to number 31, have the title called up.
Mr. Clerk, please read the title.
Senate Bill 2672, Mississippi Department of Information Technology Service, bring forward code sections.
Make the usual motion.
Usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed.
Thank you, Mr. President. Senate Bill 2672 is also code sections only. This is Information Technology Services. We're bringing those forward for possible amendment based on some changes in the law that we're seeing at the federal level and working with our friends at Accelerate Mississippi in the workforce sphere. So no changes, just bringing forward the code sections. I'd yield to questions.
Seeing none, Senator, we're on you.
Move for passage on the morning roll call.
Morning roll call has been requested. Anyone object? Court is voting no. Harkness, no. Chisholm, no. Anyone else? Anyone else? Anyone else? Seeing none, the bill passes by use of the morning roll call. Harkness and Chisholm voting no. 32, Senator.
Thank you, Mr. President. I'd like to go to that item, have the title called up and the title read.
Mr. Clerk, please read the title.
Senate Bill 2678, duration of weekly unemployment benefits, prescribed method of determining.
Make the usual motion.
Usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed, Senator.
I'd like to recognize Senator Taylor for
Senator Taylor, you're
explaining the-
recognized.
Thank you, Mr. President. Thank you, Mr. Chairman. This bill is a workforce development bill that aligns our unemployment policies with those set with our neighboring states. This bill encourages people to get back to work as soon as possible in regions where there are already available job opportunities. This bill does have a reverse repealer in it, and after discussion in committee, working with Senator Dupree to add an amendment to relate the addressing regional unemployment rates. I ask that you vote for this and keep this bill moving. And, Mr. President, at the appropriate time, I have an amendment.
I don't have an amendment.
Okay, Senator. One moment, please. Okay, it's up. You're ready to go, Senator.
What this amendment do, in discussion in committee, this will provide that this bill will be upon the regions of the unemployment rate in the state. So I move that we adopt the amendment.
Questions on the amendment? Seeing none, all in favor signify by saying aye. Opposed, no. The ayes have it, Senator.
Mr. President, this also has the reverse repealer in it, and I move for passage by morning roll call.
Use of morning roll call been requested. Anyone object? Voting no. Present. Seeing none, the bill passes by use of morning roll call. Senator Delano. One moment, please. Pass and retain. Senator Delano. Senator Barnett. Pass and retain. Oh, let me see here. I'm sorry, I missed Senator Younger. I'm sorry, I skipped over. 34, Senator Younger.
Thank you, Mr. President. Please call up item number 34 and have the title read.
Mr. Clerk, please read the title.
Senate Bill 2614, radar authorized sheriffs to use based on population and prohibit speed traps.
Make the usual motion.
Usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it. Please proceed.
I yield to Senator Thompson to explain the bill.
We have a committee substitute, I think, Senator.
Mr. President, we have a committee sub. I'd like to have that called up and be recognized to explain.
You're recognized to explain the committee substitute.
Thank you, Mr. President. Ladies and gentlemen, Senate Bill 2614 authorizes limited use of radar by sheriffs on county roads. There's been a lot of discussion about the bill. There's been a lot of discussion about the bill here the past couple of weeks. I know that you've gotten some emails, or likely have gotten some emails and some telephone calls from some folks who support the bill. I want to take the time to go through the bill and explain it section by section. Section 1, starting on line 43, it authorizes the sheriff and sheriff's deputies to operate radar subject to specific limitations, such as beginning on line 46, it must be 1,000 feet outside of municipal limits. On line 48, unanimous approval by the County Board of Supervisors before the sheriff can be authorized to operate radar. On line 50, the use of the radar by the sheriff must be prioritized to areas where they have reoccurring crashes or fatalities that are speed related. This next part is pretty significant. It is the number of radar units per county is limited by population, beginning with 50,000, then 70, then 90, then 110, and then counties with more than 110,000 people. What this means is in 66 counties in Mississippi will be limited to one radar device per county. 6 counties will have 2 units per county if their Board of Supervisors votes for it. 3 counties would have 3 units, 1 county would have 4 units, and 5 counties would have 5 units per county. If this bill were to be enacted statewide, you're talking about 116 additional radar speed detection units in the state. I believe that pages are passing around a map of the counties that would be affected by this, and it's on your screen there. You can see most parts of the state would only have 1 radar speed detection unit per county. Lines 72 to 96 defines speed trap. Important to note that this speed trap definition and the unlawfulness of a law enforcement agency setting up a speed trap would apply not only to county sheriffs, but also to police and highway patrol. It makes it unlawful for any law enforcement agency to operate radar in a speed trap. And lastly, in section 2 of the bill, beginning on line 101, all assessments for county sheriff radar would be deposited into a fund for the Mississippi Department of Education Driver's Education Program. That is a brief explanation of the bill. Mr. President, I yield to any questions.
Okay, thank you, Senator. We have several here. Senator Tate, for what purpose, sir?
Question.
You for a question?
Of course.
Senator Tate's recognized.
So I understand inside municipalities where radar is already in use that the deputy sheriff cannot use the radar inside the municipality. Is that correct?
The sheriff's use of the radar is limited to county roads.
So it cannot be inside a municipality. Can it be inside a municipality that does not have radar, like the town's too small?
It's limited to county roads, not municipal highway, and it has to be at least 1,000 feet outside of the municipal limits.
Any municipality?
Any municipality.
That's it. Thank you, boss.
Thank you, Senator. Senator Seymour, for what purpose, sir?
question, Mr.
You
President.
for a question, sir? Of course. Senator Seymour.
In the counties where you're showing the yellow, is the population, is there a deduction as far as the municipalities that already have municipal radar being shot? Are you adding that on top as the gross population?
We looked at trying to set the population parameters by unincorporated areas of the county. It got very cumbersome when you start trying to back out incorporated areas of the counties and try to set those sort of parameters. So no, these are strictly based on county population, regardless of whether the municipalities within that county have radar.
So they will be able to shoot radar in the municipalities also?
No, not the county shooting radar inside. The county sheriff would be limited to radar only on county roads. I maybe misunderstood your question. If there is a municipality inside of the county that by statute, by current statute, is authorized to operate radar within that municipality, we didn't take that out of the bill or out of the population requirements. The population requirements in this bill are based on the county population, regardless of the municipality. But even then, the county sheriff's operation of radar is limited to county roads.
Will there be pretty much like a local and private sent to us by the Board of Supervisors of the county that's wanting this radar, or we're implementing it?
What you're doing
to
in
the
this
state?
bill, what this bill does is authorize the Board of Supervisors by unanimous vote to authorize their sheriff to operate radar. If you've got one supervisor out of 5 that doesn't want the county that sheriff to have radar, that sheriff would not be authorized to operate radar in that county.
Well, Mr. Chairman, I would ask that the counties that have a municipal radar system in place, that somehow we come up with a number to where it's justifiable throughout the state at the same quota.
I'm not sure I understand the question.
If you have the whole Gulf Coast that has radar being shot,
okay,
that is in the rural area, that should be the population number that you're going by, or an average.
We looked at trying to back those incorporated, the population that resides in the incorporated areas out, and it got very, very cumbersome to try to do that practically. And so we just stuck with county population. And again, we're talking about 50,000, a county with a population of 50,000 or less has one radar unit. So we're not talking about, even if this was fully implemented statewide, we're not talking about a great number of radar units being operated by the sheriffs.
Thank you, Mr. Chairman.
Thank you.
Okay, thank you very much, Senator Seymour. Senator Dupree. For what purpose, sir?
A question, Mr. President.
You for a question, sir?
Of course.
Senator Dupree is recognized for a question on this bill.
Senator, it seems that I've been supporting this for counties for about 30 years. They've been trying to do this because everybody else seems to have it. But one of the things I always come to is jurisdiction, because I think that's what you were talking about, was jurisdiction. And so this is, you've identified that it's outside the city's 1,000
1,000 feet outside the municipal limits, yes, sir.
So what about highway, the highway patrol?
This
highways system.
This would only authorize the sheriffs to operate radar on county roads. It would not authorize them to operate radar on interstate highways.
Okay, so again, that clears up the jurisdictional problem that some people seem to have, that it's only those county roads that the sheriff has jurisdiction over.
That's correct, Senator.
And not highways that the highway patrol, and not municipalities that the chief of police have control over.
That's correct, Senator.
So I think that should clear that up for everybody. Also, it also allows them to be on par with all the other police departments or highway patrol. I think it's the only organization that doesn't have use of radar.
That's correct, Senator. And I missed out on my preamble in my presentation of the bill, but this is a public safety bill. This is to address, or an effort to address, a very real and significant problem in the state of Mississippi. Currently, we have the highest traffic fatality rate per capita in the country. We've got, we're also one of only 2 states that doesn't allow our sheriffs to run radar. All this bill is doing is trying to implement some public safety measures or allow our counties to implement some public safety measure by allowing the sheriff to run radar on county roads.
Well, you answered my other question without me asking it. Thank you, sir.
Thank you, Senator.
Thank you, Senator Dupree. Senator McMahon, for what purpose, sir?
Question of the chair.
Of course. Senator McMahon is recognized for a question on this bill.
Hey, I'm really interested in this bill from a public safety standpoint. Were any hearings held on this, on this issue of allowing radar for the county?
Can you hold your mic? I can't hear you, sir.
Were there any, is that better?
Yes, sir.
Were there any hearings conducted on this topic? Did we take any testimony from sheriffs or from supervisors or anyone on this?
Not in a formal hearing. Of course, I've had conversations with the Sheriff's Association, with the supervisors. This is also something that came up before session as part of an ongoing effort that's known as Aiden's Law. I intentionally did not name the bill after any one traffic fatality because I think there's been so many that I would not want to single out anyone to the risk of excluding others. This is a problem on our county roads, and this bill is an effort to try to address that.
Do you think it might be conducive if we had some joint hearings on this summer?
I don't really know how much more we're going to glean from it. We all know what the highway traffic safety statistics are in Mississippi. We know some of the other issues and challenges that we face in Mississippi when it comes to careless and reckless driving, uninsured motorists. All those things are well documented.
Okay, thank you for taking my question.
Thank you, Senator.
Okay, we have Senator Carter. I'm sorry, Senator Carter, recognized for what purpose, sir?
Question.
Were you for a question, Senator?
Yes.
Senator Carter.
So the whole purpose of this was based off of Aiden's Law. Is that not correct?
That was certainly one of the impetus. I've also had 2 brothers who passed away on a county road in Hancock County right before Christmas. That hit a little close to home. But yeah, there's been enough where this demands attention.
So the reason for this bill is to slow people down on these back county highways or county roads, correct?
To enforce the current speed limits would be the reason for the bill, not necessarily to slow people down, but to give county sheriffs a mechanism to enforce the law.
Well, I mean, if I knew that there was going to be a deputy that potentially had radar, I would slow my tail down. So
that stands to reason.
Yeah.
Thank you, Senator Harkins. That's all right. All right. Why are you going back, Senator Chisholm? For what purpose, ma'am?
Question, please.
Are you for a question, Senator?
Yes.
Senator Chisholm is recognized.
Thank you, Mr. President. Thank you, Senator. If the county roads are not placarded, what are we going to use? What are we going to go by if we have no signs on the county roads as to the speed limit? I have several in my area.
And I think that that's going to be something that the counties are going to have to address. I think there's probably some engineering work in some counties and on some more rural roads that will need to be addressed. But that'll fall again onto the Board of Supervisors when they're determining whether or not to authorize their sheriffs to operate radar.
Thank you, and I think this is a good bill.
Thank you, ma'am.
Thank you, Senator McCon. For what purpose?
For a question.
Were you for a question, sir? You're recognized for a question, Senator McCon.
Thank you, Mr. Chairman. Will this apply across the board to every county?
To the counties that choose?
No, sir, to every county.
It will apply to every county, yes.
So will it take precedent over current legislation that's already been passed?
There are 2 counties that I'm aware of that currently have been authorized by what I'm assuming is a local and private law sometime back when, because I was unable to find it anywhere in the code. But there are 2 counties, one of them being the chairman's, that are authorized currently to run radar by a local and private. I don't think that the general law, from what I've been able to learn from council, the general law that we would be dealing with here does not trump that local and private.
So it's not going to be good for everybody else that's already got it. So all these others that you're putting in place are good for everybody else, but not good for the two that are already in place.
Those are existing local and privates that I don't think that the general law would trump.
Don't you think that's a little counterintuitive to what we're doing here? Either we're going to make it good across the state or we're not.
They're already existing. And I've heard from folks who represent those counties, or at least one of them, his sheriff's been running radar for 15 years, and he's never had a single constituent complaint about radar.
And that's good. And the chairman and I have talked a little bit on some of this, and he knew the question was coming, so that just was fair to bring that up for today. Thank you. Thank you, sir.
Thank you.
All right, Senator Harkins, for what purpose, sir?
Question.
You for questions?
Yes.
Please proceed.
Thank you. As we've discussed, and I think Senator Chisholm kind of touched on the point, some of these counties probably, my concern is that they haven't adjusted the speed limits for certain roads throughout a county. Is there any requirement that counties look at that before they institute radar?
There's no requirement in the bill that they do that, but I think that they're going to have a hard. As a lawyer, I would think that if I have a client who had a speeding ticket on a unposted or unmarked road, they'd have a pretty hard time enforcing that ticket against my client when the speed limit wasn't posted properly.
If there's not a posted speed limit on a road, is there a understood speed limit? Is it just
I believe it's 45.
45 for unposted roads?
Unposted county roads.
Unposted county roads? So unposted county roads, if there's not a posted speed limit, it's 45 miles an hour?
That's my understanding.
Okay. What about roads that are posted that are probably too low and need to be adjusted? I think I've heard some colleagues opine that, there's sections of road, they lower the speed limit to 30 miles an hour and it shouldn't be that low. I mean, how do you determine what the proper speed limit is for a county road? Because it typically is in the county. There's probably not, for the most part, there's not a lot of activity, but there are some county roads that have a lot of activity, and obviously the speed limits are important, especially when you're setting a precedent to allow sheriffs to run radar. I represent a county that's largely populated in an unincorporated area, and so it is a concern. There's problems with people speeding through the county, but I guess my concern is we put in radar and the county hasn't adjusted the speed limits on the roads to make it, I wouldn't say modern, but just appropriate. Is there anything in the bill that would require them to do that before instituting a radar?
Well, there is a requirement in the bill that the sheriff prioritize the use of radar on those roadways and areas of roadways where there have been traffic accidents and fatalities due to speeding. So that would be the first.
That's in the bill?
That's in the bill.
Okay.
To your more overarching concern, I think that goes back to the engineering department at the individual county. If they're going to want to run radar, if they're going to authorize their sheriff to run radar, I would think that it should go without saying that they're going to need to go ahead and post roads or post speed limits and maybe adjust speed limits on some roads if they're going to be enforcing those speed limits.
Well, my concern is if it does go without saying, it won't. And I think I would imagine we're going to have a lot of constituents that are going to be up in arms when they're getting tickets on a random road out in the middle of nowhere that's posted for 35 miles an hour when it shouldn't be 35 miles an hour. And I'd like to see some language that reflected just a concern that the county would internally address it, look at the posted speed limits on a lot of these county roads that they're going to patrol and make sure that they are within reason of what the appropriate speed limit should be. Don't you agree?
No.
You don't agree?
Like I said, I think that this is primarily a public safety bill. This purpose of this bill is to address a very glaring need within the state of Mississippi. The boards are authorized to determine whether or not their sheriffs will be given the authority to run radar. Those types of, we've all got roads or sections of roads in our counties, in our districts, where it may not be posted, or it may be posted at something less than what it needs to be. As this goes into effect, I think those things will naturally be addressed at the local level.
Senator Kirby?
Thank you, Mr. President. Simple question.
Yes, sir.
Yeah, they're all simple, I guess. Per capita, you said we were the highest rated in the nation. Is that correct?
That's correct. 24.9 deaths per 100,000.
And this bill covers county roads only, correct? Can you tell me what percent of that, of the fatalities are on county roads? Evidently, it must be really high, or we wouldn't be doing just county roads. Am I correct?
Well, I think when you look at our state, that's correct, Senator. When you look at our state, it's those more rural areas that fall inside the county that are the county roads where these accidents are. More of these accidents are.
Roads than there are state roads or federal highways.
Yes, sir.
Okay, thank you.
Okay, Senator Dupree.
Question, Mr. President.
Please proceed.
Be really quick. So we have 82 counties.
Yes,
and so of those 82 counties, do you know how many counties will have one radar piece of equipment?
66.
66 out of 82 would have one.
One.
Thank you, sir.
Senator Hickman.
Motion, Mr. President.
Please proceed.
I move the table.
One moment. Well, I had my rule book. Senator Hickman, you recognize to speak on your motion. He not desire to speak. Senator, do you desire to speak? Senator Bryan, you desire to speak on the motion? Senator Bryan's recognized to speak on the motion.
Mr. President, I would urge members of the Senate not to table this bill and to keep the bill alive so that it can go through the process. I have a major problem in the district I represent, and I'll bet there's similar situations all over the state. There is a county road which people are using as a shortcut. That road is not made for through traffic. That road's been there for decades and decades. It was a small country road. It's a residential road, residences and farms. But as the countryside has become more developed, and certainly with more and bigger and faster cars, it's not like it used to be. Now, I, of course, would never participate in such a thing, but there are those who I understand use GPS for navigation purposes. And one of the many modern inconveniences with GPS is that it will route you down a road that's not a major thoroughfare. And not only have individuals discovered this shortcut, GPS has discovered this shortcut, and there are trucks and interstate traffic and all coming down this road, which was meant to be a rural residential road, and they're coming with large volumes and lots of weight and really fast, and it's dangerous. I know that we're concerned that this might be misused, but the bill before us is just about as narrow as it can get. I don't care what sort of restrictions anybody can come up with to avoid abuse or to limit this. But please, for those of us, and these situations are all over the state, that have these dangerous situations, please let us have some relief to do something about the traffic that's coming down these roads at speeds that were never intended or anticipated. Thank you. I would urge you to vote no on the motion to table.
Senator, you recognized? You're recognized, Senator. Senator Hill, for what purpose?
Speak against the motion to table.
I think we've got 1 minute left, Senator. You're recognized. We had 5 minutes on the motion.
First of all, Aiden, that was killed on Texas Flat Road, is my cousin's grandson. The bill is written extremely tight. There's no way for a sheriff's department to use this bill as a revenue generator because all the money is going to go to driver's ed. The sheriff wants to get reelected. He's not going to abuse this. I helped write this bill. This bill is tight. This bill directs the sheriffs where to use the radar. So it can't be used as a revenue generator. That's the first lie that you hear outside this body. We have no problem addressing any concerns that people have with it, but the main two things is it's going to be abused. Well, it's not, because they're not going to get any money out of it. And the second thing is the sheriff wants to get reelected, and what he wants to do is save lives. So I would urge you to vote against the motion to table.
Senator?
It concerns me that when faced with such a glaring public safety problem, there are misinformation, there are intentional misstatements of what the bill does and doesn't do that are used to try to defeat what is a good public safety effort. This is not so that county sheriffs can issue limitless citations and generate revenue for the county. This is not so that it can be abused to just randomly pull people over. This is to address speeding on county roads only throughout the state. It's a good bill. It's intentionally limited in how they can be used and even in whether or not they're authorized to be used by the County Board of Supervisors. I urge the body to vote against the motion to table so that we can continue to move forward with this piece of legislation. Thank you.
All right, so first we have an aye. First, all in favor of the motion, please signify by saying aye. Aye. All opposed to the motion signify by saying no. No! That's close. If you ask for the veto,
Mr. President, roll call.
The chair is in doubt, gentlemen and ladies, and so, Mr. Clerk, please call the roll.
Barrett.
Parliamentary inquiry, Mr. President.
Please proceed.
Because the chair was in doubt, Mr. President, we asked that we do a division.
One moment. One moment, Senator. I believe I have the authority to do that. Let me look. I know, I'm just looking, but I have the ability, I think, to do both. Just one second. Everybody go back to your calendar, please. Go back to your chair. We're going to call division. Senator Polk? Okay. Okay. All in favor of the motion, please stand. Everybody stand, we're going to count, so don't sit down. Okay, let's start one more time. Stand, please, we're counting. 1, 30. Those opposed to the motion, please stand. Motion passes. Okay. We'll go to the calendar. Senator Hill, for what purpose?
Parliamentary inquiry.
Please proceed.
On the previous bill, we had 6 for a roll call, but we weren't recognized for 6. So does the roll call take precedent over division?
No, the chair has authority under, I had the rule out here, it shows either one, we chose division. Okay.
Thank you, Mr. President. I've never seen that happen before.
All right. Senator Fraser?
Introduction at the proper
Please
time.
proceed.
I would like the senator to make welcome, sitting in the north balcony, one of my very good constituents, Evelyn Ball. Please make her welcome.
Senator Barr, Senator Barnett, past Senator Blackwell.
I'd like to go to item number 37, Senate Bill 2695. Ask the title be read.
Mr. Clerk, please read the title.
Senate Bill 2695, Medicare Certified Long-Term Acute Care Hospitals exempt from the hospital provider assessment, subject to approval by CMS.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye. Request me recognized to explain the bill.
You're recognized to explain the bill.
Thank you, Mr. President. This bill is for our LTACs, and that stands for Long-Term Care, Acute Care Hospitals. They're a fairly unique provider class serving Medicare-eligible populations, but they are excluded from our standard inpatient prospective payment system that we have with Medicaid. Unfortunately, they pay the bed tax, but they are not able to participate in any compensation. But these LTACs are important to us from a continuum of care standpoint. The patients are often on ventilator dependent and have multiple comorbidities. Many LTAC patients are transferred from intensive or critical care units from acute care short-term care hospitals. And LTACs serve as a vital discharge destination for complex patients who cannot go to a lower level of care. And the average length of stay, where in a hospital it's going to be about 6 days, it's about 27 days in an LTAC. We have 7 LTACs in our state, and they're all losing money. As an example, just with 4 of them that are related to one particular company, they have lost over $6 million this year. However, they have paid in over $8 million into the Medicaid, our tax system. And unfortunately, like I said before, they can't participate in that. So what this bill does is it will allow the department to negotiate with CMS to see if we can get them out of that, having to pay the bed tax. That's the explanation of the bill, and I have an amendment at the proper time.
I'm sorry, Senator. Where are you on the motion?
Well, I have an amendment, Mr. President.
Amendments on the calendar. You're recognized to explain the amendment, sir.
So in working with the department, this is the amendment we came up with. We're going to, on lines 173, 176, we're going to delete the proposed prior amendment and then insert the verbiage below. At the discretion of the division, Medicare certified long-term acute care hospitals may be exempt from the hospital assessment provided in this chapter. Such exemption is approved by the Centers for Medicare and does not result in the state receiving a lower federal financial participation rate for any supplemental payment programs operated by this chapter. It's an explanation of the amendment. I'll yield for questions.
Questions on the amendment? Seeing none.
Move for adoption of the amendment.
All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it.
Move for passage by the use of the morning roll call.
Use of the morning roll call has been requested. Anyone object? Call voting no. Present. Seeing none. Bill passes by use of the morning roll call. Johnson. Senator Johnson. Pass and retain. Senator Rhodes. Senator Rhodes.
Thank you, Mr. President. I'd like to skip item 39 and call up item 40 on today's calendar.
Mr. Clerk, please read the title.
Senate Bill 2761, Mississippi Lead-Based Pain Activity Accreditation and Certification Act, amend to conform with EPA.
I make the usual motion.
Usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it.
So this bill comes to us from DEQ.
They are requesting that we make some changes to the existing code, that it basically just corrects errors and omissions in the code already. It removes unneeded duplication of EPA regulations, expands qualified personnel allowed to obtain certification for certain activities, and it standardizes the length of time that's required for educational training. The goal is just to make the lead paint program easier for our customers to understand and to use, and by doing so, we're trying to just conform these definitions to those provided by the EPA. I yield for any questions.
Questions on the bill? Seeing none, we're ready on your motion, sir.
Move for passage with the use of morning roll call.
Use of morning roll call has been requested. Anyone object? Court is voting no. Present. Seeing none, the bill passes. Senator Suber. Pass and retain. Senator McMahon, for what purpose?
Introduction.
Please proceed.
In the South Gallery, I would ask Leslie Davis to stand. Leslie is one of our great ambassadors from Mississippi. And let's give her a warm Senate welcome. Stand up, Leslie. Let's give you a big welcome.
Mr. President, I'd like to suspend the rules and go back to item number 38. And
all in favor of rule suspension, please signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed, Senator.
Ask that the title be read.
Mr. Clerk, please read the title.
Senate Bill 2712, Small Loan Regulatory Law, authorize licensee to charge fee for non-recording insurance in lieu of recording costs.
Make the usual motions.
Usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Senator.
Ask that you recognize Senator Sparks to explain
Senator Sparks, you're recognized.
Thank you, Mr. President. Thank you, Mr. Chairman. Senate Bill 2712 addresses small loan regulatory law. There are items that often are pledged as collateral when you borrow money, even at small amounts, and sometimes to have a UCC filing for that would actually be more expensive than purchasing an insurance policy, so they're allowing a fee to be done instead of actually purchasing the non-filing or non-recording insurance on the instrument. That's what the bill does. It just allows that option instead of actually having to go out and file on a UCC on small loans. Mr. President, I would yield to any questions.
Senator Butler.
President, question, please.
Are you here for a question, Senator?
Yes.
Please proceed.
Thank you, Senator Sparks. I don't really understand that. Now, tell me, how does that work?
So let's say, for instance, I'm going to come in and take out a small loan, and I'm going to put up my tractor as collateral. To perfect that lien, you would need to file a UCC filing with the Secretary of State. And there's a process that you have to pay a fee to file. You have to do a lien check. So you got to make sure my tractor, I actually don't owe 10 other people for it. Just like you would do a title search on a car or, on a deed. So this allows the lender to, instead of filing the UCC, charge a fee, which would be like an insurance of non-filing or non-recording, as long as it doesn't exceed what the fee would have cost to actually file it.
Okay.
So it's not an increase, it's just allowing, in lieu of actually filing or chasing that cost, to just charge a fee.
And then you wouldn't have to do so much paperwork in order to...
Well, they'd be covered at that point. Oh, yeah, I may not get to run a title opinion. That's right.
Okay.
Thank you, Senator.
Okay, Senator Hill.
I have a question.
Yes, ma'am.
I yield.
You for a question. Senator Hill's recognized.
Do you know who asked for this bill?
No, ma'am.
So it would affect like small loan companies like Tower Loan, places like that?
It's
Would it
small.
would it make them more money, or is it I mean, from
Well, since there's no fee that is in excess of the actual fee it would cost to file, I would say it would be revenue neutral.
revenue neutral.
It
Thank
would
you.
in their position, I think.
Thank you.
Thank you.
Any other questions? Seeing none, Senator?
Move for passage on the morning roll call.
Use of morning roll call has been requested. Anyone object? Court is voting no. Present? Thank you. Senators, I'm sorry, President Simmons. I'm sorry, no Hill. Present Mumford. Simmons? Present. No Chisholm. Present Broomfield. Anyone else? Anyone else? Seeing none, the bill passes by use of morning call. Presence noted and no vote. Senator Suber.
Thank you, Mr. President. I'd like to go to item 42, Senate Bill 2428, and have the title read.
Mr. Clerk, please read the title.
28, CWD testing, make third violation a felony with an increased penalty.
I'll make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it.
I'd like to call up the committee substitute and ask to be recognized.
You're recognized to explain the committee substitute.
I want to be recognized for a motion to defeat the committee substitute. We have a strike all amendment to the original bill. So my motion would be to move for adoption of the committee sub and ask the body to vote no.
All in favor signify by saying aye. All opposed, no.
No.
The noes have it, Senator.
Move back to the original bill. I do have an amendment that I would like to offer and be recognized to discuss the amendment.
You're recognized on the amendment, Senator. It's on the screen.
So what this bill does, currently we have enclosures in our state that we have mandatory CWD testing. What this bill is doing is allowing them for alternative methods for the testing. You still gonna have the current methods. So when a deer is harvested, that they have so many. You have one for every 200 acres have to be tested. What this does is removes the acreage requirement, and we allow alternative methods. This has kind of been a work in progress. The enclosure group and the Department of Wildlife Fisheries have met. This was kind of a compromise between both parties, and I will be happy to answer any questions.
Senator Michelle. For what purpose, sir?
For question, please.
Will you yield, Senator?
I yield.
Senator Michelle is recognized.
Thank you, Mr. President. Senator, the term felony in this title scares me a little bit. And you referred to CWD testing, and then you referred to enclosed pens, and I know there's certain CWD zones.
And I can answer that question. The short title, there's a combination of numerous bills, and that was the short title of one of original bills, but there is no increase in penalties or violations. The violations that are in the current statute is what's there.
And that would just be for areas that are determined to be CWD zones.
Well, these are just limited to enclosures.
Oh, enclosed. Thank you. That clarifies it nicely.
Like I said, the short title does kind of throw it off, but there is no increased penalties. All the penalties are the exact same.
Senator Barrett.
Question, Mr.
You,
President.
Senator.
I yield.
Senator Barrett is recognized.
Thank you, Mr. President. Thank you, Mr. Chairman. So all this bill does is, in lieu of an actual cost of recording an instrument, and by that I'm assuming you're talking about a deed or some sort of promissory note that would be filed with the Chancery Clerk's office?
I think you might be on another bill.
Well, I'm looking at the CWD bill.
We don't have any deeds of trust or deeds or promissory notes in this bill.
when it refers to any kind of penalties or felonies or anything like that, I think Senator Michelle addressed that question. There's no increase of penalty or punitive measure in any way in this bill, correct?
That is correct. Like I said, the title was from a previous bill. We combined a couple bills together.
Okay. Thank you.
Senator Berry, for what purpose?
A question.
You yield for a question, Senator?
I yield.
Please proceed.
When it talks about alternative methods of testing, what are those alternative methods?
So currently, based on the discussion with the department, they can actually go in and test like scrapes, known areas of like where there's a saliva available, just any other option. You're still gonna have harvested deer that died based off of natural causes or other causes, but this will just give them another option to do some testing.
So like testing the soil prions and things like that where the virus might live?
Yes, sir.
Okay, all right.
Yes, sir.
Thank you.
Senator Chisholm, for what purpose, ma'am? I'm sorry, Senator Whaley.
I'd like to speak on the amendment at the proper time.
Okay. I believe the proper time is now. I see no further questions.
Thank you, Mr. President. Ladies and gentlemen, I'll be brief. In regards to this, I do believe that the senator has a good bill because in the past this was a bad bill. What we have come to see with CWD is I believe it is more fear tactics than it is anything. You look at CWD across the United States, the states that it was most prevalent in, the one key factor is that harvest numbers do not drop over an extended period of time. They rebound very quickly. You see that the type of deer harvested continuously grow, they get better, and a lot of this is through recognition of the genome types of deer that there are. There are 3 genome types. The prevalence of the CWD contraction within those are key critical factors. I do not trust the methods that are being used with this, and I believe that this is more of an anti-feeding of wildlife bill than it is anything. And with that, I'm going to support this bill because I do think it does help the whitetail enclosure, people who have been treated unfairly, the deer kings as they're called by some. But I am going to support this bill because it is better than what it was. Thank you.
Okay.
And I would yield for any questions if there were any.
Seeing none, Senator, we're ready on your motion.
Motion to adopt the amendment.
All in favor signify by saying aye. Opposed, no. The ayes have it.
And I move for passage based on the morning roll call.
Passage based on the morning roll call. Anyone object to that procedure? Court is voting no. Present. Seeing none, the bill passes. Senator Suber.
I'd like to go to item 43, Senate Bill 2664, and that's the title to be read.
Mr. Clerk, please read the title.
Fishing license, increased threshold for reducing issuance rate from 13 to 18 years of age.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it. Please proceed, Senator.
And I would ask for Senator Whaley to be recognized.
Senator Whaley, you're recognized.
Thank you, Mr. President. Thank you, Mr. Chairman. Very, very simple, straightforward bill. This is dealing with the Mississippi Lifetime Hunting License. This just basically changes the age limit, and it says that anyone under the age of 18 years of age is eligible to purchase the license. I would yield for any questions if there are any.
Senator Seymour, for what purpose, sir?
Question, Mr. President.
You for a question, Senator?
I yield.
Senator Seymour is recognized.
Thank you, Mr. President. Mr. Chairman, would there be any significant loss of revenue to the department that we'd have to make up?
Well, there's no way to know that because you don't know who would purchase the license or who wouldn't to begin with.
You could make an argument that they would lose revenue. You can make an argument that they would not lose revenue, but part of where the funds go on the lifetime license, that goes to a trust fund used for something else. So you can make arguments either way, but either way you wouldn't be able to prove it. But this would open up opportunities for minors to be able to purchase this lifetime hunting license.
Thank you.
Yes, sir.
Senator Berry?
Do we know how much the lifetime license would cost?
I did, and I do, and you caught me off guard. I can get you that number pretty quick. It's back there in my stack somewhere.
Okay. I don't want to make you speculate,
Senator Younger's
but
telling me 1,000.
1,000. So
We do nothing to adjust the cost of that. We're just opening up the eligibility to anyone under the age of 18.
okay. So we wouldn't set the cost. That would be up to the department to set the cost.
That is already set.
Okay.
This does nothing to those costs.
So like an all sportsman license is $70, $80 or something like that a year. And if I buy one when I'm, 16, in 10 years, I've pretty much paid out for that. Then I'm basically hunting for free for the rest of the life compared to someone that buys them year to year. Is that fairly accurate?
Senator, the minor's reduced rate is $500, so there's a $500 charge for that lifetime license. So it would be a very good investment, I believe, for someone. But that's the answer to your question there. It's $500 for the license cost.
Well, I want to make it easier for folks to hunt. Don't make it hard on them. But that's a pretty good deal for $500. If there's not going to be a lot of interest on that over 20 or 30 years versus if I buy the license year to year. I think that maybe the department would be missing out some revenue. So I would certainly encourage them to maybe look at raising that from 500 to a little bit higher number that doesn't offset them as much.
I appreciate your question.
Thank you, Senator. We're ready on your motion, Senator.
Move for passage by the use of the morning roll call.
Use of morning roll call been requested. Anyone object? Wish to be recorded as voting no. Present? Seeing none. Senator Suber. Senator Whaley, thank you. Senator Suber. Senator Wiggins. Pass and retain. Senator Wiggins. Pass and retain. Senator Carter.
Thank you, Mr. President. I'd like to go to item 45, Senate Bill 2058. Have the title read.
Mr. Clerk, please read the title.
Senate Bill 2058, Mississippi Gulf Coast Region Utility Act, expand provisions concerning promulgation of rules and regulations.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it.
Thank you, Mr. President. So we had this hearing back in September on all these different water issues, and this is another water bill, and I'm going to be very, very hydrated once I get done with these bills. But anyway, so what this bill does, if you look at Section 1 on the 8th line, this coordination with certificated providers, PSC, confirms that the authority may operate systems but may not duplicate service in areas already certificated, and the PSC may not act in conflict with these powers. Section 1 on 9 is right of first refusal. This is new. It creates an exclusive right of first refusal in uncertificated areas within the authority's service area. Written notice is required 90 days to elect service. If elected, no other provider may serve. Section 1 and 10, unauthorized service prohibited. This is new as well. Prohibits any provider from serving inside the county's authority service area without written consent from the authority and compliance with the PSC requirements. Section 1 on 11, it's penalties enforcement. This is new, and this is a big part of the reason for this bill. Up to $500 a day civil penalties, injunction relief, recovery of attorney fees and costs, standing to file suit. In Section 1 on 1213, supplemental powers and legislative intent, states that these powers are supplemental and are intended to prevent duplication, protect public investment, and promote coordinated planning. That's an explanation of the bill, and I'll be happy to entertain questions. And this is committee sub.
Senator England, for what purpose?
Question, Mr.
Do
President.
you have a question, Senator?
I do.
Senator England, you're recognized.
Thank you, Mr. President. Senator Carter, are you aware that currently cities are allowed to operate within 1 mile of their certificated area, and that there are cities that are currently serving those areas?
I am aware.
Okay. And this is going to prevent them from doing that?
This doesn't prevent them from doing that.
Well, that not the way I read it. Number one, I would say that lines 21 to 22, which discusses the intent, not only establishes the right of first refusal and robust remedies, it says to prevent competing. So these authorities that you're speaking of, they don't want to have to compete with these other areas that are already serving that water. Is that correct?
No, this is the intent of this bill is, and this is what the problem is. So whenever this act was first passed in 2012, there was no teeth in the law. And so what you had these mom and pop operations open up these water utilities, and then you had these sewer entities come in. Well, what's happening is people aren't paying their sewer bills, and these mom and pop water operations are not shutting the water off. The money's in the water. It's not in sewer. That's what's going on with this bill.
Yes, I understand that, and I understand there's money in the water, which is why I'm concerned for our cities right now. Are you aware that MML is against this bill?
Oh, I'm aware.
Have you talked to MML about the bill?
MML doesn't like me.
Well, I don't think they hold that personally against you, Senator Carter, but are you aware why MML is against the bill?
Like I said, they don't like me. They haven't talked to me about anything.
Okay, well, if you'll look at lines 74 to 79, and this is where the penalty is going to come in, it says no municipality, public or private utility, person or entity shall construct, install, connect, operate, extend, or, and I want to point this out very clearly, or continue operating any water, wastewater, stormwater system to serve the customers or property not wholly located in the area. So you've agreed that we know that there are cities and water authorities. You call them mom and pop, but like West Jackson County Utility Authority, for instance, I wouldn't say they're mom and pop. I sat on their board, and they serve a very large unincorporated area of Jackson County. They are not able to continue operating to those customers that they may have served for 20 years under this legislation. Am I reading that correct?
Well, I will tell you there's a reverse repealer going in this bill, and these issues need to be addressed, and maybe this language isn't perfect, and that's why I'm putting a reverse repealer in it. I'll be happy to work with you moving forward on it.
And I appreciate that, but with the reverse repealer and that, number one, the statement of intent that says it wants to prevent competing for these services, and then also it says that no municipality or any current utility authority can even continue operating those services, is going to be subject to a $500 fine per day according to this bill, and that's the meat of the bill. Am I missing the other?
What you are talking about sounds like protectionism, which I'm completely against. I'm open to the free market. That's what it sounds like, because I haven't gotten any pushback from any of the 6 coastal counties but Jackson County. So I would say that there's some protectionism going over there in West Jackson County, and I'm putting a reverse repealer in this bill, and we want to move forward with it.
So if MML is against the bill, am I correct that the cities of Long Beach, Gulfport, Biloxi, Pass Christian, there's
Not
a lot
one
of cities in
mayor,
Harrison
not one
County.
municipality has reached out to me, and I represent Gulfport and Biloxi. I haven't heard from either one of them being opposed to this bill.
Let me ask this. You mentioned in 2012 that this utility authority system was established.
Right.
The Harrison County Board includes mayors on their utility authority board. Is that correct? I can let you know that is correct, that those members are elected mayors that are on that board. However, Jackson County is different. We don't have elected people holding this that are in charge of that board. So you have unelected officials that are now going to be able to say, West Jackson County Utility District, or City of Goche, City of Pascagoula, City of Ocean Springs, you cannot serve these customers you've been servicing for 20 years, and if you continue to do so, we're going to fine you $500 a day for that. And there's nothing that's making them whole in this either, is it?
There's nothing in this that all this does is give the attorneys the ability to enforce the law. That's
Yeah.
all it does. There's
So,
no,
you mentioned not being for protectionism, and I don't know if I've seen a more protectionist bill that's come before this body for a service that's being provided by a lot of these cities and a lot of these authorities on the coast. I mean, this quite literally gives the utility authority the authority on their own, some of these non-elected bodies, to say, you've got to stop servicing these areas. And if you don't stop servicing these areas, the Mississippi legislature gives us the authority to fine you $500 per day per customer if you continue servicing them. And I will remind you, Senator Carter, these are customers that the utility authorities that are in place now, that are in these cities and that are servicing these customers in unincorporated areas. They've worked with contractors. They've run their own pipes. They've maintained these pipes. And now they're going to be fined $500 a day if they don't disconnect that service under this bill. Isn't that correct?
I disagree with what you're saying.
Well, you can disagree with me with what I'm saying, but that's what the bill says, correct?
No, that's not what the bill says.
Well, tell me how I'm wrong.
Because you're wrong.
Well, that's just not that. Look, that might work in some areas where you think people just don't like you for not voting against something. But this is a very dangerous piece of legislation here that is going to give these authorities way more power to not only tell these existing entities that they have to abandon customers that they're serving, that they have serviced for a long time. Not only that, they're going to be fined $500 a day for that service, and those customers are being told, you're going to have to sign up with this utility authority and pay for authorities. I think what you said earlier, and please correct me if I'm wrong, you said this is about the water because the water's where the money is, correct?
100%.
So these utility authorities are trying to grab that money from these already existing service providers.
That's not, and like I said, there's a reverse repealer going in this bill, and if you have an issue with it, then work with me on it.
Senator Carter, if this passes today, I will certainly ask you to work with me on it because I think the whole thing needs to die, but I'm against this bill even with the reverse repealer in it for the exact reasons that I've said, and it says it right here. Establish a right of first refusal for these customers and to prevent competing and conflicting service providers.
Well, I will say that there are 6 counties in this bill, and there's only one county that's against it, and it's Jackson County. So,
Senator Carter, I don't think that's correct with the people I've talked with, and I also
well, they
don't
might.
think...
The people that you talked to probably should have talked to me. How about that?
Well, I imagine the ones that I've talked to have tried to talk with you about this. I've talked to
My
some...
cell phone is readily available. My phone is all over the internet. It's very easy to get in contact with me.
I understand. I have received messages from mayors today. I've received messages from MML, which I'm sure many others have, and they are very concerned with the authority that we're giving to in some cases, like in Jackson County.
Well, you know what? Maybe
non-elected
MML should
authorities.
probably text the chairman. How about that?
Well, I would be okay with that.
Yeah.
And I think you probably will receive texts on this because I seriously have never seen us do something to this extent where we're flat out giving a non-elected body the authority to tell somebody you've got to quit servicing a customer and receiving their payment for those services. But if you don't stop doing that, we're going to fine you $500 a day per customer. So that's going to, what that's going to do, Senator Carter, and I'll ask you if you'll agree with me on this. Would you agree that if those entities that are servicing those customers, if they start getting fined $500 a day per customer, that's going to cost that utility authority money? Is that going to make the customers' prices for those services go up?
That's not going to happen on this piece of legislation.
Senator Carter, I've got the legislation right in my hand here. I'm telling you exactly what it says. I asked you to tell me how I was wrong, and you said you're just wrong. I'm asking you to tell me how I'm wrong, and you can't do it. Please tell me why I'm wrong on that.
Well, I mean, if they are not acting in good faith and they're not doing what they're supposed to be doing, then they're going to get fined. And yeah, it's going to go down to the ratepayers. But the ratepayers should hold their utility authority accountable.
You say they are acting how they're not supposed to be acting, if they're acting in good faith, but you're talking about if we pass this legislation. If we kill this legislation, they get to continue to service their customers. the customers of those service providers don't have to worry about their utility authority getting fined.
That's the whole reason for the legislation, is that people aren't servicing their customers. I wouldn't just come bring up some bill just for someone. I'm trying to solve a problem.
You had a hearing. Where are these customers not being provided services?
It's not that they're not being provided services. It's that I told you earlier on. You've got two separate entities. You've got a water association. You have a sewer association. And so people just aren't paying their sewer bills. And the water associations won't cut the water off. And so this puts teeth in the law to where you act in good faith or you don't get fined. If you do what you're supposed to do, you don't have to worry about being fined $500.
Right, but it doesn't just do that. It says if you continue to service areas that you're servicing, they're going to fine you. This is a huge government overreach, in my opinion.
That's your opinion. And like I told you, I'm putting a reverse peeler in the bill, and I will work with you further on it if you have that many concerns
Well,
with the bill.
I've seen a lot of bills get reverse repealers and end up at the other end of the hall, and we get mixed up on things. And if we have a piece of legislation that's this bad in front of us, I think it's on this body to go ahead and kill it and let you work on it again next year and bring us something that maybe we can vote on.
Is it kind of like that piece of legislation you had yesterday?
Which piece of legislation would that be?
The one that I tabled? Is that why you're so mad?
Oh, I'm not even worried about yesterday. I'm worried about this piece of legislation I've got in my hand right here. Yeah, listen, I told you earlier, nobody's mad at you, Senator Carter, but this legislation, I don't think you should take it personally that this legislation is so bad. I don't think you drafted this legislation, correct?
I have had many, many people vet this legislation.
Did they work with the utility authorities? I think your silence lets me know who
they didn't
exactly
work
is
with,
wanting this piece
Jackson
of legislation.
Utility Authority.
I'm going to vote against this bill. Mr. President, I'd like to speak against this bill at the time.
You're recognized to speak against the bill, Senator. Thank you, Senator Hill. For what purpose, ma'am?
I need to speak against the bill.
Y'all come on and line up. Senator Seymour. Senator Seymour, for what purpose?
Question, Mr. President.
Are you for a question?
Yes.
Senator?
Thank you,
You're
Mr.
recognized.
President. Mr. Chairman, let's kind of talk about line 2122. If we go back to the inception after Hurricane Katrina, Haley Barbour at the time had the forethought of the...
Y'all pipe down. Listen to what Seymour's saying, please.
The coast had growth coming, and these utility authorities were one of the outcomes of trying to keep redundant service being put throughout the coastline. When on its inception, I believe that the federal grant program was CDG, but that money was given into through DEQ and administered on the Gulf Coast. It would be knowledgeable for y'all to understand that we're still under a lien agreement with HUD for the next decade on this money. And we're talking hundreds of millions, maybe in the billions of dollars. This language here, getting a little ahead of myself, the supervisors were actually the ones that bought into this agreement. They sent a local and private that we all have approved, and that's what they're supposed to be operating under. Without this language to keep them viable as far as they're a pass-through service, they will falter. If they falter, then HUD is going to come back to the state of Mississippi. The state of Mississippi is going to have to come back on the counties involved for clawback money. The other part of this is the board, speaking of the Jackson County Utility Board, is actually appointed by the supervisors themselves, along with, I believe, a appointee of each of the cities along the coast. So the saying that it's being operated by unappointed people, we have boards all over the state that do that. But these are actually appointed for a term by our supervisors to do the best they can for the local economy and their water and sewer situations. Part of that, as far as the pavement and all, municipalities have in the past, the utility authorities get audited just about every year by one federal agency or other. And they always pass with pretty high scrutiny. On the local level, there is no audit of a municipality or how that money is being handled. Some of our cities along the coast have found it at times to introduce an extra amount of money into their general fund, which by statute is against the law, but we have no way of correcting that. But anyhow, this is a good bill. It gives them some teeth to get their money that by law they are supposed to collect. And if the city or the rural water is not going to be in cooperation, this entity that these counties have voted on, or the overstating, they hold all the cards. They're the ones that's
And
supposed
you make
to
a
make
great
the decision.
point,
Thank you.
and I probably should have brought that up about the HUD money. I mean, the state will be on the hook if these systems fail. But with that, I'll yield the mic.
Senator, one moment. Senator Dupree, I'm sorry, Senator Harkins,
For an introduction.
please proceed.
Thank you. Ladies and gentlemen of the Senate, if y'all would please turn your attention to the gallery. We have the Secretary of State Student Ambassadors with teacher Alana Magliola, who is here today. If y'all would please stand and let us make you welcome. They're here for their spring summit.
Welcome. Senator Frazier,
Introduction.
please proceed.
Please welcome in the West Gallery Reverend Catherine Ori Perry. Please make her welcome.
Okay.
Mr. President, I need to move to adopt the committee sub first.
A motion is to adopt the committee substitute. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed.
And then I have an amendment.
Amendment to the committee substitute. One moment. There's the amendment.
It's a simple amendment. It's just put a reverse repealer in the
All in
vote.
favor signify by saying aye.
Aye.
Opposed, no. Ayes have it. We're on the bill. Senator
think you have
England
a
is first, I
couple to
think,
speak.
on, yeah, Senator England, you're recognized to speak on the bill. On the bill, Senate.
Thank you, Mr. President. Ladies and gentlemen, thank you for listening to me on this bill today. Like I said before, this is such a large overreach on this, what's trying to be done here. And not only is it an overreach, it tells us that it's to prevent competing for these services. There's not much, I know we've got a reverse repealer in this bill. I don't know what's redeemable in this bill, because there's only a few underlying sections after the intent tells us this is to prevent competing. But I want everybody to look at lines 74 to 79. No municipality, public or private utility, person or entity shall construct, install, connect, operate, extend, or continue operating any water, wastewater, or stormwater system to serve any customer or property not wholly located within an area subject to a certificate of public convenience and necessity. I did say the word person because it's in the bill right there. When I was campaigning in my district, I talked to a lot of people. I know you all have done the same thing. And I went to many doors with people that were on fixed income on their retirement. And they said, sir, the utility authority is trying to get me to get rid of my well, to stop operating my well and hook onto their service. And they told me, sir, that road is 200 feet away from my house. I can't afford to run the pipe that they're telling me that I have to run to hook up to their main line. This bill, let me go on and tell you what it does after that, because it clearly says that no person can do that any longer. Not only can they not do it, they're charged $500 a day if they continue to do it. We're allowing for injunctive relief for these utility authorities to enforce that. And if you'll look at lines 86 to 87, we're also allowing for the recovery of reasonable attorney's fees for them to enforce this authority they're asking us to give. So I will have to go home and tell these individuals that live in the rural parts of my county that have lived on a property that has septic and a well that they've operated properly for a long time and they've got their fixed income. Ma'am, I'm sorry. I tried my hardest to stop this in Jackson, but you've got to pay to run that pipe to that line. You've got to pay your monthly charge to operate that now. You've got to find the money for it. And if you don't, you're going to be fined $500 a day by this government for doing that. They've got a right to file injunctive relief against you. You don't have that right. They have the right to file that injunctive relief against you, and you're going to have to pay their attorney's fees for them doing it. That is ridiculous. And guys, senators, with all due respect, there's not much more underlined language than that. I don't know what a reverse repealer can do anymore on this bill. Again, the intent there is to prevent them from having to compete with these people I talked with that are operating their own wells. The cities are the same way. Your cities are servicing up to 1 mile outside of their corporate limit because current law allows them to do that. We're going to tell your cities, you've got to stop servicing those customers, or we're going to file injunctive relief. And cities, you're going to pay $500 per customer, and you're going to pay our attorney's fees. And boy, I bet those are pretty lucrative when you have that many customers involved. And who pays for the city? The taxpayers do. That's taxpayer revenue. This is a terrible bill. I think I've said all I really need to say on it. I hope I've said all I need to say on it. And let's defeat this bill right now and not send this other to the hall and worry that this might come back before us. Thank you.
Senator Seymour, for what purpose, sir?
Question, Mr. President.
You for a question, Senator England?
I will yield for a question,
Senator
yes.
Seymour, please proceed.
Thank you, Mr. President. Mr. Chairman, do you receive any financial compensation for professional services to any of these municipalities or districts?
I do not.
Well, when you start talking about the hookups of the utility authority wanting to charge a fee for not in compliance, what does the fee for West Jackson County District charge?
I don't know. When I was on that board,
they charge it too.
They charge.
They charge the same.
I don't know if they charge the same.
Oh, yeah.
And I tell you what, if the utility authority had a monopoly on this, I can tell you what will happen to those fees that you're worried about. Once they get that monopoly, those fees are going up.
This is not a strike to go out and create revenue. This is to come under compliance of DEQ and EPA regulations. All this started back before '69, before there was an EPA. The first growth on the Gulf Coast had gotten to where, for a better term, the fecal count in the Bay of Biloxi and along the coast had become unsafe. We was almost to go under a cease and desist as far as growth, and Hurricane Camille hit.
Is there a question, Senator Seymour?
You want to hear? Well, your utility district and municipalities apply the same fees for hookups if you're not in compliance. Maybe not to the dollar that's in this bill, but they also do.
Senator Seymour, I didn't catch the question, but I'll tell you this based on your first question asking me if I had I don't appreciate the insinuation that I would have been in the position where I'm accepting money from anyone to work up here to do that, and I'm not. And I'll tell you another thing, I don't have any relatives that work for a utility authority either.
Correct.
Can you say the same?
No.
Okay, thank you.
All right, Senators, let's go. Senator Hill, you're recognized to speak on the bill.
Thank you, Mr. President. I live in one of those counties with the Gulf Coast Regional Utility Authority. We have been getting along well as of late, but I can tell you the first thing that I had to do when I got elected was fight the utility authorities. Number one, they were trying to make people in rural Pearl River County, Jackson County, and wherever shut their wells down. There's not a whole lot of stuff that scares me in a piece of legislation, but lines 74 through 79, I agree with everything that Senator England said. This language gives them the authority to tell me that I got to shut down my well, or that I can't put another well in to service my farm or whatever property that I have. It says person, no municipality, public, private utility, person or entity shall construct, install, connect, operate, extend any water system that's not in a certificated area. I'm not in a certificated area. I'm in rural Pearl River County. The first thing I had to do was fight the utility authority because they were working in conjunction with DEQ to try to force the city of Picayune to turn their water system over to the utility authority. That was the first thing that I had to fight as an elected official. Even before I was sworn in, I was at a meeting at Pearl River Community College trying to fight them taking over the city's water and taking over the people that had wells in rural Pearl River County. And the last meeting I had was up in the penthouse suite at Butler Snow's office because they represented the utility authority, and their lawyer is the one threatened my city. Said if you don't turn your water over to the utility authority, you'll never get permission to drill another well from DEQ. Now may the lightning strike me right now if I'm telling you a lie. I hate to repeat this, but this is how desperate they are to get customers. They threatened my city and said DEQ will never give you another well if you don't turn your water over to the utility authority. And the last thing I had when they were trying to smooth it over and meet with me up in the penthouse suite at Butler Snow, I said, go ahead and run that water through in front of my house. I said, and you're going to have to run it through my dead body to hook it to my house. So here we are again, right back where we were all those years ago with the utility authorities wanting to take every customer that they can get, make you shut your well down, make you shut your septic tank down, and do everything they can to take over other water systems. So I'm telling y'all, this is going to adversely affect my rural people. Me, I don't want to shut my well off. I want my water. I don't want their water. I want my water. This doesn't affect everybody in here, but it affects us. And I don't think that's Senator Carter's intent. Honestly, I don't. He's my friend. He's my desk mate. But this is written too strong. I'm scared for it to get out of this body. I don't want it past this body. I want it dead today. Okay? This is overreach. And the fact that the notion that the utility authority language was not written strong to begin with, they were given more power than God. It even says in that statute they have sovereign immunity. Okay? They're powerful. They're a political subdivision of the state. And this unbridled power to take over all the water that's not in a certificated area is not what we need. And I'm asking y'all to help me not be forced to shut my well down and go on the utility authority's water, because y'all might have to come to my funeral. Thank you.
Thank you, Senator. Senator, you're recognized.
This has been fun. This is what I will say. All these water issues are not, they're very, very political, and they're very difficult to solve. And the reason why I put a reverse repealer in this bill is obviously we have two senators that have issues. We have a senator from Jackson County. We have another senator from Jackson County. They're on both on opposing sides. One of them made some really good points. But the whole problem, I move passage on one roll call.
Okay. Now, anything, Senator England, for what purpose? Questions on this bill?
Yes, I'd like to make a motion, Mr. President.
Please make your motion, sir.
I move that we recommit this bill to the committee that it came from.
Motion is to recommit. One moment, please.
have to put this.
Okay. Y'all have heard the motion. All in favor signify by saying aye. Aye. Opposed, no.
No!
The ayes have it. Thank you, Senator. Next to 47, I believe, Senator.
Well, considering what just
46.
happened, I'm going to pass on that.
47, Senator Boyd. Senator Boyd.
I'm going to call it up and ask the title be read.
Mr. Clerk, please read the title.
Senate Bill 2523, State Institutions of Higher Learning bring forward code sections concerning.
Make the usual motion.
Usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it, Senator.
I'm going to ask the pages to go ahead and pass out. I'm going to make an amendment at the appropriate time, but just to tell you a little bit about what.
One moment, please.
Okay.
While they're passing out, one moment, please. Senator Tate, for what purpose?
Thank you, Mr. President. Ladies and gentlemen of the Senate, if y'all will direct your attention to the North Gallery, Miss Lauren Skinner, if you will, please stand up. She will be paging for me next week. If y'all will, make her feel welcome.
Okay. One moment, Senator. We're still handing out. 1 second. Okay, let's go.
Okay. Universities and colleges, a number of us have been working with the IHL board for a number of years now, really trying to ascertain the information about the funding formula and really how it's done. And basically, what we know is, and this is a document from a consulting firm that they hired, it's a report from May 2nd of 2025. And the report is done by the National Center for Higher Education Management and Service Systems. And that is called NCHIMS. And you'll hear a lot more about NCHIMS. And some of you have been in the legislature and worked in universities and colleges are very familiar with NCHIMS. NCHIMS is an organization that came in a number of years ago and helped develop a performance-based budget to be implemented by the colleges and universities. And for various reasons, that funding formula was never fully implemented. So since 2012, IHL institutions basically they call it a base plus approach. Since 2012, they have based what is the amount they get is based on what the institution received the year before, with any adjustments made on state budgetary capacity. So if we gave them less, they got less as a system. If we gave them more, they got more. Basically what has happened is now, because institutions have grown in size, they've grown in different missions and all of that, the funding that they receive is in no way relations to the students they're serving, the performances they're serving, or anything of that nature. So we have been asking that they put a funding formula in place that has some applications to what is going on at the university level. So the bill before you, we are continuously working with this organization. The College Board contracted with them. They did a report in May. They came back to them in September, and they are supposed to have something to us towards the end of this month that we can bring back to see. But many of you in here wanted to know a little bit, wanted more of a reason to know what it was going to look like. So what we've done is we've kind of put a bill that basically has an outline. We're not putting in what the metrics are. We're not putting in anything like that. We're simply putting in this bill what a performance-based budgeting model would encompass and it would look like. It has a reverse repealer in here. We are going to be working with everybody on this piece of legislation, and that's probably not what anybody wants to hear, but this is something we have been steadily working on. The College Board is working on it, and so we wanted to put this in here. So this is a reverse repealer in here, but this is what basically a funding formula would look like with guardrails on it, that the things that we would want to see it encompass. So I'm going to go through this, and I don't want to read it. I'm going to read parts of it to you just so that you have an understanding of what this is looking like. Basically, beginning in July 1st of 2029. So this would not take place until 2029. Not less than 75% of all state general funds appropriated for a state institution of higher learning would be distributed through a funding-based model. 25% would just be a general appropriation. With that, the funds that we appropriate as the legislature, separate line items, separate projects, capital outlay, debt service, and all of that would not be included in that aspect of the formula. What are some of the things that the formula would take in place? Would have the base approach of a 25% and then a 75% of the performance-based allocation. The measurable outcomes that you see kind of as best practices in there, it looks at student attainment, degree completion, completion of a baccalaureate degree within 4 years, then one within 6 years. It looks at community college transfers to make sure that those are appropriately incorporated within the funding. It also looks at transfer completions. It also would look at students who also receive Pell Grants or HELP grants. It looks at student progression and persistence towards completion, post-secondary employment or continuing education. It looks at low-income and underrepresented students. It looks at degree or credential production in fields of statewide workforce needs, and all calculations done to use a rolling 3-year average. And that's done in a number of other states, and that's one of the things that we are proposing is done because it creates institutional stability. So if you have something 1 year that's anomaly, it doesn't affect that much. We are telling the Board of Institutions of Higher Learning they need to complete this process by June of 2026, and that when they do implement the process, they've got to make sure that the standards aren't changed before they would have to give them notice before that started counting in those aspects. So it's make sure that we're fair to them. Another thing that we are trying to make sure that we do here is that if someone is not going to meet the minimum performance standards, the IHL should be monitoring them. And if they're not going to meet this, they need to give them notice that they're not going to meet it. They also need to send in an assistance team. They need to help them and offer them help so that they can make sure that they try to help them meet those performance metrics. The funding model will look at the academic and educational revenues and expenditures with that, and the board should continuously monitor this and make sure that they are helping our institutions meet those goals with this. We also have put in a safeguard provision in this that no institution would be subject to more than a 10% loss each year, just to try to make sure that that we are making sure that there's some institutional stability with that. We also are going to require a significant amount of reporting to the legislature on this process to make sure that we are really looking at how this would implement institutions and requiring annual reports. And as this would not take effect until we're looking at what we're proposing is kind of July of 2029, that would give us a really good measure of how this would take effect and come into place. That is a very broad thing, a very broad discussion about what this is, about what the funding formula is. We are not specifying in here any specific metrics. Our institutions all have different missions, and this would allow IHL to make sure that those metrics are accounted for. They also have a different student body. These are kind of best practices that we see across the country that make sure it takes into account those student bodies. So that's an explanation of the bill. It does have a reverse repealer, and we will be continuing to work with NCHIMPS in trying to make sure that we get a fair formula.
Senator Blunt, for what purpose?
Question.
You for a question, Senator?
Yes.
Senator Blunt's recognized.
Thank you, Mr. President. Thank you, Madam Chair. A number of us have been watching this bill. We've been down here 6 weeks. The bill, the code sections in here deal with all the power of the IHL board regarding budgets, regarding funding, regarding personnel, regarding the future of our 8 institutions. And I'm like Senator Seymour and a bunch of other people in here. I'm here every day. I'm trying to read. I'm trying to keep up. And literally 8 minutes ago, we get a handout that proposes to change the funding formula into some performance model for all the 8 universities, and we're just asked to send it to conference. I mean, we've been down here for 6 weeks. This is our 8 public universities and the complete funding and power for personnel and everything else in the governance of those institutions. And we're just asked to send those code sections to conference without any meaningful opportunity to read and understand what the formula is in the amendment that you put forward. Now, why should we vote for that?
Senator Blunt, we've been working on this for a number of years, and we held extensive hearings in December where we discussed all of these aspects. We discussed with entities that had done this and looked at this because we are trying to work with NCHIMPs, and they are supposed to be back with us actually in a week or two. And we have desperately been trying to work with them, work with the College Board, and we've been pushing the College Board on this for a number of years now. So this is, and we will be back again here next year.
Yep.
If we don't have a funding formula, and we're going to be that much more behind, and we're not going to be any closer. We are behind in college attainment in this state. And this will make sure that we put everybody on the same track to do this. So it is not by a lack of effort from myself or my committee in doing this. It is simply, we could have rolled a formula out, Senator, but we are trying to work with NCHIMPs and we are trying to work with the College Board. That's why we have this at this point. So, and we have an outline here of what this looks like as to what a performance-based model would look like.
Well, I certainly don't question your effort on all this, and I know it's been an issue. I'm not on your committee. I don't know who these consultants are, but I'm being asked to vote for a funding formula.
No, sir. You're not.
Well, I don't know what's in it. I hadn't read it. I just got it.
Well,
I mean, what am I voting on? I just got it. I mean,
you're not being asked to vote for a funding formula. What you're being asked to vote for, as I said, the metrics are not in here as to what the funding formula would be. What is in here right now is the best practices of items that will be considered and concluded in a funding formula.
I literally got it 10 minutes ago. I'm trying to listen to what you're saying. I haven't even read it. This is something that the public needs to see. This is something that the 8 universities need to see so they can read us and call us and tell us what they think. And all we had when I got to work this morning was code sections about the entire power and budget and decision-making about 8 public universities.
Well,
what am I supposed to do? Is that adequate preparation for me to just send all these code sections to conference knowing what potentially is at stake?
Well, Senator, that's why we have the reverse repealer on here that we've sent about probably 400 bills with the reverse repealer down there so that we can continue to work the process. This bill is no different.
But I'm not going to see this again potentially until conference, and that's 24 hours.
Well, no, sir. The House would have to send it back to us, and we would have to invite conference first.
That's right.
So you would see it again then, and then you would know, then we would have a conference process if the House decides to send it back to us.
Okay.
So you would absolutely see it again before a conference report.
I would just say there's too much at stake, and to have a bill that is just code sections I'm just not comfortable voting for it. I certainly don't question your effort. I don't have the opportunity to serve on your committee, but this is very important, and we all need more time to review it, in my opinion. Thank you.
Thank you, Senator Blunt. Senator Chisholm.
Thank you, Mr. President. I have an amendment to offer at the proper time.
Thank you, Senator. If you approach the Secretary. Senator Norwood,
Question, Mr. President.
you for a question, ma'am? Do you recognize Senator Norwood?
Thank you, Mr. President. Thank you, Senator Boyd. Senator Boyd, when do we expect to have the review that the College Board is doing now? When do we expect to have that?
So NCHIMPS has told us, and we have continuously been in meetings with them, they expect to have something to us. Basically, it should be within the next week to 2 weeks. Senator Norwood, I am happy. I've been open about our meetings and our processes, and I'm happy to share that once I receive something from NCHIMPS about this. So, and we will be working with them to try to make sure that we get an appropriate funding formula.
Okay, and the document that we received today is the framework for what is to be done. And I guess my question would be, when we get the report, so the report, regardless of what the report would say, it would have to fit into this framework.
I think, Senator Norwood, these are really whatever we get really should fit. These are all the best practices. We've looked at them across the country. These are all the best practices that are in funding formulas across the country. So this is where I kind of wanted y'all to know where we're going with this. And so this is what the best practices are as to, but we don't say, that, like the old funding formula, Senator Norwood, if you were an engineering major, you maybe got more of a credit for that. Or if you were a STEM major, there was maybe more credit. We're not doing any of that. That will all be left to the College Board, and that's all left to NCHIMPS. So this right here is just a framework, like looking at baccalaureate rates, looking at, one of the things we have on there is making sure that they really look at Pell Grant students, because a lot of people, it takes more support to help that Pell Grant student. So usually there's more support offered in a funding formula for that. So those are the type of things that, these are just best practices right now.
Okay, and I mean, I'm not questioning, I've glanced through it,
yeah.
and I see some of the components that we had talked about in terms of the weight for the low income or disadvantaged students, if you will, the non-traditional students. Those are some of the things that I think that we had talked about, and I guess my concern would be is, have we had, will the universities, I know the College Board, their consultants are scheduled to meet with the universities, and will we have their total feedback by the time that we get?
We should have their feedback by the time that we would be looking at something. And Senator Norwood, I pledge to you that I will have a very open meeting as we have more information that is presented to us, but that they should, I know they've already started their meetings I know they have several this week with the universities. They're actually visiting those sites and going through, from what I'm told, 3 different options with them and presenting those options and getting their feedback from them.
Well, would they have an opportunity more or less to present their case to us?
I'm hoping so. That is our plan, Senator Norwood, that they would be here towards, in the next couple of weeks, that they will be presenting it to you.
No, I'm talking about will the individual universities and colleges have an opportunity to present their case, to talk about the impact that it may have on?
I think so. I definitely think so, but I'm also wanting NCHIMPS to actually come and talk to you as well. That is our plan.
Okay, thank you.
Senator Simmons, for what purpose, sir?
Question, Mr. President.
Are you for a question, Senator?
Yes.
Senator Simmons is recognized.
Thank you, Mr. President. Thank you, Senator, for yielding. Senator Boyd, I'm not on universities and colleges, and during your presentation, you said my committee. Were you talking about the universities and college committee? Okay. Are you working, or have you worked with someone else other than universities and colleges in bringing the proposed language before us?
I've worked with actually a number of people.
Okay.
A lot of what we're relying on came from really a lot of conversations with Tennessee. because that seems to have been that has seemed to have been very effective for all the colleges and universities there. So I've looked at them. We've been talking with them. We've looked at Florida. I've worked with national groups looking with this. And this is bottom line is we were doing a deep dive just to know what are best practices? What are the things that people see move the needle? And what are those outcomes?
And what you have proposed and what you continue to speak of as best practices, do they take into account what we have had as challenges in the state of Mississippi regarding the funding of our historically black colleges and universities?
Well, they all have had challenges with the funding of historically black colleges, particularly across the South. This really kind of takes into, because what this really looks is outcomes, and you're really looking at the students, but you're giving heavier weights. And we specifically articulated out some of those students that are I'm going to say the most expensive and the most challenging, but also the most rewarding to get through. And so what it does is, in a lot of those other states, it really gives a stronger emphasis and gives a stronger weight on those students. So what you would do is it would actually give you more dollars when you find one of those students that has those criteria. So, yes.
And of course, like one of the calls I received was that there may be a wait, and I have not had an opportunity. So I'm like,
I have not listed any weights.
Okay.
That would be up to IHL. That would be up to the College Board. We have not articulated any weights on this. This is kind of like guidelines, but it is not a weighted formula at this point.
in this building over the last couple of years, we've had proposed legislation regarding the closure of some of our institutions of higher learning. What do you say as it relates to, is the funding formula or these best practices that's being proposed that will later result in maybe a funding formula coming back for an up or down vote in a conference report? Is it an intent to close the W?
No.
Is it an intent to close Delta State University? No. Is it an intent to close Mississippi Valley State University?
No.
Is it any intent to close any one of our historically black colleges and university who are there and serve a great and valuable asset to students not only in Mississippi but also in this country?
I will not be presenting to this body a bill during this process and this funding formula. I can say that. I won't be presenting any bill that closes a university.
My last question. Can I get your commitment in light of the history in the state of Mississippi, and I'm speaking about heirs, that whatever you bring back to this body will take into account the historical underfunding of our historically black colleges and university, and if this deliberate body decides to do something going forward, that we don't have to look at possibly filing a lawsuit because our 3 HBCUs are underfunded under whatever scheme that comes back?
Yes, I'm not, and let me say this, you brought up just a question. When we look at this funding formula, we're looking at the student. And so we have made sure that students that are typically, that you're serving, like the Valley, for instance, Mississippi Valley University, State University, I'm tongue-tied up here. It has the second largest amount of Pell Grant students in this country at a university. So we made sure that when in the guidelines that we put here, that we think that that specifically should be taken into account. Delta State has a large number of Pell Grant students as well. Those are things that we know from the work that we've been doing is those children, those students, they need a little bit of extra hand-holding. They need a little bit more wraparound services to make them successful. And so that's why we have included this. That's why we detailed this in that formula, with those things in mind.
And do we know, and this is my last question, do we know, will this result in an increase of funding to our institutions of higher learning, all 8 of them, or would it result in a decrease? Do we know that?
I think, I don't have an answer.
Okay.
We will have to look and see when a formula is done with all those weights and metrics and all of that. I can't tell you. I was very surprised to look and see at Tennessee's, like what they did, and I looked at their money as they progressed through that. And so I can't answer that. That's one of the reasons we want to work with NCHIMPS, is to see what this looks like.
Thank you so much, Senator Boyd. Thank you, Mr. President.
Senator Barnett,
Thank you, Mr. President, for a question.
you here for a question, Senator? You're recognized, Senator Barnett.
Yes, sir.
Thank you. Senator Boyd, when did the information that you passed out, that you handed out to us, when did you become aware of this information, or when did you get this information?
Well, I didn't get the information. I had to, I have been working on this information, and I thought I would have more information possibly from NCHIMPS. When we passed brought forth the code sections the other day, I had hoped that I would have more information from NCHIMPS or the College Board. And so we have been steadily working on this and working at what these guide rails would be. And I've been working continuously on this. And so this is something I was running through to make sure that we had listed. We've been working on it and really we have been working on this continuously.
So you just finished it about 30 minutes ago?
No, sir. I finished it yesterday, but then I was making sure that the language I put in there was correct, and so I've had Corbin look at it, and I wanted to make sure that the language I put in there is what the funding was and all of that was correct. So
that was confirmed about 30 minutes ago?
It was what?
So that was confirmed about 30 minutes ago before we got
No,
the
sir, it was
handout.
not confirmed 30 minutes ago. I confirmed that yesterday, but we've been looking over it and reviewing it.
Okay. And the reason why I asked that, because, I'm sure that most of you can look around your desk in here and can see information that was distributed by several different legislatures in regards to legislation that they were proposing. And the reason that we do that is because we want to let the members have an opportunity, give the members opportunity the time to look over the proposed legislation that's coming, especially when we think that it's something that's very important or that they should know about. So my question is, if this was the case with the handout that was given to us about 30 minutes ago, why wasn't this placed on our desk this morning so that we could have the opportunity to thoroughly read it, to have an opportunity to look through it, talk to our colleges and universities, get their opinion on it, find out how they felt about it? So this is my question, Senator, because this is like a rush to us, and this is very serious. We're talking about colleges and universities here in the state of Mississippi, where most of us attended. And I think that if this was something that was handled on yesterday, and we knew that it was going to be taken up today, I think it should have been on our desk this morning again, so that we would have had time to research this versus 30 minutes ago and acting to vote on it right now. So can you answer that for me, Senator?
Senator, I've explained it. I don't think I can explain it any more than I've just explained it.
But I don't remember.
Senator, in a courtroom, it's called asked and answered.
Ma'am?
In a courtroom, if I was in a courtroom, it would be called asked and answered.
Okay, well, I asked, but I don't remember an answer.
I think I replied to Senator Blunt with the same answer.
Okay, thank you, Senator.
Thank you, Senator. Senator Wiggins,
Introduction out of order, Mr. President.
please proceed.
Thank you, Mr. President. We have in the South Gallery with us Ms. Candace Jones and court reporters from the Mississippi Court Reporters Association. If they please stand, and let's give them a big hand.
Senator Isom.
you, Mr. President. In listening at, your presentation, I just wanted to know, since we don't have the matrix and all, would you not want to table until we got the adequate information that we need in order to present?
Senator Isom, we have been, no ma'am, absolutely not. And I would oppose that. We have been working on this and trying to work with the College Board. It is great frustration to me that they don't have a formula and didn't have a formula this fall that we would come back to you with. But we have continuously tried to work with them and do that. And we are still in the process, and it's still a very long day to sine die. So I absolutely don't think we should table this, and we should continue doing this and keep working with them to try to get something that will help our students.
Like you're saying, since we have tried numerous times and they're not cooperating or working with you, then what is your resolution to getting what you need in order to make this adequate and whole?
I think we are doing that right now by making sure that we are coming forth with guidelines to a funding formula, and we are putting a date specific that we are putting legislation in place that they are going to have to do a funding formula. This legislation says that they have to do a funding formula by June 30th of this year.
Thank you.
Thank you, Senator. Seeing no further questions, Senator? I think you have an amendment, right?
Yes.
Okay.
Move to adopt the amendment.
All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it.
Move to adopt the bill by the use of the morning roll call.
We have I think Senator Chisholm had.
Sorry.
One moment. We have another amendment, I believe.
I'm sorry.
Senator Chisholm.
Thank you, Mr. President. Thank you, Madam Chair. This amendment is very simple. I've brought it to the floor before, and all I'm asking for is registered sex offenders not to be allowed to live on the campuses of the colleges. A person subject to the registration requirement under sections 453321 through 453363 may not reside in a dormitory or other student living accommodations located on the campus or managed by the state institution of higher learning. The reason I'm asking you to vote for this amendment is because this is a common sense idea. The annual Clery Act report, which tracks sexual assaults on college campuses, shows that there are multiple rapes on college campuses in Mississippi each year. This amendment will not cost our universities one dime. It will only increase public safety. It will increase public confidence in the law. It is law enacted in other states. It is constitutional. If you have a child or a grandchild at a Mississippi higher ed institution, you will want to vote for this amendment, I would think. I have grandchildren. I have a granddaughter who will be going to college in one more year. She graduates this coming December. And I'm very concerned about registered sex offenders living in the dormitory where my granddaughter could possibly be living. To explain why we need the amendment, I'm going to read some of the offenses in the current law that makes a person subject to registration as a sex offender. I hope this list convinces you, and I won't read all of it because there's a lot of them on here, but I hope it convinces you to vote yes on this amendment. Sex offender or registerable offense means any of the following offenses. Section 97.353 relating to kidnapping if the victim was below the age of 18. Section 97.365 relating to rape, however, conviction or adjudication under Section 97.365 when the offender was 18 years of age or younger at the time of the alleged offense shall not be a registrable sex offender. Section 97.371 relating to rape and assault with intent or ravish. Section 97-395 relating to sexual battery. However, conviction or adjudication under Section 97-395 when the offender was 18 years of age or younger at the time of the alleged offense shall not be a registrable sex offender. Section 97-55 relating to enticing a child for concealment, prostitution, or marriage. Section 97-523 relating to the touching of a child, mentally defective or incapacitated person or physically helpless person for lustful purposes. Section 97-527 relating to the dissemination of sexually oriented material to children. I have another page that goes on and on. I don't want to bore you with it, but I'm asking you, if you have children or grandchildren that are college age or going to be college age, please consider this amendment, because it's only for the protection of our children and others. We have neighbors that have children and grandchildren that we love as much as our own, and it's to protect them too. If there are no questions, I ask for adoption of this amendment.
Thank you. Senator Boyd, you're recognized to speak on the amendment. Senator Boyd, you're recognized to speak on the amendment.
No objection to the amendment.
Thank you very much. All in favor signify by saying aye. Aye. Opposed, no. The ayes have it. Senator Bryan, for what purpose?
I'd like to speak on the bill.
Okay, we're back on the bill. I believe we have it as amended. Senator Boyd, let's go. Senator Boyd. Senator Norwood, for what purpose?
I had a question, Mr. President.
On which one? For Senator Boyd?
Yeah,
We're back on the bill now.
I'm sorry.
Well, it's my question. That's fine.
Okay, thank you very much. Right, we got, I know, Senator Bryan's first.
Like the rest of you, I've been reading the underlying language hurriedly, trying to see exactly what it did. All I know for sure is it uses a lot of lingo that I don't understand, and I frankly doubt any of the rest of us do. But I can't figure out anything that funding is based on, and these metrics are based on, other than attendance and advancement from grade to grade in graduation. I can't find anything in here that tries to measure whether the students have learned anything or not. I think about measuring education, which is difficult to do. There's some specific things you can measure. You can measure ability to read, ability to do math and all. It's harder to measure ability to think. But also there's the question of what sort of students do you have? And again, I'll quote the guy from Harvard a number of years ago who said, the reason our graduates do so well is we're so careful about who we let in here in the first place, and we don't do too much to mess them up while they're here. And, you know, I don't see anything in here that measures how well people have learned. If you really want to know what's going on in a school or an institution, you look at a bunch of different, or the economy, you look at a bunch of different metrics, and when you put them all together, you have a picture. And I say that to say that the measures of student retention and the graduation rates are very important metrics, but they're not the only metric. And if you think about it, if what you're measuring is a graduation rate and that in and of itself, you're rewarded, or the institution is rewarded for lowering the graduation standards so that it's easier and easier to graduate, and there's no reward or measurement, again, as to whether the students are learning anything. I don't know what this does. I don't think any of us know what it does. I don't know what the effect is going to be on the 8 institutions. If the amount of money stays the same, and there's a different formula, then some institutions have to be winners and some institutions have to be losers. It would be good to look at that and know who's winning and who's losing and why. I just have misgivings about this bill, and I've outlined some of them, but I would just ask you to read the language about metric this and outcome that and see if you can make any sense of it, because I sure can't.
Thank you, Senator Bryan. Senator Sparks, you want to speak on the bill?
Yes, Mr. President.
Senator Sparks is recognized.
Thank you, Mr. President. I was not going to speak on this bill until it came back and we had final language, but based on some of the questions, I want to be very fair with what we're doing. Labor Force Participation Rate Committee met with all 8 colleges. It's all recorded. You can go watch it. And the question is, what's your mission? And it stumped them. They told me what their mission was at their founding. Well, I appreciate that that was your mission. If it's still your mission, that's fine. What's your mission today? How are you serving the students? And they've tried to work on that. The IHL in 2012 hired NCHIMS, and they did develop a budget, and it never got implemented. A lot of interference was there, some from this legislature, but the fact is it didn't get implemented. And now, 15 years later, we're going to pay $292,000, these are the board minutes, if y'all want a copy, October 16, 2025, to the same company to do the same study. So we're going to pay them twice and implement none. That's not good government. They have interviewed all the institutions. They've actually interviewed me. I'm sure they would interview you. Senator Harkin's hand went up. So if you want to talk to NCHIMS, I encourage you. I'll get a number for you. Nobody wants to do anything that's not out in the open, but at the end of the day, the focus is not on the institution. It's on students. And as I told the regionals, if your student outcomes are good, your institutional outcomes will be good. We listen to the issues that some of our entities have, that they come from low-income families, they come from difficult school environments, et cetera, first-time students. We want NCHIMS and the IHL to take all of those things into consideration. And Senator Simmons asked a question about how much more money or less. That's going to be up to the appropriators. But I can assure you this, if you get accountability, transparency, and return on investment, this body is more likely to vote for more money. But if all you're going to do is study it every decade at the cost of $300,000, I don't support that. Every time we ask them a question, they talk about enrollment. There is a very difficult conversation to have about enrollment in the state of Mississippi, because we have institutions that are subsidizing in-state students by charging out-of-state tuition, and that's a good thing. I like it. You want to come from Georgia, Texas, Tennessee, come on down here. But you're going to pay out-of-state tuition. The problem is some of our institutions believe waiving out-of-state tuition is the way to draw more students. We will then, as the taxpayers, be subsidizing out-of-state students. So that's a metric I want them to talk to our partners in the university world about, because we want them to be financially viable. So I know you didn't get this paperwork till just a few minutes ago. You can go watch the labor force participation rate hearings from last year, 2 years ago. You can watch the universities and colleges meetings. A lot of your questions have been brought up. You could watch JLBC, where the IHL presented something, but I can assure you I didn't understand it. So what I'd like to ask you as this body and members and alums, as we move through this process, ask IHL what they're doing. It's their job. They got constitutional protection to do great things or to do nothing. I can tell you what they did. For sure, They got my language stripped out of the appropriation bill last year that asked a lot of the questions you're asking. But you can go to last year's appropriation bill, 2001, and I would refer you to section 17, because this says the Mississippi Performance Budget and Strategic Planning Act of 1994. That's been in their appropriation bill every year, and it has these metrics. Performance measures is what is in our appropriation bill you vote for every year, and I don't have a clue if they're meeting these measures. But you can also go to section 47 for the part of my language that didn't get stripped out. And it required them to talk about the methodology, calculation, and distribution of general and special fund monies. Tell us, what do they need? Where's the money coming from? Report on population shifts. We have a declining birth rate. Tell us how we're going to meet that enrollment cliff. Report back to us on graduation rate disparities. I can tell you what I got back, they don't want me grading like a college professor, because it wouldn't have got a passing grade. So when people say this has happened too quickly, it's happened too slowly. And right here's the 28 pages from NCHIMS that's to the commissioner of the IHL dated May 2nd of 2025. So I want to be very transparent. I support this bill. It's not a finished product, but I want to be very clear. No one is doing anything fast. We're moving like a turtle. And it's time for the IHL to put up or shut up, because this body will appropriate money, and if they can't deliver a funding formula, we have a duty to do it, and everybody in this room has a say in it. Thank you, Mr. President.
Thank you. Senator Boyd, you're recognized.
Move to adopt the bill on final passage by the use of the morning roll call.
Use of the morning roll call has been requested. Anyone object? Senator Bryan objects to the procedure. Please call roll.
Barnett, Barrett, Berry, Blackman, Blackwell, Blunt, Boyd, Brumfield, Bryan, Butler, Carter, Chazanall, Chisholm, DeBar, Delano, Dupree, England, Fillingane, Frazier, Gillespie Isom, Harkins, Harkness, Hickman, Hill, Hobson, Jackson, Johnson, Johnson, no. Kirby, Ladner, McCon, McClendon, McMahon, Michelle, Mumford, Norwood, Parks, Pope, Rhodes, Seymour, Simmons of the 12th, Simmons of the 13th, Sparks, Suber, Tate, Taylor, Thomas, Thompson, Turner Ford, Whaley, Wiggins, Williams, Younger, Barnett, Berry, Blackwell, Brumfield, Dupree, Fillingane, No. Okay. Voting yes or yay: Barnett, Berry, Blackwell, Boyd, Carter, Chazanall, Chisholm, DeBar, Delano, England, Harkins, Harkness, Hill, Hobson, Kirby, Ladner, McCon, McClendon, McMahon, Michelle, Parks, Rhodes, Seymour, Sparks, Suber, Tate, Taylor, Thompson, Whaley, Wiggins, Williams, Younger. Voting no or nay: Barnett, Blackman, Blunt, Brumfield, Bryan, Butler, Dupree, Fillingang, Frazier, Gillespie Isom, Hickman, Jackson, Johnson, Mumford, Norwood, Pope, Simmons of the 12th, Simmons of the 13th, Thomas, and Turner Ford. Yes, 23.
Vote of 32 to 20, the bill passes. Senator Fillingham.
Thank you, Mr. President. I'd like to go to item 48, call it up and have the title
Mr.
read.
Clerk, please read the title.
Senate Bill 2339, firearms, criminalized possession of by certain persons and order removal after a hearing with a specific finding of risk.
Mr. President, the motions can be to recommit, and I would like you to recognize Senator Wiggins to explain.
Senator Wiggins, you're recognized to explain them.
Thank you, Mr. President. And Mr. Chairman, I'm not going to be long. And as the chairman said, this bill, the motion is to recommit. But I'm standing before you on this bill because I know that members of this body have received an alert from the NRA. And yes, Bryce Wiggins, a Republican, is sitting up here talking bad about the NRA. This bill before you is for domestic violence and supported by domestic violence survivors, advocates, and people who understand that domestic violence is an epidemic in the state of Mississippi. If you don't believe me, you can do a quick search. In 2022, 45 homicides occurred. 78% of them were firearm related. In 2024, 80 incidents that resulted in 100 deaths. 300 Mississippians died from domestic violence homicides between 2020 and 2024. Mississippi has the highest overall gun death rate in the country. Now, this bill is based on the U.S. Supreme Court case of Rahimi. And I want to appreciate the attorneys who provided this information. Rahimi was decided in 2024 by the U.S. Supreme Court appointed by President Trump. The most conservative Supreme Court upheld the federal law. That they overturned the Fifth Circuit, which is our federal circuit, which is known as the most conservative court of appeals in the U.S. And what did the U.S. Supreme Court say? They said that there is a long-standing historical tradition of temporarily disarming individuals who pose credible threat to others, as long as there's due process. And this bill had due process. When I took an oath and I put my hand on the Bible and took an oath, my oath was to faithfully support the Constitution of the United States and the Constitution of the state of Mississippi and obey the laws thereof. The U.S. Supreme Court, in an 8-1 decision by President Trump's court appointees, upheld the exact federal law that this bill did, but does it on the state level. And let me be clear, I am not at all saying that anybody in this body is responsible. But what I am saying is that when somebody like the NRA sends out an alert and we're going to dock you, or we're going to run a commercial against you, in the meantime, because you're going to vote one way or the other, I think we've lost common sense. And the reason I appreciate the chairman working with me on this or bringing the bill up is because we need to have this discussion in Mississippi. And we're going to recommit this bill, and we're going to work, at least I am, to get us something that could actually be good for the citizens of Mississippi and not violate. And by the way, this bill doesn't do that. I've been an NRA member in the past, voted for every Second Amendment bill that's come along, but we've got to have common sense in our laws. And I look forward to that next year. And so, Mr. President, the motion is to recommit.
All in favor signify by saying aye. Opposed, no. The ayes have it. Thank you, Senator. Senator Fillingham, you're recognized.
Thank you, Mr. President. I'd like to pass items 49 and 50 and go to item number 51.
49, 50, retain their place on the calendar. 51, Mr. Clerk, please read the roll.
Senate Bill 2416, law enforcement officers entitled to certain follow-up drug testing before loss of certification.
I make the usual motion.
Usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed.
Mr. President, if you recognize Senator Sparks, stand on the
Senator
bill.
Sparks, you're recognized.
Thank you, Mr. President. Senate Bill 2416 is a bill we've passed on multiple years. It's a request of Police Benevolent Association. It simply allows an officer who is MLOTA licensed, certified, that if they have a negative drug test, in other words, if they're accused of drug use in violation of the policies or state law, upon a urinalysis, they're afforded the opportunity to go get a more invasive test, a more reliable test, to refute that test. Often with a police officer, if they're involved in a car accident that's not their fault, they're drug tested. These things are out there. There's so many different things that people take, supplements, other items. We just don't want anybody losing their license, to be a law enforcement officer on a false positive. So they have the right to go obtain the test in a very short period of time, as the bill lays out, at their own expense. And if it comes back as an actual negative, the first test is deemed a false positive, and they would be reimbursed for the cost of that. One of the reasons I think this bill is more important this year is because last year we passed good legislation to make MLOTA be able to have the ability to take the certification of a law enforcement officer under more broad circumstances. So we just don't want somebody that it's not justified losing their certification. That's an explanation of the bill, Mr. President. I'd yield to any questions.
Okay, Senator.
I yield to any questions.
There's no, I'm sorry, there's one question. Senator Blackman, I apologize, I was just looking. Senator Blackman, for what purpose?
Question, Mr.
Will you yield,
President.
Senator?
I yield.
Well, please proceed.
Why should, if they get a failed urinalysis test, they should be on paid leave until they get the second test?
Well, the time frame is such that it's 2 days from the notice that they receive that they've got to say, look, I'm going to go get a test. And within 5 days, they've got to deliver those test results. So it's a 7-day period. This is language, obviously, that the Police Benevolent Association preferred, so that's why it's the language it is.
Well, I understand that they get the second subsequent test, but if they fail a urinalysis test, shouldn't it be unpaid leave until it's confirmed that, all right, this was a false test? Because it could still be a positive test, but they got paid an extra week knowing that they were going to get fired.
I understand that, and I'm not going to say that everybody's got leave time built up enough that, you know, we capture that. I think my big concern is simply that if I'm testing positive for a drug and I know I hadn't taken it, I'm going to go get that follow-up test. If I know I have, I'm not going to go waste the money for that, and I'm going to end up, because 2 days, if I don't tell you I'm going to go do it in 2 days, then that's it. I've got to, you know, once I get notice, I got 2 days to report that back to you. So it's really a 2-day issue, because if you tell me you're going to go get the test and you know you're hot, you probably ain't going to go get the test.
Or you know you're hot and say, let me get an extra week of pay before I get out of here.
That's fair.
Yeah. So would you be opposed to amendment saying that it's unpaid leave?
I guess I would approach it this way. I don't have an issue with what you're saying, but I would ask, if you're going to amend that, then amend that they would be eligible for the back pay if it's a negative test the second time.
Yeah, I wouldn't have an issue with that.
I'll tell you what I'll do. Would you like me to put a reverse repealer in the bill?
Yeah.
Instead of having you go get an amendment?
Okay,
Okay. Yeah. If I could, Mr. President, just enough time to get a reverse repealer before the body, and
one moment, please.
Mr. President, okay. Mr. President, the question would be, if we pass this and Senator Blackman holds it and we can amend it to get the language right instead of putting a reverse repealer in it, that would be what I think we prefer.
Well, it's your motion, sir.
Right.
It's your bill.
Thank you, Mr. President. Then I would ask that we pass this using the morning roll call.
Do we have an amendment at all?
The understanding is we pass it today, Senator Blackman can hold it, and then we can fix the language and get it right and send it out the way it is.
Okay, so there's no amendment.
There's no amendment.
Okay. Use of morning roll call has been requested. Anyone request, object to that procedure? According to voting, no. Present? Simmons, no. Turner Ford, no. Anyone else? Anyone else? Seeing none, bill passes for use of morning roll call. Two negatives, Simmons and Turner Ford. Present, I'm sorry. Brumfield, no. Present, I'm sorry, present. I didn't call present, my bad. Anyone else on present? Seeing none, the bill passes by use of morning roll call. Senator Simmons.
Mr. President, may I hold that bill in a motion to reconsider?
Motion to reconsider. It's usually made at the end, Senator. We'll note now. All right, Senator Simmons.
Thank you, Mr. President. I go to item number 52 on today's calendar. Call it up and have the title read.
Mr. Clerk, please read the title.
Senate Bill 2118, Jail Docket requires sheriff to include certain information about incarcerated persons awaiting trial in.
I make the usual motion.
Usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it. Please proceed, Senator Simmons.
Thank you, Mr. President. Actually, we recognize Senator Turner Ford to explain.
Senator Turner Ford, you're recognized.
Thank you, Mr. President. Thank you, Mr. Chairman. Senate Bill 2118 proposes to require sheriffs to provide copies of their jail dockets in advance of the monthly meeting of the boards of supervisors, simply for the fact of making sure that the supervisors are aware of inmates, the length of time that they've been retained, as well as the arresting agency responsible for effectuating their arrest. I will yield for questions. Hearing none, I move adoption by use of the morning roll call.
Any questions? Seeing none, use of the morning roll call has been requested. Anyone object to that procedure? Court is voting no. Present. No. Sparks? No. Harkins? No. Hartness? No. Boyd? Anyone else? No. Hill? No. Rhodes? No. Barrett? No. Seymour? No. McClendon? No. McMahon? No. Whaley? No. Chisholm? No. Berry? Where is he? Oh, no. Taylor. I'm sorry, I couldn't see through the window there. Phillingain? No. Blackwell? No. Williams? No. McCon? No. England? No. Ladner? No. Suber? No. Carter? No. Anyone else? Anyone else? Kirby? No. Anyone else? Anyone else? Senator Delano, for what purpose?
Vote to the vote.
What?
I vote no.
No. Delano. All right, we're getting close. Twenty-four no vote, the bill passes. Thank you, Senator Turnford. Okay. We go to Senator Simmons. Pass and retain Senator Tate. Senator Tate. Pass and retain Senator Johnson. Senator Johnson, we're on 56.
Thank you, Mr. President. I'd like to go to that item and ask that the title be read.
Mr. Clerk, please read the title.
Senate Bill 2769, Home Upgrade Revolving Fund established within the Mississippi Home Corporation.
I make the usual motions.
Usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed.
I'd like to be recognized to explain the committee substitute in lieu of the original bill.
You're recognized to explain.
Thank you, Mr. President. During the course of the last year, we were tasked with a special committee on housing to look at where some areas of the state have a shortage of supply for what is deemed as a starter or entry-level home. We had a committee meeting regarding this and several follow-up meetings, and what we found is that the number or the top reasons why there's an uneven demand for the supply right now in many markets of Mississippi have to do with two things. Federal decisions that have driven up the cost of inflation, cost of everything, rising cost of taxes and insurance, and thus the price of homes has gone up. That's coincided with land prices. And then we also find that in some local areas, for any number of reasons, there's different zoning. That could be based on infrastructure or any number of other reasons why there may be limitations on the minimum square foot or minimum lot size, which obviously would affect the size of home you can build. Those factors are not in any way related to the state, and so we looked at ways that maybe the state could interject into the market and do the minimum amount of harm, but hopefully help provide more housing supply for that market. What we came up with was a plan to offer a revolving loan fund through Mississippi Home Corp that would be subject to appropriation, and we leave it wide open for it to be A, appropriated, and B, to the amount it would be appropriated if
if we choose to do so. As part of that, we defined what a starter home is and related it to the median income of a geographical area, so a city or a county, to try to give for latitude to different parts of the state where home prices may be higher or lower. The loan program would be a very short-term loan, and the idea would be to help homeowners who are looking to sell their home that would fit in that price range be able to have a small loan for a period of 6 months with a 3-month extension under certain conditions to do repairs to the home that would make it marketable and lendable to the most people in that home price. And so the bill before you is an attempt to do that. I can tell you that we are continuing to look at this and work on it, and so it does have a reverse repealer in there. I would ask for your indulgence as we work through the progress to see if this is a route we truly think would be beneficial to the state or not, and then come back later if it's something that we think we can move forward with for your approval. And with that, I'll yield to any questions.
Excuse me, we have a couple. Senator McClendon, what purpose?
Question, please.
You yield, Senator McClendon.
Yes.
Senator McClendon, you recognize.
Thank you, Mr. President. Thank you, Mr. Chairman. In certain parts of the state, I think you need to add one more factor to your list of corporations that are buying up affordable homes that could be listed as starter, older, whatever they may be, anything under well, in our area, $350,000 price below, and renting them. And no matter what you do, if you put an offer down, somebody's going to come in and put a $25,000 or $50,000 on top of it. Now, certain states have done legislation to stop these corporations from doing it, well, at least slow them down by possibly losing tax credits that they may have. Is that part of...
That's not part of this bill.
Would you be inclined to add that?
I personally, I mean, that would be up to the body. I am personally not in favor of those types of legislative acts. I think that I do see a problem in some areas with that, but I think that the reverse can also happen. Markets change. I think when anyone, especially a private equity firm or a corporation who is trying to upload a bunch of properties in one geographic area, also takes on a large risk. We saw that here in the city of Jackson. So a couple of years ago, in an area of Jackson, there was one corporation who had 100 plus homes, and after some water issues and other issues, they decided to unload all of those. That caused a depressed price in the area, and so the complaint was the opposite. Our home values are dropping because there's so many homes on the market at a lower price. So that was a risk by that corporation that did that, and it drove the market down in the opposite direction. So I think
that was in Jackson?
It was in Jackson, yes. And so I think
that was the reason that the prices went down?
In one particular area, that was the case. And so I think that that's a risk that anyone who overpays for a home today takes on. I think right now we're currently seeing, as a national average, this varies based on location, home prices are coming down. I think there's multiple articles that have been out lately in Wall Street Journal and other periodicals that will point to the drop in home prices across the country. So I think you're seeing potentially a little correction in the market, and I think that will the market will cure that to some extent.
But with those prices coming down, aren't we just making it, or that's making it easier for these large corporations to buy these homes? And you know, a lot of people don't realize that a lot of these sports pro contracts are tied to rental properties. You know, they diversify these contracts to where these young athletes may get 100 rental homes And, you know, we've got an issue where we live, where Senator Blackwell, where Senator Isom, Senator Jackson represent. And the issue is it's affecting our municipalities. All these people used to live in municipalities. And with the rental homes now, the people aren't as vested in that community.
Yes.
And those people are now moving to the county. Well, then what in turn happens? Now we've got municipalities trying to annex these people that have left these cities because of this very problem. And I would like to offer an amendment at the proper time.
At the proper time, yes, sir. Please prepare it. Senator Williams, what purpose?
Question, Mr. President.
Yes.
You yield?
Yes, sir.
Thank you,
Senator
Mr. Chairman. Thank you, Mr. President. I think I understand this. Did you say that this is trying to provide a low-interest loan for sellers that are preparing to sell their homes so they can fix them up and probably get maximum value?
Not just get maximum value, but put them on the market in a marketable way. So certain loans require that your if you have a fuse box, that it be upgraded to a breaker box, or certain windows and doors. And so the idea, or an HVAC system or roof, the idea is for things that would help a home in this certain market price range meet more lendable opportunities, and also be appealing to buyers that would be looking at that priced home.
Increase supply.
And try to get them on the market quickly. So it's tied to a person who is interested in selling, and this little change can help make it more marketable.
Would it just be a very low interest rate? Is that the benefit that they would get, and probably qualification where it be, as you said, more difficult?
Yes, and I tried to write it with a minimal cost on the front end also. And so, you know, again, it is geared for someone who is ready to list their home for sale and has licensed and insured contractors that have already given them bids on what they're going to do. And so it's designed to be ready quickly, out the door, and hopefully turn over quickly.
Just one last question. Is the loan tied to the property as far as collateral?
It is. It will be secured with a deed of trust on that property. Obviously, and there's some conditions that the total loan amount on that property can't exceed 85% of the value, that the loan is capped at $30,000. Most likely in most of these, I would assume it would be a second position. It may not be, but most of them would likely be a second position.
It makes sense. Thank you for your work on this. This is an area that we need a lot of help. Thank you.
Thank you.
Okay, I see no further questions. Senator, you move for adoption of the committee sub?
Yes, sir.
Senator moves for adoption of the committee substitute. All in favor say aye.
Aye.
All opposed, no. The ayes have it. Committee sub's adopted. Now we have an amendment. In just a minute, we have an amendment. Okay, Senator McClendon, you're recognized for an amendment.
Thank you, Mr. President. Like to read the amendment?
Yeah, if you want him to read the amendment, you request it be read.
I'll speak on the amendment.
You do want the amendment read? Is that what you asked?
Yes, please.
Okay.
Amend line 301 by inserting section 1 and 2 of as new sections and renumbering the subsequent section.
Okay, Senator. Okay, Senator McClendon, you're recognized.
Speak on the amendment.
You're recognized to speak.
I was part of that study committee this summer, and there were loan officers, there were real estate agents. As a matter of fact, the Mississippi Association of Realtors is for, this is the bill I had that it didn't make it out of committee, but Mississippi Association of Realtors is for this. There is an issue in Mississippi with homes being bought by hedge funds, national agencies that are buying homes and renting them, and they're going into every municipality and they're buying up homes. And what this, it's a simple amendment. What this does is, if a corporation comes in and owns more than 50%, what Section 1 does, this act shall be known and be cited as the Stop Predatory Investing Act of 2026. It's the intent of the legislature to prohibit large institutional investors from buying multiple single-family homes and destroying property values and neighborhood integrity and characteristics. With respect to any taxable year beginning with the year ending December 31st, 2026, in the case of an institutional real estate investor who owns directly or indirectly 50 or more single-family residential rental properties, no deduction shall be allowed under the Mississippi income tax law for any interest or depreciation accrued in connection with any such single-family residential rental property. This disqualification in this subsection shall not apply to a sale to an individual for the use of the principal residence of the individual or to a sale to a qualified nonprofit organization. The deductions prohibited under this subsection shall not be applicable with respect to any property which is constructed by the taxpayer or acquired by the taxpayer after its construction, but before the first date on which any dwelling unit in which the property was occupied by a resident. For purposes of this subsection, institutional real estate investor means large pension fund, insurance companies, university endowments, asset managers, and real estate investment trusts, which invest over $1 million annually to generate returns and stable income for beneficiaries and include all legal, corporate, or partnership limited liability entities. Qualified nonprofit organization means any organization which is not organized for profit and has a principal purpose for creation, development, or preservation of affordable housing. Folks, if this can happen in DeSoto County, it can happen to you. And it is happening everywhere. And it's an issue, and it's a way to stop the issue that we have of young people not being able to be first-time home buyers. It's also effectable with taxable year ending 2026, any income tax levied under this chapter and any deduction allowed under this chapter will be in compliance with the provisions of the Stop Predatory Investing Act of 2026 provided in the Senate bill.
prohibits institutional real estate investors from purchasing large parcels of single-family properties and taking tax deductions. And that's the amendment, and I'll be happy to answer any questions.
I see no questions, Senator. Senator Johnson, would you, are you finished, Senator?
Yes, sir.
Okay, Senator Johnson.
I understand and hear what Senator McClendon is point is and the problem that it is in DeSoto County. I do want to make a point of order that I don't believe it's germane because it does deal with tax credits, and this bill is not a revenue bill and does not have tax credit language in it.
Okay. According to our legal staff, the point of order is well taken. The amendment is not germane. Senator Johnson.
If there are no further questions, I would move adoption using the morning roll call, knowing that this has a reverse repealer and it is a work in progress. And if we come up with something that is worth bringing back to the body, I will present it as we move forward.
Okay, I see no questions. Senator suggests you use morning roll call final passage. Any senator object? Any senator wish to be recorded as voting no? Senator Chisholm, Senator Hartness, Senator Hill. Anyone else? Seeing no others, please record all others present by the use of morning roll call as voting aye, and the bill is passed. Senator England.
Thank you, Mr. President. I'd like to skip item number 57 on today's calendar and go to item number 58 and have the title read.
We'll pass and retain item 57. Go to item 58, Senate Bill 2587. Please read title.
Senate Bill 2587, absentee ballots, remove envelope requirement, and amend other process related to.
Thank you, Mr. Clerk. I make a usual motion, Mr. President.
Senator makes a usual motion. All in favor say aye.
Aye.
All opposed no. The ayes have it. Senator.
Thank you, Mr. President. Ladies and gentlemen, if I can get your attention for just a minute, I need to call up the committee substitute on this bill and ask you to vote against that. I do have a strike-all amendment that I will be submitting right after that. So my motion is to adopt the committee sub, and I ask you to vote no, please.
Motion is to adopt the committee sub. All in favor say aye. All opposed no.
No.
Committee sub has failed. Coming back to the bill.
Thank you, Mr. President. I have an amendment. It's a strike-all amendment that I'd like to explain, if we can get that up. Thank you.
You're recognized to explain.
Thank you, Mr. President. What the strike-all amendment does is very similar to what we did in committee, and I will explain as I go along here why we needed to do the strike-all amendment as well. This bill simply removes the requirement that in-person absentee voters put their ballots into an envelope at their clerk's office. Instead, they will cast that ballot after going into their circuit clerk's office, showing their valid photo ID. They will be printed an affidavit. They will sign that affidavit stating that they meet one of the enumerated excuses that we have. They will then cast their ballot into an actual, it's called an OEM, it's a ballot counting machine, and those votes will be tabulated on election night just like all other votes. So we're just getting rid of the envelope here. The reason I had a substitute, because we've been working with the clerks on this, your circuit clerks support this idea. I've been working with them because there are a lot of code sections we had to bring forward, we had to look at. I'm not doing anything to mail-in voting, so we brought those sections forward, and I'm still working on this. This does have a reverse repealer in it. This creates a 22-day period from the date of each primary for voters to go swear by an affidavit that they have an excuse to vote absentee, and then to actually cast that ballot. I think this is a good thing. It's something that the circuit clerks support. It's going to help with election integrity in that your votes will be counted at the time every other vote is tabulated when those machines are pressed. And you're essentially, if you're voting in-person absentee this way, you're voting just the same way you do at the precinct. That is what this bill does. I'm happy to take any questions.
You have a couple, Senator. Senator Chisholm, what purpose?
Thank you, Mr. President. I have an amendment to offer at the proper time.
bring it forward, and at the proper time, we'll call it up for, do questions first. Senator Boyd, question?
Question, please.
Do you yield?
Yes, I yield.
Senator Boyd.
So this would completely get rid of the envelope.
For in-person voters.
For
You still have to
in-person
mail
voting.
in, but it does get rid of it for the in-person, yes.
And so that would ensure that when I go, if we're here in session and I need to go cast a vote, it will ensure that those counting the ballots actually don't pull my ballot out and then my name is written across the back of it, and they all know who I voted for, don't they?
That's absolutely correct. You are secure. You can feel much safer with a secret ballot if we do this and allow you to vote just as you would at the precinct on Election Day, yes.
And that has happened to me, and my vote has been reported, so thank you.
I thank you for your support, Senator.
Senator Whaley, what purpose?
Question, please.
You yield, Senator Whaley.
Yes.
Senator Whaley, recognized.
Thank you, Mr. President. Thank you, Mr. Chairman, for taking my questions. Just for clarification purposes, are we adding any excuses to the process, or is it still the same process that it has been as far as work or elderly or disabled?
Yes, thank you very much for that question. We do have, we are adding an excuse mainly for mail-in voters because we're cutting this down to a 22-day period. So if you are not in your county of residence within that 22-day period, you then have an excuse to cast a mail-in ballot. So that's going to take care of your people who are offshore oil workers and people who ordinarily would be able to go during that 45-day period if they could make it. This gives them that excuse. Also, if you're an emergency response provider deployed to a state of emergency declared by the president or by the governor, you are allowed to vote absentee. Also, if you are at work or expect to be at work on Election Day. Those are the only things we've added. Everything else stayed exactly the same as it did before. But I really appreciate your questions. I skipped over that. I didn't mean to.
Well, I was waiting on that explanation. Of course, I don't serve on elections, so, and not knowing the strike all, I wanted to make sure that we weren't opening this wide open. I do want to see ways that people who are working or the disabled or the elderly have options to go and vote. I think that's very important, but I just want to make sure we weren't getting too wild with it.
Absolutely, yes. Thank you.
So to expand on this, since we're taking the envelope piece out, do we expect that it will be like a regular voting machine that we see at the polls, and you will go and insert your ballot into that machine? Is that correct?
Yes, they're required to be the same voting machines as you have at the polling place. It's called an OEM machine. You put the ballot in. As you know, also, if you make a mistake on your ballot, it'll give you that second chance, make any corrections, and then vote. So you have that added level of knowledge that your ballot was actually counted, because you don't know what's going to happen when it gets opened if it gets tossed for some odd reason. This is a very secure thing. A lot of process. I want to say this too from the well. I'm very thankful for the clerks working with me on this, and for the Secretary of State's office. They have worked with me on this as well, and will continue to do so.
We have the full support of the circuit clerk's offices.
That's my understanding. Yes. When I met with them earlier this year, they said if we could get rid of the absentee ballot envelopes, we would be extremely happy. The reason I have such a late amendment right now, as a matter of fact, is because as we know, Senator Tate mentioned this, they lost a very close friend of theirs in the community, Miss Donna Jill. Very sad. They didn't get their stuff to me as quickly as they wanted to. I got it yesterday. I have inserted their concerns into this, taken care of those, but I'm still going to work with them. It's got a reverse repealer.
Thank you very much.
Senator Hartness, for what purpose? You yield, Senator Hartness, for a
question, Mr. President?
Yes, I yield for a question.
Senator Hartness.
Senator England, you and I talked about this, and of course I've talked to my clerk extensively. When that person walks into the courthouse, the first thing that's going to be done is a valid ID check, correct?
That's right.
Now, if that doesn't check out, then what happens? If they can't find something, they get kicked out, or they file a provisional ballot and then contest, or what?
They're not allowed to vote in-person absentee if they don't have a valid photo ID.
All right, once that process is done, you run it through the machine. They fill it out, they run it through the machine. Where does that ballot go once it goes through the machine?
It goes into the machine where it's secured, but one step that you missed, I want to make sure that they still have to sign the affidavit, and the clerk's office also has to keep the affidavit.
So that goes in a box, I guess, and protected?
That's right, a secured box.
And it gets counted on election night, correct?
That's correct.
Okay, thank you.
Yep, thank you, Senator Hartness.
Senator Dupree, what purpose?
Question, Mr. President.
You yield?
Yes, I yield.
Senator Dupree, you recognize.
You said now the election commissioners just finished having their conference in Tunica last week. You said you talked to the clerks. Did you talk to the election commissioners at all?
I've talked with the elections commissioners on this before. I didn't talk with them about this specific bill, mainly because they don't have much to do with the in-person absentee process or the mail-in absentee process. That's all handled in the circuit clerk's office. But with this reverse repealer, if they have any concerns, I will certainly reach out to make sure, and we'll talk to them before we come back up here with this measure.
So actually, to answer this question, I guess when they actually vote, it goes in the same place that one that was involved had an envelope. It's secured the same way, and they put a seal on it and do all that kind of stuff the same way. And so, other thing that it changes, I assume that it changes. If someone does an absentee ballot, did it change the number of days that you have to do it?
Yes, for in-person only. It didn't change it for mail-in. For in-person, it's a 22-day period
Instead of
now.
45 days, it's now 22 days.
That's correct.
Okay. There's no other changes.
Well, getting rid of the envelope is the significant change in this, and having the ballots cast into the machine. And there is a House bill that's a little different, so we're gonna work on that. The clerks are also working with them. I just want to make sure that our position is in a bill when we send it forward.
There was one provision, I think, though, when you vote absentee and you have an envelope, and then you are in town on election day, you can come and vote in person, and they discard the absentee ballot.
That's a very good question. No. We changed that a couple of years ago, though.
You did? Okay.
Yes. And so now if you go and you vote and it shows that you have voted absentee, then you would vote affidavit, but your absentee ballot is one that still counts. But I make clear in this, since it goes into a machine, it is a final vote once it's cast into that machine.
Okay. Thank you.
Yes, thank you, Senator.
Good bill. Thank you.
Thank you very much.
Senator Tate.
Speak on the bill at the proper time.
At the proper time. Let's see who's next. Senator Gillespie Azam. What purpose, Senator? Senator Gillespie. Gillespie Azam, you have a question?
I did. I'd like to ask a question.
Okay. You yield for a question, Senator.
Yes. Yes, Mr. President.
You're recognized, Senator.
Just wanted to get an understanding of why the time was decreased to 22.
That came after talking with the clerks, and with making this big change, we understand that most of your in-person absentee voters come in later anyways, and this just allows their office to be ready for this. And if there are more, they can handle it and get them through there. So it was through working with them. Thank you for your question.
Okay, let's see who's next here. Senator Hobson.
Question, Mr. President.
You yield, Senator Hobson.
I do, yes.
Senator Hobson, recognized.
Thank you. And Mr. Chairman, I'm going to give you a hypothetical. Just if you would, please tell me if I'm correct on this.
Okay.
If you go in to vote, in-person absentee, you go to the courthouse, Chantry Clerk's office to vote, correct?
That's correct, yes.
And I'm sorry, Circuit Clerk's office.
Circuit Clerk's office.
And then you get there and you go to a machine at the Circuit Clerk's office, correct?
Well, what you will go to the desk and see either the clerk or the deputy clerk, and that's where you'll show your ID and let them know you're there to in-person absentee vote. But there will be a machine that you cast your ballot.
And you cast your vote both electronically, and there's a paper ballot too that goes in, correct?
The paper ballot is the one you fill out, and it goes into the machine where it's secured into the machine.
That's right.
Yes.
And you, on the day of the election, do they take those to the precinct where you should have voted, and then they're brought back to count at the courthouse later, or does it stay in a separate? I'm sure I'll get asked these questions. Does it stay in a separate box for those that voted in-person absentee?
Yeah, it stays there. So this is like, they would just be tabulated there immediately by running the machine, as opposed to them having to open the envelopes and then count them that way. They just have them in the machine, so they will tabulate it there. They don't have to move the ballots anywhere.
So they would know before the elections how many votes are in favor of a particular candidate?
Not before an election. They're not allowed to, this
thought you
bill
said-
prevents them from tabulating until 7 p.m. on election day, when all the other machines are tabulated across your county.
Okay.
That's when they will tabulate that machine.
Right, and then it would, I think you said that it would not need to go to your precinct. So if you're voting on different people, like a supervisor's race, I guess they would just find a way to push that to that particular area where they know how to handle those that supervisor's race.
Yes, they'll have the results from each of those, and when you walk in and you give them you show them your photo ID and give them your information, they look you up based on your address as you give them, and then they mark you in SIMS, which is the state elections management system, and that's how they know which ballot to print you as well. And so they have all of that capability through the SIMS system, and you'll be marked immediately as having voted IPA, meaning in-person absentee, and that's in the bill as well.
All right, and then with respect to the people that live, you mentioned military or construction workers or something like that may be out for a while. What's changed on their mail-in voting? Anything, or have the dates changed for them?
The dates haven't changed. It's the same mail-in procedure. We're giving that excuse if you're not available to vote in-person absentee during that 22-day period, then you're eligible to vote by mail.
Yeah, and how long is that period?
45 days.
All right, thank you.
Yes, thank you, Senator Hobson.
Senator Younger. Pass. Okay, Senator Blackwell, what purpose?
Question.
Do you yield Senator Blackwell for a question?
I yield, yes.
Senator Blackwell, you're recognized.
Thank you, Mr. President, Mr. Chairman. It's been a few years since I used to be chairman for our party, conducted a lot of the primaries. When we absentee voted or counted the absentee votes, there was a card. Each precinct has its own unique card that we would pull out, enter into the machine, vote whatever ballots that we had, and then remove that card. How does that work under your system? Just walking, how do they know to assign my vote to my precinct is my question.
So now they will use SIMS to print that ballot. Since now we use paper ballots everywhere instead of the cards, they will actually print you a ballot that is based on your address.
I understand that, but from a counting standpoint, when they feed it into the machine, how does it know to assign it to my particular precinct?
Yes, so I just confirmed, Senator Blackwell. So each machine is programmed for the ballots that are going to be fed into it. So they'll have that. But I think your question is with regard to the number. Those machines will also tell you, you can print out how many, the numbers of ballots in the machines. Without getting the results, you can tell the numbers of ballots that have been cast. And of course, you'll also have those affidavits that were signed. Will also be a number you can count to see how many votes should be in there. I hope I've answered your question. If not, if you'll rephrase it, I'll.
Yeah, you're not there yet.
Okay, all right. Well, if you,
and maybe let me see if I can reframe the question.
Yes.
So when we count the absentee ballots, we have the machine, and then we have a card that's associated with that particular precinct that has all those votes that occurred at that precinct.
Yes.
When I come in now to do early voting, and I say I'm from precinct 207, how does my vote link up with precinct 207? Because when I've done this recently, there's just one machine.
Yes.
So how does my vote get tabulated to my precinct?
Yes, those machines are programmable to accept the multi-different ballots. Because it's my understanding that did I answer? I'm trying to answer correctly, because I know that even now when you have envelopes, the ballots in the envelopes, those can be put in the same machine, and they can count every different race. So it's based on what ballot you were given. So you're voting the races that are on your ballot based on your precinct and your address, and then that ballot machine will tabulate those votes.
Thank you.
And if I didn't answer Senator Blackwell, I'll just remind I do have a reverse repealer in the bill, and I
think Senator Hobson and I kind of are on the same path with our question.
Okay.
Support what you're doing, but I just want to make sure that an
Yes.
individual's vote is going to line up with their precinct.
Absolutely. Happy to meet with each of you and discuss this further and appreciate your work.
Senator Dupree, what purpose?
A question,
You
simple
yield?
question.
Okay.
Senator Dupree, you recognize.
Thank you, Mr. President. I want to follow along the lines of Supervisor Isom. We've gone from 45 days to 22 days, so that's virtually 2 weeks. I understand the 45 days because you have to get, you have to make your request, they have to send it to you, you send it back, and then they send you a ballot. And then you fill out the ballot, then it has to go back in the mail again. So you need that back and forth time. But if you're increasing and allowing other people to look like 21 days on and off and that kind of stuff, I just don't think 21 days or 22 days or whatever is did you consider 30 days?
I will look at that while we have the
just don't know how you
reverse
got down
repealer
to
in the
yeah,
bill,
yeah.
because like I said, the House has a version of this bill. I'm trying to, you know, we've got our ideas of how this should look. They've got theirs, so this will end up in conference. I will look at that,
Well,
and I will meet with you about it.
What you've done, I think, is more efficient. I'm being told, my wife's an election commissioner.
Well, good. Thanks for her service.
So, yeah. So I think it's more efficient, but I wish you would consider, maybe if not the 45 days, at least 30 days, I think would be more palatable for them.
I will certainly look at it. And one thing I've learned in this position since I've been this chairman, deadlines and days are very important when you have to have ballots printed, the work that has to go into it, as your wife knows. But I will certainly visit with you on this and let you know should this make it back to this body, I'll make sure to address that with you.
Because for years in the municipal government, we were inside that 45 days. And if you had a snafu, you never made the 45 days. People always had to vote within that 45 days, and a lot of people didn't get the opportunity to vote because of that snafu.
Right. Thank you, Senator.
So, excuse me, to let you guys know what I'm going to do here, I think you have an amendment.
That's
We're going
correct.
to do the amendment. Senator Chisholm will offer her amendment after your amendment. Senator Tate will then speak, and then Senator England will bring you back up.
That's correct. So, Mr. President, so my motion at this time is to...
You have an amendment, right? Yeah, you're recognized, yeah.
Okay, Mr. President, I've been instructed what may be the best procedure here is for me to step aside and allow this amendment to my amendment come forward first, and then I can make my amendment if that's
okay.
fine. Okay,
All right.
thank you, Mr. President.
So that would be Senator Chisholm. Okay, Senator Chisholm, you're recognized.
Thank you, Mr. President. Thank you, Mr. Chair. I'm going to move a couple of your papers here. I'm sorry. Okay. In this amendment, I'm asking for closed primaries. Closed primaries is something that we have needed for a long, long time. Closed primaries, primary election in which only voters registered with a political party can vote in that party's primary. And I'm going to give you some pointers here or some pros on this, and then if you need me to, I will read or answer questions on the amendment itself.
Senator, can you hold on one second? For what purpose, Senator?
Point of order, Mr. President.
Point of order? Oh, what's your point of order?
My point, Mr. President, is that Senator England's amendment before the body does not deal with closing primary. So the amendment to the amendment is not germane to the proposed amendment by Senator England.
Hold on, please. According to our attorneys, the amendment is not germane. Your point is well taken. I'm sorry, Senator Chisholm. Okay, we'll go to Senator Tate.
You want to speak?
Not today.
Thank you, Mr.
Well,
President.
Senator Tate, I think,
Yes.
it needs to speak before you come back.
Would you, can I adopt my amendment? Because you want to speak on final passage? Is that?
You want to speak on final passage? So you want to explain the amendment? Okay, go for it. Thank
Yes,
you.
I would, so I've explained my amendment. I'm going to move that we adopt the amendment.
Okay, you have a, first you have a question. Senator Blunt? Pass that? Okay, the motion is we adopt the amendment. No questions. All in favor say aye.
Aye.
All opposed, no. The ayes have it. Okay, now we go to Senator Tate.
And Mr. President, will I be allowed to close before we
Yes.
move final? Thank you. Oh, I'm sorry.
Ladies and gentlemen of the Senate, y'all know that I do not address y'all often. I don't ask a lot of questions. I don't speak on bills. This is just one that's passionate to me. I was an election commissioner for 10 years, put on over 45 elections in Lauderdale County, have volunteered in dozens other. I can tell you that this is not a good bill. There's several reasons why, but I'm going to limit it. Our courthouses are not feasible for what's about to happen here. If we look to our neighbors to the north, they were a lot like us. They had absentee voting like us. In any given election, roughly 10% of the turnout comes out for absentees, and they have 40 days to do that. 10% for 40 days. There's a lot of different reasons why to vote absentee with a legal reason, but the ones that need it the most are our elderly and our physically disabled. They have 40 days to share a line at the courthouse with 10% of the electorate. Our neighbors to the north, Tennessee, passed a bill with early voting. Within 4 years, 50% of the electorate comes out to vote. Now, this bill limits it to half of that time, 22 days. We all know that in Mississippi, it's going to rain once every 22 days, which means it's going to be 21 days. If it rains another time, it's one less than that. We do not need our elderly and our physically disabled to have to share the line with 50% of the electorate. I want you to think about your courthouse. I talked to Senator McClendon, so he told me that it was okay to say this. I want you to think about DeSoto County and that square. Think about the traffic up there. Think about half of the electorate having to come up to park to go vote. Think about your own personal courthouse. Think about if grand jury is going on. There's a lot of other reasons that I'm not for this bill. We're basically opening up for everybody to come in. This legalizes busing of voting. I'm not for that. I am for election day voting. Right now, if you want to vote, it is easy to vote and it is hard to cheat. Right now, there is no excuse to not be able to vote. We have everything under the sun for an excuse to be able to vote. We do not need to change this. Again, when we vote, I want you to think about your courthouse or courthouses that you represent. Think about 50% of the turnout coming out to park and having to vote, and how that would hurt people that really need this. This is not what my amendment was last year. And Chairman, I told you I wasn't going to speak, but whenever you brought my name up, I just felt like that I needed to make sure that the body knew this. And so I asked you to vote no on this bill, and I yield the podium. Thank you.
Well, you have a couple of questions, Senator. Would you yield, or would you like to answer?
No, yes, sir.
Okay, the first one, Senator Blackman, for a question.
Question, Mr. President.
You yield?
Yes, sir.
Senator Blackman?
So if it rains on Election Day, should we get another day to vote?
Say what now?
If it rains on Election Day, should we get an extra day to vote?
Well, I don't think that we need to change the law at all because you have 40 days.
Well, you said one of the reasons was if it rains.
The point is it'll be a
and we only
longer
got
line
21.
if something like that were to happen. And we had this discussion last time about opening up the days up further. You know, I think that would make it better, but at the same time, I'm against this bill.
Okay, I was just checking on the rain part.
Yes, sir.
Senator Carter, for what purpose?
I have an announcement out of order.
Well, go ahead, Senator.
Ladies and gentlemen of the Senate, Alliant Insurance Services has sponsored y'all some pizza that will be here in about 30 minutes in the Senate lounge.
Oh.
And I know that several of y'all are pretty damn hungry. And if you need some insurance, I can meet all your insurance needs.
Okay, Senator Tate, I think that's all the questions.
Okay, that sounds good.
Thank you, Senator Tate. Senator England, you're recognized to close.
Thank you, Mr. President. Ladies and gentlemen, listen, I do owe Senator Tate an apology. When I mentioned his name earlier, I certainly didn't mean to insinuate that he supported the bill. I did mention his name. I did that because I know that you lost a friend, and based on her colleagues not being able to get back to me, I wanted to mention her. We all miss her. She will be a great, and I'm sorry I mentioned your name. Did not mean to insinuate that you supported the bill. I do think that what we have here with your comments is a situation where we will sit down in our chairs and we will think, wow, 45 days is too long, or wow, 22 days is way too short. It should be 30 days. It should be 14 days. It should be 10 days. And we'll vote against the bill. And what do we have after that? We have the same system with envelopes, that ballots have to be put in the envelopes, and they're cast for 45 days. We don't have the vehicle to do anything anymore. We have that here. The main thing that I'm working on for our clerks, and I do have their support on this, is to get rid of that absentee ballot envelope. I was listening to a radio show recently with a young man that was against this. He apparently has worked on campaigns and has worked on resolutions boards. And he said, this is a bad idea. We don't need to do this. And then he came back from break, and his example of why we didn't need to do this is that he was in a county in Mississippi at one point in time, and they almost threw away 100 ballots because they were in envelopes and did not have postmarks on them. Those were in-person envelopes. So you can see right there that this young man that was opposing these sees that this is a problem that we have. There is nothing more secure than taking a ballot that you have put marked your ballot and putting it into a machine to cast that ballot. That's this vehicle to do this. I'm happy to talk with everybody, and I'll get 52 different opinions on how many days it should be, or whether we should do this or whether we should do that. I'm happy to do that. I know this is a big change. I know everybody cares very greatly about elections. I should mention, because I failed to mention it in my explanation earlier, so this is my fault, that in this bill, in this amendment that we passed a few moments ago, circuit clerks are allowed to use an adjacent building if it's owned by the government, or an annex to that building. So if space is an issue, I have worked with our clerks on this issue. I have worked on that. I've looked at that. I think that's a very valid concern for this bill. We've looked at that. We're trying to help them with the space. I would really appreciate your vote on this. I want to move this forward so that we can get our discussion in on the House when we go to conference, that the Senate has a bill and the House has a bill, and we can talk about it, and we can talk about those number of days, or we can all sit here and vote no and say that we want to keep those envelopes, we want to put the ballots in the envelopes, we want to keep doing things the same way for 45 days, and if that's what this body wants to do, that's fine. But if we think it's more secure to put those ballots into a ballot machine and get our results immediately on election night, which goes directly to the heart of integrity of an election, then let's pass this bill and keep working on something that we can do that. So I ask for you to support this bill. My motion, Mr. President, is for final passage by use of the morning roll call.
Okay, seeing no questions, Senator suggests the use of morning roll call, final passage. Any senator object? Any senator wish to be recorded? You object? Let's have a division on final passage. No? Wait a minute, what was the objection on? Oh, you object on the morning roll call. I'd rather have a division. I don't have to, but, all right, let's call the roll. You can have division. Okay, call the roll.
Barnett, Barrett, Berry, Blackman, Blackwell, Blunt, Boyd, Brumfield, Bryan, Butler, Carter, Chazanall, Chisholm, DeBar, Delano, Dupree, England, Fillingham, Frazier, Gillespie Isom, Harkins, Harkness, Hickman, Hill, Hobson, Jackson, Johnson, Kirby, Ladner, McCon, McClendon, McMahon, Michelle, Mumford, Norwood, Parks, Pope, Rhodes, Seymour, Simmons of the 12th, Simmons of the 13th, Sparks, Suber, Tate, Taylor, Thomas, Thompson, Turner Ford, Whaley, Wiggins, Williams, Younger, Barnett, Barrett, Berry, Blackwell, Blunt, Brumfield, Carter, Chazanall, Delano, Fielding, Frazier, Gillespie Isom, Harkins,
No.
Harkness, Michelle, Parks, Sparks, Whaley, Younger, voting yes or yea, Barnett, Blackman, Blunt, Boyd, Brumfield, Bryan, Butler, Dupree, England, Frazier, Gillespie Isom, Hickman, Hobson, Jackson, Kirby, Ladner, Mumford, Norwood, Pope, Simmons of the 12th, Simmons of the 13th, Thomas, Thompson, Turner Ford, Wiggins. Voting no or nay, Barrett, Berry, Blackwell, Carter, Chisholm, DeBar, Fielding, Harkness, Hill, Johnson, McCon, McClendon, McMahon, Michelle, Parks, Rhodes, Seymour, Sparks, Suber, Tate, Taylor, Whaley, Williams, and Younger.
I'm not sure. I couldn't hear, so I missed some people, so we're stuck down on the.
I got 25, 24. Let me see what they have.
Before the vote is counted, I'd like to change mine from aye to no.
Let's see. Wait a minute. Kirby changed from no to aye. I mean from aye. Senator Kirby?
By a vote of 24 yeas, 25 nays, the bill has failed. Okay, let's go to the next item. Senator Whaley. Senator Whaley. Pass and retain on 60 as well, 59 and 60. Senator Michelle. Pass and retain. Go to Senator Wiggins on 62. Senator Wiggins.
Thank you, Mr. President. Go to item 62, call that up, ask the title be read.
Please read title.
Senate Bill 2728, the Mississippi Chancery Youth Court Act of 2026, an act to provide uniform youth court and extend automatic repeal on related sections.
Make the usual motion.
Senator makes the usual motion. All in favor say aye.
Aye.
All opposed no. The ayes have it. Senator Wiggins.
Mr. President, I'd like to call up the committee substitute in lieu of the original bill and be allowed to explain.
You're recognized to explain the committee's sub.
Thank you, Mr. President. This is the youth court bill that we have been working on. What you're being handed out is a summary of the committee substitute. I appreciate council working on that. It's just a summary, and as you'll see on the top, in the bill is a reverse repealer, and like you've heard a number of times today, this is a work in progress, and I will tell you that I know you've probably heard from either judges or folks like that, and when the committee substitute finally passed and came out, I heard from quite a few judges that said they understood that we were trying to work on it, and that there weren't the objections they had from the original bill. And I just wanted to go briefly through them and then take some questions. So on the additional chancellor's part, and remember, this is part of the governor's plan, and before I go to the summary, the best way to sum it is many people through the court system, the conferences, the commissions that we've had agree there are issues. It's just how do we get there? And what this bill is doing, in my hope, is to present a path, a workable path, not the final path, to getting us a better system. I know Senator Boyd's been trying to work on IHL. We've been working on mental health, the system there. This is the same thing we're trying to do for the youth in our state. And so under the summary, the additional chancellors, none of that takes place until January 1st of 28. So nothing gets done, which is different, obviously, from the original bill. And then it says numbers are to be determined. So we are waiting to get through to the other side, if you will. We're working, looking at some things, and also looking at the cost to make a final determination of the numbers. And this is where the governor's office has been on it, is that the chancellors should, quote, replace the referees. And that's not just the governor's office, that's come out in recommendations. Now, since the committee substitutes come out, I think valid issues have been brought up about numbers of chancellors, and could we have some other referees, or how are we going to deal with the geographics? Those are, as I said, a work in progress. That's where you're, under the summary, the special youth court referees and so forth. It transfers the Family Services Forum, or creates that and replaces the Mississippi Council of Youth Court Judges. That's simply getting us a better commission that can provide information. Data management system That is the My Kids that I've talked to y'all about. The House had a standalone bill. They've passed that unanimously. So we have those code sections to replace that. The opening of the youth court proceedings, as we stated in committee, there's definitely at least one judge who is already doing that. We're looking at quite possibly a pilot. The language that's in the committee substitute is opening that up, the court proceedings. But if you look in the committee substitute, the provisions that relate to youth court records have the limitation they cannot be provided to people except in certain circumstances. And also, as we've said in committee, there are different instances as chancellors when you can close a courtroom, seal a courtroom, and it provides a procedure for that. Then the youth diversion program, most people that I've talked to think this is a really good thing to help our youth get there, to divert them from having, not from having to, but to divert them to programs of a rehabilitation type nature. And then the intake unit, creating, streamlining and clarifying the intake unit throughout the state. And then specifically the uniform rules of circuit court, which were created under the Supreme Court Commission a number of years ago. The youth court law had not been updated, and so we've updated it there. And so that's a brief summary of the committee substitute, and be happy to take any questions.
I see no questions. Senator, move for adoption.
I do move for adoption, Mr. President.
Senator moves for adoption of the amendment. All in favor say aye.
Aye.
All opposed, no. Ayes have it. Senator, you recognize final passage?
Final passage on the morning roll call, Mr.
Senator
President.
suggests use morning roll call, final passage. Any senator object? Anyone wish to be recorded as voting no? Senator Frazier is no. Senator Derek Simmons is no. Senator Mumford is no. Senator Brumfield is no. Senator Jackson is no. And Senator Sarita Simmons is no. Senator Norwood, no. Senator Gillespie Islam, no. Senator Brumfield, Senator Butler, no. Anyone else? Senator McCon, no. Senator Pope, no. Senator Bryan, no. And Senator Blunt, no. Senator Thomas, no. Senator Dupree, no. Senator Turner Ford, no. And Senator Barnett, no.
Senator Turner Ford is present.
Yes. Who? You want to be voted as no? Hickman? Hickman, no. And Suber, no.
Hickman, no. Suber, no.
Yeah, I think I've got everyone.
We did.
Anyone else? Hold on, please. I got you. With 18 noes and one present, has passed. So, Senator,
Thank you, Mr. President. Go to item 63, call that up, and ask the title be read.
please read title.
Senate Bill 2747, Mississippi Transparency and Consumer Legal Funding Act, enact.
Make the usual motion.
Senator makes the usual motion. All in favor say aye.
Aye.
All opposed, no. Ayes have it. Senator,
Mr. President, I'd like to call up the committee substitutes in lieu of the original bill.
okay, you recognize to explain.
Thank you, Mr. President. A brief explanation of what this is doing and what consumer legal funding is. This actually has come to us from the consumer lending industry, and they have actually asked, which I appreciate, to be, quote, regulated. The consumer legal funding industry, what that is they serve what I call hard-working men and women. And when when you're in a lawsuit of some kind, particularly on a plaintiff's side, it's a long time before you see the result of that monetarily. And so what this does is these lending programs lend money to a potential plaintiff in a lawsuit, and to allow them to have money for different services to live, if you will, until that comes about. There are certain, as in a lot of things, bad actors, and what this is doing at the request is to allow for the good actors to be allowed to provide these services in the state. It's really a consumer protection bill. And so it requires certain disclosures. It requires certain things to be put in a contract with the litigant, and it requires other certain matters as they get into it. This is different from what you may be known as legal financing, where people finance a legal case. This is clarifying that there are distinctions between those. And with that, Mr. President, I'd be happy to answer any questions.
Senator Thompson, what purpose?
Question, Mr. President.
Do you yield, Senator Thompson?
I do.
Senator Thompson, you
Thank
recognize.
you, Mr. President. Thank you, Mr. Chairman, for yielding. Senator Wiggins, does this have the Section 7, the disclosure requirement to the?
That's why we did the committee substitute. Yeah, the amendment that we made in committee is what I think you're talking about.
Correct.
Right. This is the committee substitute that
Has that amendment?
Yes.
Thank you, Mr. President.
Yes.
Thank you, Mr. Chairman.
Okay, I see no further questions. Move we adopt the committee substitute.
Move passage on the morning roll call.
Well,
yes, move adoption of the committee substitute,
Right,
Mr.
we need to
President.
adopt the committee sub first. All in favor of the amendment, say aye.
Aye.
All opposed, no. The ayes have it. Now, final passage, Senator.
Move passage on the morning roll call, Mr. President.
Senator suggests you use morning roll call, final passage. Any senator object? Anyone wish to be recorded as voting no?
Thank you.
Seeing none, please record all present by the use of morning roll call as voting aye, and the bill is passed. Now we'll go to item 64, pass and retain. Thank you, Senator Bryan. Pass and retain that item. Go to item 65, Senator Fillingane.
I'd like to skip item 65 and go to item 66.
We'll pass retain 65, go to item 66, Senate Bill 2794. Ask the title be read. Please read the title.
Senate Bill 2794, Law Enforcement Officers and Firefighters Death Benefits Trust Fund, delete prohibition for intentional harm.
I made the usual motion.
Senator makes the usual motion. All in favor say aye.
Aye.
All opposed, no. The ayes have it. Senator.
Thank you. We have committee substitute, Mr. President, and then I have an amendment to the committee substitute.
Okay, you recognize to explain the committee sub.
Thank you, Mr. President. So, Senate Bill 2794 amends Section 4521 to delete language that prohibits payment from the Law Enforcement Officers and Firefighters Death Benefits Trust Fund where the death was the result of suicide or an intentionally self-inflicted bodily harm. The committee substitute placed a reverse repealer in the bill, but the amendment that I'll be offering shortly would remove the reverse repealer and amends the definition of, quote, cause of death. And in place of that, we will put the term also includes any cause of death at the discretion of the Commissioner of Public Safety that would be covered under the Public Safety Officer Support Act of 2022, end quote. For a benefit to be paid, the Public Safety Officer Support Act of 2022 establishes a presumption that could be granted in the discretion of the Commissioner of Public Safety, and that federal law that we would be mimicking that portion of says, for the purposes of the death and disability benefits, the Act creates a presumption that an officer's death or permanent disability was directly caused by a personal injury in the line of duty if the officer took an action intended to bring about his or her death and exposure to a traumatic event that was a substantial factor in that action, or that action occurred within 45 days of an exposure and was consistent with a psychiatric disorder. So essentially what the amendment to the committee substitute does is it gives the Commissioner of Public Safety the discretion as to whether or not to grant death benefits to officers who have injured themselves through suicide. Now, I've spoken with Commissioner Tyndall about this, and he is of the opinion that he doesn't want just a blanket statement in the law saying if you commit suicide, you get this benefit, because that can create, in some instances, the situation where if someone is thinking about harming themselves and they do so, they would know automatically their family would receive this benefit, and he doesn't want to create that situation. But he also has seen instances where people in the line of duty have committed suicide and their families do not get the death benefits currently, and that's a really bad situation as well for the family. So we're trying to kind of walk a balancing act between the two by giving the Commissioner of Public Safety discretion to look at all the facts and circumstances and decide in that instance whether or not to grant those benefits. So that is the amendment which I would offer, if we can put it on the
Well, we need to
screen.
adopt the committee sub before we do the amendment.
All right, I move adoption of the committee substitute.
Senator moves for adoption of the committee sub. All in favor say aye.
Aye.
All opposed, no. The ayes have it. Now we go to the amendment.
I move adoption of the amendment, Mr. President.
Move for adoption of the amendment. All in favor say aye.
Aye.
All opposed, no. The ayes have it. Now for final passage.
Any questions? If
I
not,
see
move
no questions.
Adoption by use of the morning roll call.
Senator suggests use of morning roll call, final passage. Any senator object? Any senator wish to be recorded as voting no? Seeing none, please record all present by the use of morning roll call as voting aye, and the bill has passed. Okay, the last bill, Senator McMahon. Senator McMahon, item 67. Pass that item. Okay, that ends our calendar. So what we need to do is go back. This is deadline day. So anyone have anything on page 1 that they didn't take up? Yes, sir.
What are we doing?
Well, it's deadline day, Senator. I was saying people that held one on pass and retain.
But Mr. President, we've passed the place it was on the calendar.
You're exactly right. You're exactly right. They have to. You're right. Anyone that has any on any of these pages would have to suspend the rules to go back to that item. So my proper statement should have said anyone wish to take one up by suspending the rules.
I have a motion if I'm recognized.
Senator, we have a senator that would like to take up a bill. But motion, I think, well, if I knew what the motion was, it would make a difference. But, hold on a second. Let me ask. Okay. I think I may know what the motion is, but Senator Bryan, you're recognized for a motion.
I move the Senate adjourn until 9 a.m. in the morning.
Okay. The motion is we adjourn till 9 a.m. tomorrow morning. You want to speak on the motion?
Yes, Mr. President. My concern is, before we vote on that motion, is if a senator has something that they wanted to take up today, that this would absolutely stop. No, I'm speaking on the motion. I'm sorry.
I'm sorry, but a motion is not debatable.
Oh, I'm sorry.
To adjourn.
I apologize. Point of parliamentary inquiry.
Yes, sir.
Would ending right now to come back tomorrow kill everything on the calendar that is a general bill that has not been taken up today?
If it's not held on a motion to reconsider or not on the reconsider calendar, yes, it would. Okay, for Senator Simmons, for what purpose?
All in favor of the motion to adjourn?
The motion is that we adjourn to 9 a.m. tomorrow morning. All in favor say aye. Aye. All opposed, no. My understanding is we can have a division on this one. So, those in favor, please go to your seats. So the motion is for adjournment. Thank you. Okay, those in favor of adjourning, please stand. Help me count them, man. I'm not standing. I'm not standing. Okay, please be seated. Those against, please stand. Okay, the motion to adjourn has failed. Now, does anyone wish to suspend the rules, go back on the calendar? Which is what I should have said the first time. If not, then any announcements?
Mr. President, my motion would be to suspend the rules to go back to Senate Bill 2416
okay.
to put the amendment in that I told Senator Blackman I would.
All right.
That's my motion.
What item number?
To reconsider the vote on 2416.
Motion is to reconsider the vote on what was the item number?
Okay. My motion would be to suspend the rules for immediate consideration of Senate Bill 2416 on today's calendar, number 51.
51. Okay. Senator Simmons, for what purpose?
Parliamentary inquiry, Mr. President.
You recognize?
As I understand it, the motion was held, that bill was held on a motion to reconsider?
No, I think it was, I'm not sure. Was it held on a motion to reconsider?
No, Mr. President, it was not.
What item number was it?
It's number 51.
Okay. Was not held on a motion to reconsider. So your motion again, Senator.
We did hold. Okay, we did hold. Excuse me, we did hold. I'm sorry.
It was held on a motion.
Yes.
No, he held it. He held it before he left. He held it at the podium.
With a two-thirds vote. Okay, your motion is reconsider the vote. Suspend the rules to reconsider the vote. Okay. All in favor say aye.
Aye.
All opposed, no. One more time. All in favor say aye.
Aye.
Those voting no? No. Jesus. The noes have it, I'm afraid. Let's do a division. I'm not sure. I said I'm afraid. I didn't say they had it. So let's do a division. So all those, please stand. Please stand in favor. Yeah, please go to your seats so we make sure we're counting everyone. Yeah. Well, I'm no longer in doubt. chair is no longer in doubt. Please be seated. Senator, you recognize.
Thank you, Mr. President. I'd like to go to item number 51, and it's been held on a motion to reconsider. I would like to reconsider the vote by which the bill passed for the purpose of an amendment.
All in favor say aye.
Aye.
All opposed, no. Okay, Senator, ayes have it.
Thank you, Mr. President. There should be an amendment on the screen for Senate Bill 2416 that has the language Senator Blackman had proposed while we discussed the bill. I would yield to any questions on this amendment.
Any question on the amendment? See no questions. Senator?
If there's no questions, I move for adoption of the amendment.
Senator moves for adoption of the amendment. All in favor say aye.
Aye.
All opposed, no. Ayes have it. Senator?
Move for passage on the morning roll call.
Senator suggests use morning roll call. Yes, sir. You're recognized.
A parliamentary inquiry.
Okay. You're recognized, Senator.
Upon the demand of any one member of this body, would the bill be read?
Did we not read the bill? We did read the bill.
No. The answer to his question is yes.
I'm sorry, what?
The answer to his question is yes, upon the demand.
Yes, to answer your question, Senator. On the demand of any one senator, I thought you meant title. You meant the bill be read? Yes, it can be. Okay. Anyone else? We passed that. So. Okay. Senator Sparks, did you have anything else?
No, my motion was passage on the use of the morning roll call. I'm sorry, Mr. President.
Okay. I thought we did that. The senator suggests use the morning roll call final passage. Any senator object? Any senator wish to be records voting no? Please record all present. Seeing none, no. Senator Turner Ford, no. Anyone else? Seeing no. Present for Senator Dupree, Senator Gillespie Eisel, present. Brumfield, present. Anyone else? Seeing no others, oh, I'm sorry, Senator, no, Senator Derek Simmons. Senator Simmons, present, Sarita Simmons. Anyone else? Seeing no others, please record all others present by use of morning roll call voting aye. It's passed. Now, anyone else? If not, then we can go to announcements. Any announcements? Seeing no announcements, okay, they lit up all at once. Here we go. Senator Derek Simmons for announcement.
Thank you, Mr. President. I'd like to hold item number 58 on today's calendar, Senate Bill 2587, on a motion to reconsider.
Join the chairman.
And also, Mr. President, I'd like to hold item number 62 on today's calendar, Senate Bill 2728, on a motion to reconsider.
Please join the chairman. Okay, next, Senator Carter. Senator Carter.
Announcement.
You're recognized.
Y'all better not leave me hanging on that pizza. Like, I thought we were going to be here a lot longer than we are, and I've got 10 pizzas coming, and Alliant Insurance is paying for that. And if you have any insurance needs, I'd be happy to help you out with those.
Senator McMahon, announcement.
Adjourn in memory.
You recognize.
Today, when the Senate adjourns, I ask the Senate adjourn in memory of Janet Gentry Nichols of Baldwin, Mississippi, and Willie Barnes, a Vietnam veteran of Baldwin, Mississippi.
Thank you, Senator. Senator Younger.
Adjourn in memory.
You recognize, Senator.
When the Senate adjourns, please do so in the memory of Ruth Berry from Columbus, Mississippi, and Dorothy Dottie Nelson from Columbus, Mississippi.
Thank you, Senator. Senator Frazier.
Thank you, Mr. President. I request unanimous consent to be added as a co-author on item 29, Senate Bill number 2419.
Motion to reconsider. Co-author.
Unanimous
Co-author.
consent.
To co-author. Got you, Senator. Okay, I just didn't hear you. Senator Thomas.
Thank you, Mr. President. With unanimous consent, I would like to be added to item 25, bill number 2408, as a co-sponsor.
Okay. Senator Gillespie Isam.
Thank you, Mr. President. I'd like to be added to bill number 24, the online item. The bill number is 2708. And from yesterday, I would like to be added to bill 2032.
Okay, Senator Harkins.
Thank you, Mr. President. I'd like to hold item 58 on the motion to reconsider.
Please join the chairman. And next, Senator Seymour for announcement.
Yes, Mr. President. With unanimous consent of the Senate, I'd like to be added to item number 23, Senate Bill 2716, as co-author.
Thank you, Senator. Senator Williams.
Thank you, Mr. President. With unanimous consent, I'd request to be added as a co-author to item number 4, Senate Bill 2874.
Okay, Senator Mumford.
Thank you, Mr. President. With unanimous consent, I wish to be added as a co-author to item number 29, Senate Bill 2419.
Thank you, Senator. Senator Norwood.
Mr. President, I'd like to hold number 47 on today's calendar, Senate Bill 2523, on a motion to reconsider.
Please join the chairman. Okay, Senator Sarita Simmons.
Thank you, Mr. President. With unanimous consent, I would like to be added as a co-author for item number 12, Senate Bill 2679, item number 58, Senate Bill 2587, item number 55, Senate Bill 2424, and then on yesterday's calendar, I would also like to be added as a co-author on item number 104, Senate Bill 2543, and item number 108, Senate Bill 2444. Thank you.
Thank you, Senator. Senator Barrett.
Adjourn in memory.
You recognize.
When the Senate adjourns today, I would ask that we do so in honor of Mr. Verily Hamill. He is the father of Mr. Henry Hamill.
Thank you, Senator. Senator Dupree.
Yes, Mr. President, adjourn in memory.
You recognize.
Attorney Michael Alderman from Hattiesburg, a great civil rights attorney who passed last week.
Thank you, Senator. Senator McClendon.
Thank you, Mr. President. On yesterday's calendar, I'd like to hold on a motion to reconsider number 102, Senate Bill 2454.
Okay, Senator Butler.
Yes, Mr. President. With unanimous consent, I would like to be added to item number 25, Senate Bill 2408, and item number 29, Senate Bill 2419.
Thank you, Senator. Senator McMahon.
I ask for unanimous consent to be added to item 51 on today's calendar, Senate Bill 2416.
Thank you, Senator. Senator Brumfield.
Thank you, Mr. President. With unanimous consent, I would like to be added to item number 24 on the calendar, Senate Bill 2708, item number 25, Senate Bill 2408, and item number 29, Senate Bill 2419.
Thank you, Senator. Senator Younger.
Yes, Mr. President. With unanimous consent, I would like to be added to item number 43, Senate Bill 2664.
Okay, any other announcements? Seeing none, Senator Blackwell.
Thank you, Mr. President. Move the Senate stand adjourned until 9 a.m. tomorrow.
Motion is Senate stand adjourned to 9 a.m. tomorrow. All in favor say aye. All opposed no. The ayes have it. The Senate is adjourned until 9 a.m. tomorrow.